The House suspend the rules and concur in the Senate amendment to H.R. 674.
The clerk will report the title of the bill.
H.R. 674, an act to amend the Internal Revenue Code of 1986 to repeal the imposition of 3% withholding on certain payments made to vendors by government entities, to modify the calculation of modified adjusted gross income for purposes of determining eligibility for certain health care-related programs and for other purposes. Senate amendment.
Pursuant to the rule, the gentleman from Michigan, Mr. Camp, and the gentleman from Michigan, Mr. Levin. Each will control 20 minutes, and the chair now recognizes the gentleman from Michigan, Mr. Camp.
Thank you, Madam Speaker. I yield myself such time as I may consume.
The gentleman is recognized.
I ask unanimous consent that all members have 5 legislative days within which to revise and extend their remarks and include extraneous material on the bill under consideration.
Without objection.
I come to the floor today in support of permanently repealing the onerous, job-killing 3% withholding law. During House action last month, this legislation garnered more than 400 votes for repeal and passed as amended with an overwhelming 95 votes in the Senate last week. The legislation, which has been championed by Ways and Means Health Subcommittee Chairman Wally Herger and our Democrat colleague Earl Blumenauer, is supported by President Obama and makes clear that when we work together, we can find bipartisan solutions to the laws and regulations that stifle job creation. This legislation does just that and frees up valuable resources businesses can use for hiring. In addition to the provisions in the House-passed 3% withholding bill, the Senate amendment contains a variety of veterans-related provisions, a group of Americans clearly deserving of our support. Finally, the Senate amendment retains another provision passed by this House with bipartisan support and authored by one of the newest members of the Ways and Means Committee, Representative Diane Black. Ms. Black's legislation modifies the income definition for determining eligibility for exchange subsidies, Medicaid, and the Children's Health Insurance Program, conforming the definition of income in the Democrats' health care law to the standards used by other federal low-income programs such as food stamps and public housing. In doing so, taxpayers save $13 billion, and Medicaid funds will not be diverted away from serving America's lowest-income families. Madam Speaker, today we can take the final step and send this deficit-reducing and job-creating legislation to the President's desk. I urge my colleagues to vote yes on the Senate amendment to H.R. 674, and I look forward to seeing the President sign this bill into law. And I ask unanimous consent that the gentleman from California, Mr. Herger, control the balance of the time.
Without objection. And the gentleman reserves his time. The gentleman from Michigan, Mr. Levin, is recognized.
Speaker, I yield myself so much time as I shall consume.
The gentleman is recognized.
Madam Speaker, I believe this bill will pass with overwhelming support. Nearly everyone agrees that the 3% withholding provision should be repealed. It was a misguided approach when it was enacted by the last Republican Congress, and it is misguided now. That is why we tried to repeal it earlier and ultimately delayed its implementation. Its repeal, however, should not be claimed as a significant jobs bill. As economist Mark Zandi has said, and I quote, "I don't think it's meaningful in terms of jobs. It's more trying to clean up something that needs cleaning up," end of quotes. The veterans provisions added by the Senate are a real jobs bill. They are a useful start in helping those who have loyally served our nation find work. And I would hope all of us support them, including the tax credits to encourage businesses to hire veterans. Most on our side support these provisions, and they were included in the President's job proposal. But no one should consider these modest steps as a substitute for action on the President's comprehensive jobs plan, which Republicans have so far blocked. The President's job plan includes a payroll tax cut that would save the average family $1,500 a year. It includes tax credits for hiring the long-term unemployed, payroll tax cuts for hiring, and incentives to invest. It includes an infrastructure bank and $75 billion to build roads and schools. That's a job agenda that could help many of the 14 million Americans who are still looking for work. Picking out two of the smaller pieces of that agenda and saying you've acted on the President's jobs bill is really disingenuous. The 3% withholding repeal and the veterans provisions are things we should do, but we must do much more. Millions are counting us to do more. So passage of this bill today represents a challenge to the majority in this House. End your blockade of comprehensive jobs legislation as proposed by the President of the United States. I reserve the balance of my time.
Reserves the time. The gentleman from California.
Madam Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
I rise in strong support of H.R. 674. Members of this House are well aware of why the 3% withholding tax must be repealed. It threatens to destroy the cash flow of thousands of small businesses that sell goods and services to the government agencies and impose additional costs on cash-strapped state and local governments. Today I want to talk about the big picture and why this is so important for job creation. Americans are hurting. Nearly 14 million are unable to find work, and millions more are stuck in part-time jobs even though they would like to work more. We are now well into the fourth year of this downturn, and many Americans are increasingly discouraged about the long-term future of our economy. America's job creators are hurting too. Today, thousands of small business owners will sit down, look over their books, and try to discern what the future holds. They are uncertain about whether there will be sufficient demand for their goods and services. They are uncertain about how Europe's fiscal crisis will affect our economy and whether we would do what is needed to address our own debt crisis before it's too late. And they're uncertain about the direction of government policy, whether Washington will continue to hand down new taxes and regulations that stifle economic growth. The 3% withholding tax is an example of the kind of government policies that discourage job creation. When small business owners are evaluating whether their investments will allow them to make a living, it matters if a new tax is going to cut off their cash flow in just over a year. Repealing this tax is one important step. It sends a message to America's job creators that jobs are our #1 priority and that Congress is committed to undoing policies that stand in the way of restoring prosperity. I reserve the balance of my time.
Gentleman reserves. The gentleman from Michigan.
I now yield 2 minutes to the distinguished member of our committee, the gentleman from Georgia, Mr. Lewis.
Gentleman from Georgia is recognized for 2 minutes.
Madam Speaker, I want to thank Mr. Levin for yielding. Madam Speaker, the most important task we face today is helping Americans get back to work. People stop me all over Metro Atlanta and tell me how long they have been looking for work, how many applications they have filled out, how many resumes they have sent. And with the unemployment rate for Iraq and Afghanistan veterans over 12%, Senator Tester's amendment is a good start. It is a necessary start. These are people who want to work, who need to work. They don't want a handout. They want a job. These men and women put on that uniform to serve and protect our country. We can and must do more to honor their service. It is simply the right and good thing to do. Now, I must say, Madam Speaker, that I strongly object to the Republican effort to stain a bipartisan bill with a partisan poison pill, making it more difficult for American seniors to get private health insurance and Medicaid. It is not right, it is not fair, and it is not just. And with that, I yield back the balance of my time.
Gentleman yields back. The gentleman from California.
Madam Speaker, I yield 3 minutes to the gentlewoman from Tennessee, Ms. Black, who has been instrumental in working on this legislation and coming up for savings that we can do to see that it is paid for.
Gentlelady from Tennessee is recognized for 3 minutes.
Thank you, Chairman Herger. And Madam Speaker, I'd like to begin by stating that I am extremely proud that my legislation is part of this very worthy bipartisan jobs package. Congress can and should work together to find common ground and forward solution-based legislation like what we are considering right here. Today, the House will pass a package that not only creates more certainty for small business, encourages hiring of our nation's veterans, but is also paid for thanks to my legislation that repeals a costly glitch in the health care law. And this is more than a deficit neutral. This legislation will save billions of dollars. I've spoken on the floor of the House previously about my cost-saving legislation that is now part of this package. When the Affordable Care Act was passed, few realized that this legislation contained a loophole that would allow middle-class Americans to receive Medicaid benefits. The new income formula that determines eligibility for government-subsidized health insurance, the Modified Adjusted Gross Income, or MAGI, deviated from other federal assistance programs, failing to include Social Security benefits as income. Under the health care law, a married couple with an annual income of over $60,000 could qualify to receive Medicaid benefits. Let me put it in more stark terms. Changing the income formula could result in individuals whose incomes are up to 400% of the poverty level receiving Medicaid. This is unacceptable. I very strongly believe that it is our duty to ensure that the very scarce Medicaid resources are there for those in most need. Again, let me state that the Affordable Care Act income formula for Medicaid, CHIP, and exchange subsidies deviated from the eligibility requirements for other federal assistance programs. Supplemental Social Security income, supplemental nutrition programs known as food stamps, temporary assistance for needy families, and public housing all include the entire Social Security benefit as income. My legislation, now a part of this package, adds Social Security benefits back into the equation, realigning Medicaid with the other programs and stopping these improper payments before they occur. Closing the loophole in Medicaid will save $13 billion over 10 years, according to the Congressional Budget Office. And by adding my legislation into this package that includes the 3% withholding repeal and the veterans' tax deductions, this package will save vital tax dollars. Madam Speaker, I'd like to take a moment to praise other sections of this bill. And on the heels of Veterans Day, I cannot think of a better time for Congress to step forward and help our veterans get to work. As a wife, mother, and daughter of veterans, I know how important it is that we support those brave men and women who fought for our country.
I yield an additional minute.
Gentlelady is recognized.
Thank you. I hope that this bipartisan, bicameral veterans legislation is just the beginning of more veterans bills getting passed by Congress. Veterans who return home to us and seek work should be able to find it. With our economic recovery sluggish at best, my colleague, Mr. Herger's 3% withholding repeal will go a long way to create more certainty for small business. Taxing business at 3% is something we cannot afford, and I look forward to this legislation and the entire package of being signed into law by the President as soon as possible. We should not have to wait for these common sense, bipartisan solutions to go into effect. Thank you, Madam Speaker, and I yield back the balance of my time.
Gentleman from Michigan.
It's now my real pleasure to yield 2 minutes to a gentleman who has worked so hard on veterans issues, the gentleman from California, Mr. Fellner.
Gentleman from California is recognized for 2 minutes.
Thank you, Mr. Levin, and appreciate the time, and thank you, Mr. Herger, for bringing us this bill. I rise in support of H.R. 674. You know, every day I get phone calls and letters from veterans telling me how rewarding their service was and what an invaluable experience that they received in the military. But they are confused as to why potential employers don't value their time in service and why they get rejection letters for jobs they are qualified to perform. These veterans are highly skilled individuals who are ready to make an immediate impact to any job. Veterans bring real-world experience to any company, and unfortunately employers fail to see this value. On August of this year, the President proposed a comprehensive plan to decrease the veteran unemployment rate. Part of his plan includes a tax credit for employers, and I'm happy to see that Senator Murray included this in H.R. 674. It would provide a tax credit for firms that hire certain unemployed veterans, and these tax credits are a win for the veterans and a win for the companies. The credits will incentivize struggling businesses that need to increase their workforce to hire veterans while getting a tax deduction. The bill also provides veterans with training, mentoring, and placement services and allows for the appointment of honorably discharged veterans to the civil service. I'm happy to see H.R. 674 move forward because it will provide individualized assessments for service members in the Transitional Assistance Program, increase access to apprenticeship programs for separating service members, provide authority to the VA to provide services to service members with severe injuries, and many other positive programs that will help veterans. The President's message was clear. We must fight for our service members and veterans by enacting legislation that will help veterans get jobs. I hope that all of my colleagues will join me in supporting H.R. 674, and I would yield back, Madam Speaker.
Gentleman yields back. Gentleman from California.
Madam Speaker, I yield 5 minutes to the gentleman from Florida, Mr. Miller, the chairman of the Veteran Affairs Committee.
Gentleman from Florida is recognized for 5 minutes.
Thank you very much, Madam Speaker. I thank the gentleman for yielding. As chairman of the House Veterans Affairs Committee, I do stand today in strongest possible support of the Senate amendment to H.R. 674, which includes the provision of the bipartisan and bicameral Vow to Hire Heroes Act 2011. This bill contains many provisions of H.R. 2433, the Veterans Opportunity to Work Act, or the VOW Act, which was introduced in July and passed the House by an overwhelming majority just last month. The VOW Act honors the 1% of Americans who, as veterans, have signed a blank check in the amount of up to and including their lives, and payable to the other 99% of Americans. In return for that investment, too many of them, veterans of every working age generation, are finding themselves unemployed or seriously underemployed due to the current economic downturn. Unfortunately, today's economy has eliminated millions of jobs, which many will unfortunately never return. Regardless of the reason, nearly 1 million veterans need help in acquiring the skills needed for today's job market. And that is what the Vow to Hire Heroes Act will do in a very comprehensive and cost-effective manner. There are millions of jobs going unfilled right now because employers can't find workers with the right skills. I'm proud that a major provision of the Vow to Hire Heroes Act will give nearly 100,000 veterans a chance to gain the new skills that are in demand for today's jobs. And these jobs are not just in high-tech fields. Many are in the trades. Many are in fields that cannot be moved overseas, like transportation. And this bill helps provide the training needed to complete and compete for these types of jobs without adding new programs. In fact, the two major provisions of this bill essentially recycle two existing well-regarded education and training programs, the Montgomery GI Bill and the Vocational Rehabilitation and Employment Program. That will make use of existing staff and current regulations. As I said, this act takes a comprehensive approach. For those just leaving the service, this bill would vastly improve the Transition Assistance Program, or TAP, as it's known, by adding personal skills assessment and improved skills crosswalks into civilian occupations. The bill would also begin the process of working with the states to help standardize occupational licensing and credentialing, a major bottleneck that often wastes millions of dollars spent on our military training. For the disabled veterans who have completed VA's Voc Rehab and Employment Program, and who have exhausted their unemployment benefits, the bill would offer up to an additional year of vocational rehabilitation. Madam Speaker, I want to thank the chair of the Senate Committee on Veterans Affairs, Senator Patty Murray, for her insight in including the vocational rehabilitation benefits as part of the compromise bill. I have two final points. The first is this bill is paid for, both mandatory and discretionary. We have worked with the Veteran Services organizations in order to find the pay-for provisions, and they understand the urgency to help veterans become employed, and I thank them for their support of this legislation. And secondly, Madam Speaker, I'd like to thank Chairman Camp. I know his plate is full right now, and I thank him most sincerely for helping bring this to the floor. And with that, I yield back.
Gentleman yields back. The gentleman from Michigan.
I now yield 2 minutes to the very distinguished member of our committee and a co-sponsor of the amendment that we now add to the original bill, Mr. Blumenauer.
The gentleman from Oregon is recognized for 2 minutes.
Thank you, Madam Speaker. Thank you, Mr. Levin. It's a pleasure to be on the floor with my partner on this legislation, Mr. Herger, being able to see it finally brought to fruition and actually made a little better with the inclusion of these important provisions for our veterans. I am hopeful that we will act with dispatch and approve it unanimously. But I hope we can also focus on what this chapter represents. There was something in terms of working with Mr. Herger, moving this through Congress, that it seemed to me that there are three elements that we ought to focus on going forward. First and foremost, that same spirit that has resulted in being able to fix and improve this legislation ought to be focused on how we rebuild and renew America. Because so many of the businesses and governments that were going to be pounded with this 3% withholding are struggling to deal with challenges that they face. There are hundreds of thousands of veterans that could potentially be at work rebuilding and renewing America. We are in a precarious position in terms of our competitiveness internationally with problems of congestion, pollution. I am hopeful that this same spirit focused here can be focused on this major effort to rebuild and renew America that can help revitalize the economy while it improves our communities. Second, we need to take a hard look at flaws in how we score legislation. This piece of legislation that we were looking at, and part of the challenge was to have some sort of offset because it was going to, quote, cost government money. Well, as a practical matter, that is not the case because the CBO rules never take into account how much it would cost to implement it. And as a result of the hearings with Mr. Herger, with small business, with a whole range of, I am absolutely confident that it would have cost the federal government far more to implement it than it ever would have collected. We need to make sure going forward we don't have these aberrations that cost...
Gentleman's recognized.
That cause us to go through these gyrations for something that on its face really is not going to yield the economic results. And finally, I hope we can work together in the same sort of spirit, evidenced working with Mr. Herger, Chairman Camp, Ranking Member Levin, to deal with the broader picture of how we're going to deal with long-term problems of our budget deficit and our flawed revenue system. We can reform and balance our system, give a balanced program to deal with both that reforms and raises revenues, that changes how we do business. I'm convinced that this is within the capacity of those of us in Congress, and today's positive vote on this legislation is a little indication of how it can be done. Thank you, and I yield back.
Gentleman yields back. Gentleman from California.
Madam Speaker, I yield 1 minute to the gentleman from Indiana, Mr. Stutzman, the chairman of the Veteran Affairs Subcommittee on Economic Opportunity.
Gentleman from Indiana is recognized for 1 minute.
Thank you, Madam Chairman. I thank the chairman for yielding. Thank you, Madam Speaker. Jobs for America's veterans has become a popular topic over the past few weeks. The Vow to Hire Heroes Act is a vital first step in meeting our responsibilities to that 1% of Americans mentioned by VA Committee Chairman Miller in his remarks. For those who are in the middle of their civilian working life, Gaining new skills is often problematic due to a lack of resources to fund education and training. While recently discharged veterans have the post-9/11 GI Bill's generous resources to acquire the skills now in demand, therefore I believe the most important provision in the Vow to Hire Heroes Act offers 99,000 unemployed veterans between the ages of 35 and 60 the resources to acquire those new skills. Finally, Madam Speaker, I ask unanimous consent to insert the joint explanatory statement for the Vow to Hire Heroes Act of 2011 into the record. And to my colleagues, the veterans' provisions in this bill are worthy of your support, and I urge you to join me in voting yes on the Vow to Hire Heroes Act, and I'll yield back.
Gentleman yields back. Gentleman from Michigan.
I now yield 2 minutes to the gentleman from Pennsylvania, Mr. Altmaier.
Gentleman from Pennsylvania is recognized for 2 minutes.
Madam Speaker, I spoke in favor of repealing the 3% withholding provision when it passed the House just last month, and I'm pleased the Senate has not only passed it, but added important provisions to help our brave men and women in uniform find work when they return home. The amended bill provides retraining assistance to unemployed veterans as well as tax credits to businesses that hire unemployed veterans, a segment of our population that has been especially hard hit by our sluggish economy. An estimated 12% of veterans who have served since the attacks of September 11th are unemployed. This is far above the national average and not what our nation's heroes deserve. Our service members have gone above and beyond for their country, and this legislation is one way for Congress to honor their sacrifice and help them succeed here at home. I strongly support this legislation and urge my colleagues to vote in favor and yield back the balance of my time.
Gentleman yields back. Gentleman from California.
Madam Speaker, I yield 2 minutes to the gentleman from South Carolina, Mr. Mulvaney, the chairman of the Small Business Subcommittee on Contracting and Workforce.
Gentleman from South Carolina is recognized for 2 minutes.
Thank you. Last week I came to this floor and stood in the well and called upon the Senate to do something, which was to take up this bill that had passed out of our subcommittee with tremendous bipartisan support, passed off of this House with bipartisan support, something that went practically unnoticed nationwide, especially in the media. And I asked the Senate to simply take this bill up because it was not only something that the House had supported on a bipartisan basis, but it was something that was actually part of the President's jobs bill as well. So in the name of doing the right thing, I thought I would come today and thank the Senate for actually doing that. And while they're at it, figured they might want to take the opportunity to take up the other 19 job bills that we have sent them over the course of the last several months. They have done the right thing here. They have taken a bill that the House has sent them that will actually help people have the opportunity to go back to work. And we're seeing what's happened here today as both parties come together to try and figure out ways to give folks exactly that opportunity. That same possibility exists another 19 times over in the Senate. The Senate has done the right thing with this bill. They have passed it. They sent it back to us. It's going to become law now. I call upon the Senate to please do the right thing again, take up at least take up the 19 bills that we have sent them over so that we have the opportunity to do this again before the end of the year. With that, I yield back the balance of my time.
Gentleman yields back. The gentleman from Michigan.
I yield myself 15 seconds.
Gentleman's recognized.
The problem is that the 19 bills weren't real jobs bills, and so now what the Senate has sent us back is an addition that is a real jobs bill, though not comprehensive. I now yield 2 minutes to the gentlelady from New York, Mrs. Maloney.
The gentlelady from New York is recognized for 2 minutes.
I thank the gentleman for his leadership, not only on the committee, but in so many ways in this Congress, and for yielding me time. Madam Speaker, I rise in strong support of H.R. 674 and the President's Veterans Jobs Bill. The 3% withholding repeal is very important on its own. This was an important bill that would help small business contractors that would have experienced significant cash flow problems for day-to-day operations had the withholding tax gone into effect. It also provides important tax credits to encourage more employers to hire our veterans who are out of work. Well over 12% of our returning veterans are out of work. This bill provides additional education and job training for veterans to gain additional skills to be successful in an increasingly competitive job market. And it takes important steps to help ease the transition between military service and the civilian workforce. I am pleased that we are working together to repeal this tax burden and help our veterans in a comprehensive way during these tough economic times. I am pleased that this portion of the President's job bill is being enacted today. I thank all that are supporting it, and I yield back the balance of my time.
Gentlelady yields back. The gentleman from California.
Madam Speaker, I might request we don't have any, I would be the closing speaker.
We have one more speaker.
Okay, I yield.
Gentleman reserves his time. The gentleman from Michigan.
I now with pleasure yield 2 minutes to the gentleman from Georgia, Mr. Bishop.
Gentleman from Georgia is recognized for 2 minutes.
I thank the distinguished gentleman for yielding. Madam Speaker, I request permission to revise and extend my remarks.
Gentleman's recognized.
Madam Speaker, I'd like to thank the Democrat and Republican leadership in both the House and the Senate for their timely consideration of the Vow to Hire Heroes Act of 2011. As the House sponsor of the Hiring Heroes Act provisions that are in the bill, I'd also like to thank the chairman and ranking members of the House and Senate Veterans Affairs Committees for their outstanding work on this jobs measure, as well as the chair and ranking members of the House Ways and Means Committee. Just as this nation has the responsibility not to leave our soldiers behind on the battlefield, we also have an obligation not to forget our veterans when they return home. Last month, the unemployment rate for veterans who fought in Iraq and Afghanistan was 12%. The youngest of veterans, aged 18 to 24, had a 30% unemployment rate in October. Among African American veterans, aged 18 to 24, the jobless rate is a striking 48%. These numbers, Madam Speaker, are unacceptable. H.R. 674 allows us to honor our veterans by ensuring that they have the resources and the tools they need to find suitable and sustainable employment. I urge my colleagues to support H.R. 674 and to provide our nation's veterans with the employment opportunities that they need and that they so rightly deserve. Thank you, Madam Speaker. I yield back the balance of my time.
Gentleman yields back. Gentleman from California continues to reserve. Gentleman from Michigan.
I yield myself the balance of our time.
And the gentleman is recognized.
It can be stated very briefly. The unemployment rate for veterans is beyond acceptance, and these bills hopefully will help. We need to pass more comprehensive legislation so that everybody has a chance at a job. And for those who are unemployed looking for work, we need to act so that by next February, 2 million people will not be left without unemployment insurance. But again, these provisions added by the Senate that were part of the President's bill will help to address this simply inappropriate, unacceptable, unsatisfactory rate of employment and reemployment for people who have served our country so loyally and so well. So I support this bill and urge its passage. I yield back.
Gentleman from Michigan yields back. The gentleman from California.
Madam Speaker, I yield myself as time as I may consume.
And the gentleman is recognized.
And first, I'd request unanimous consent to enter 2 letters of support into the record, one from the Government Withholding Relief Coalition, the other from the U.S. Chamber of Commerce.
Without objection.
Madam Speaker, today we have an opportunity to encourage job creation by repealing a tax that's looming over small businesses, and also to improve economic opportunities for the men and women who have risked their life and limb to serve our country in the armed forces. I urge a strong bipartisan vote for this legislation, and I yield back the balance of my time.
Gentleman yields back the balance of his time. The question is, will the House suspend the rules and concur in the Senate amendment to H.R. 674? And those in favor will signify by saying aye. Those opposed will say no. In the opinion of the Chair, 2/3 being in the affirmative, the rules are suspended. The Senate amendment is agreed to, and without objection, the motion to reconsider is laid upon the table.
Madam Speaker, I request a yeas and a nays.
The yeas and nays are requested, and all those in favor of taking this vote by the yeas and nays will rise and remain standing until counted. A sufficient number having arisen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed.
Gentleman from Texas seek recognition.
5 legislative days to revise and extend their remarks and include extraneous materials on H.R. 822.
Without objection. Pursuant to House Resolution 463 and Rule 18, the Chair declares the House in a Committee of the Whole on the State of the Union for the consideration of H.R. 822. The Chair appoints the gentleman or the gentlewoman from Michigan, Mrs. Miller, to preside over the Committee of the Whole.
That was wrong. He was the Speaker then, not the Chair.
She just got appointed to preside over the Committee
Yeah, I know, but when he was up there.
The House is in the Committee of the Whole House on the State of the Union for the consideration of H.R. 822, which the Clerk will report by title.
A bill to amend Title 18 United States Code to provide a national standard in accordance with which non-residents of a state may carry concealed firearms in the state.
Pursuant to the rule, the bill is considered read. The first time, the gentleman from Texas, Mr. Smith, and the gentleman from Michigan, Mr. Conyers, each will control 30 minutes, and the Chair now recognizes the gentleman from Texas.
Madam Chairwoman, I yield myself such time as I may consume.
The gentleman is recognized.
H.R. 822, the National Right to Carry Reciprocity Act of 2011, was introduced by Mr. Stearns of Florida and Mr. Schuler of North Carolina and is co-sponsored by 245 members of Congress on both sides of the aisle. This landmark legislation recognizes the importance of the Second Amendment and makes it easier for individuals with concealed carry permits to travel to other states. 49 states now allow concealed carry permits, and 40 of these states also extend some degree of reciprocity to permit holders from other states. This bill simply applies the states' reciprocal agreements nationwide. This legislation requires states that currently allow people to carry concealed firearms to recognize other states' valid concealed carry permits, much like states recognize driver's licenses issued by other states. The bill recognizes the right of states to determine eligibility requirements for their own residents. State, local, and federal laws and regulations regarding how, when, and where a concealed firearm can be carried that apply to a resident will apply equally to a non-resident. For example, many states bar individuals from carrying firearms in a bar, at a sporting event, or in a state park. Under this legislation, all of these restrictions will apply to non-residents as well. H.R. 822 also addresses concerns regarding the ability of law enforcement agencies to confirm the validity of an out-of-state concealed carry permit. The bill requires a person to show both a valid government-issued identification document, such as a license or passport, and a valid concealed carry license or permit. State law enforcement agencies can verify the validity of an out-of-state concealed permits through the INLETS system. INLETS is available to law enforcement officials in all 50 states 24 hours a day, 7 days a week. Data from the FBI's annual Uniform Crime Report shows that right-to-carry states, or those that widely allow concealed carry, have 22% lower total violent crime rates, 30% lower murder rates, 40% lower robbery rates, and 12% lower aggravated assault rates as compared to the rest of the country. Opponents of this bill have noted that some states would be required to recognize concealed carry permits issued by states with different standards of eligibility. However, 40 states already grant reciprocity to other states, including to states with different eligibility requirements. The states would not do this if different eligibility requirements were a concern. The Second Amendment is a fundamental right to bear arms that should not be constrained by state boundary lines. Opposition to this legislation comes from those who believe concealed carry permit holders often commit violent crimes, which is demonstrably false, or from those who want to restrict the right of law-abiding citizens to bear arms. This legislation enhances the public safety and protects the right to bear arms under the Second Amendment. So I urge my colleagues to support H.R. 822, and Madam Chairwoman, I will reserve the balance of my time.
Gentleman reserves his time. Gentleman from Michigan.
Madam Speaker, I yield myself as much time as I may consume.
The gentleman is recognized.
Members of the House, the measure that we have under consideration today is a very curious one in that there is some misunderstanding of what the constitutional right to carry loaded, hidden guns in public is really all about. And I would begin our discussion to point out that under the proposal before us, a concealed firearm permit issued by any state would be valid in every state that allows a concealed carry provision. And so, for example, a visitor to my home state of Michigan would be allowed to carry a loaded, hidden weapon in public, even if he has not met the minimum requirements to do so mandated by our state law. Different states have enacted different requirements for carrying concealed weapons within their borders. And although federal law prohibits individuals with federal convictions from possessing a weapon, 38 of our states have chosen to deny concealed carry licenses to individuals with convictions for certain misdemeanor offenses. And so I would like to start our discussion off with the fact that there are so many members of law enforcement, so many members of the government, so many members of our editorials. Please consider with me, my colleagues in the House, that every major law enforcement organization in the United States of America opposes the measure that is on the floor today, H.R. 822. Every single organization, the International Association of Chiefs of Police, the Major Cities Chiefs Association, which includes the 56 largest cities in the United States of America, the Police Foundation, the National Latino Peace Officers Association, the National Organization of Black Law Enforcement Executives. We have letters from 600 mayors of the cities in the United States. The National Network to End Domestic Violence have sent us letters. The editorials in the New York Times, the Washington Post, the St. Petersburg Times have all submitted letters. And so I conclude my opening remarks by observing that there is no constitutional right to carry loaded, hidden guns in public. And one of the things I hope we will be able to persuade you on is that the Supreme Court case of 2008 entitled District of Columbia versus Heller is the case that the majority of the court ruled, and Justice Scalia wrote this decision, that while the Second Amendment protects the right of law-abiding citizens to use arms in defense of their home, but that it bans on carrying in public were presumptively lawful. It went on to say that the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment, that the prohibitions were lawful. And Justice Scalia's majority decision in that landmark case rendered 3 years ago stated the Second Amendment is not unlimited and not a right to keep and carry any weapon whatsoever in any manner whatsoever or for whatever purpose. I cite the Supreme Court decision 128-2783 of 2008, the District of Columbia versus Heller, and I reserve the balance of my time.
The gentleman from Michigan reserves the balance of his time. The gentleman from Texas.
Madam Chairwoman, I yield 1 minute to the gentleman from Ohio, Mr. Shabbat, who is a senior member of the Judiciary Committee.
Gentleman from Ohio for 1 minute.
I thank the chairman for yielding. And Mr. Speaker, the Second Amendment to the United States Constitution states, and I quote, "The right of the people to keep and bear arms shall not be infringed," unquote. In this modern age, when it's very common for people to travel to work or for pleasure, it's really become routine. The National Right to Carry Act is a common-sense solution to adapt to today's needs. This legislation allows people with valid state-issued concealed arm permits or licenses to carry a concealed firearm in any other state that has essentially the same laws. To be clear, this legislation does not create a national licensing scheme or agency. It does not supersede the laws for firearms use in any other state. The right of self-defense is a fundamental one, and has been recognized in law for centuries. The Second Amendment dictates that the appropriate way to fight crime is to target criminals, not law-abiding gun owners. Today, we have an opportunity to clearly recognize the right to bear arms for our citizens and to allow law-abiding citizens to exercise freedom without restrictive barriers. Let's take that opportunity today. Yield back.
Gentleman from Michigan.
Thank you, Madam Speaker. I'm pleased to recognize the former chair of the Constitution Subcommittee of the House Judiciary Committee, Jerry Nadler of New York, for as much time as he may consume.
Gentleman is recognized.
Okay, thank you, Mr. Speaker. Madam Speaker, I'm sorry. Madam Speaker, I rise in strong opposition to H.R. 822, what the Brady campaign correctly calls the packing heat on your street bill. Mr. Speaker, America is in dire economic straits. Millions of people are out of work. Our growth rate is anemic. People are clamoring for Congress to pass legislation to grow the economy and help create jobs. And so what is the House of Representatives doing? This august body is considering gun legislation. The disconnect between the Republican House majority and the American people is beyond belief. It is no wonder that Congress' approval rating is 13% according to the latest Gallup poll. Not only are we wasting our time on this issue, but what the bill does should scare every American. This bill, as amended by the Judiciary Committee, would let a person with a concealed carry permit issued by one state take his or her weapon into any other state of which they are not a resident, regardless of the laws of that other state. State laws on both gun possession and concealed carry would be overridden. This bill takes away the right of the citizens of each state to set their own gun control policy. For a Republican House majority that supposedly believes in states' rights, this bill is shocking. So, for example, some states require firearms training or require that people be 21 years old to have a concealed carry permit. All such rules would be tossed aside by this new federal mandate. I tried to protect states by filing an amendment with the Rules Committee, which would have created an exception to the bill to let states enforce laws against persons convicted of sex offenses against minors from possessing guns or having concealed weapons. That amendment was not made in order. I guess it was more important to satisfy the gun lobby than it is to make sure our kids are protected from violent predators. To the extent states want to allow their citizens to enter into other states with concealed weapons, they can do so by entering into reciprocity agreements, and many states have done so. But why would we force those that have not, or which have chosen to end reciprocity agreements due to the lax standards of another state, why would we force them to accept the concealed carry permit of every other state? Because any permit would suffice, this bill will create a race to the bottom, with whatever state has the most permissive concealed carry rules setting national policy. In some states, you don't even have to be a resident to get a concealed carry permit. This lowest common denominator approach will only lead to more people carrying more hidden weapons, packing heat on your street. Knowing there are more concealed handguns all around does not make me feel safer. Lastly, I want to address the constitutional argument. In Heller, the Supreme Court held there's a Second Amendment right for persons to bear arms. Nowhere did the Court say, however, that there is an unlimited national right to carry a concealed handgun. In fact, Justice Scalia recognized the legality of reasonable limits on the Second Amendment. I can't imagine a more reasonable restriction for states to impose than those which govern who can carry a concealed firearm in their own states. I ask that members reject this deeply flawed and dangerous bill, and I yield back the balance of my time.
Gentleman yields back. The gentleman from Texas.
Madam Chairwoman, I'll yield 3 minutes to the gentleman from Arizona, Mr. Franks, who is the chairman of the Constitution Subcommittee.
Gentleman from Arizona is recognized for 3 minutes.
And I thank the chairman. And Madam Chair, H.R. 822, initially introduced by Mr. Stearns of Florida and Mr. Schuler of North Carolina and supported by more than half of my colleagues in the House of Representatives, would allow people with a valid permit or license to carry a concealed handgun in any other state that permits concealed carry. This is a policy akin to allowing licensed drivers from one state to drive their car in another state so long as they obey the local laws. Madam Chair, clearly the constitutional right to defend oneself and one's family should not be limited to only when you are at home. Madam Chair, criminals have always preferred unarmed victims. Conversely, law-abiding citizens capable of defending themselves and their fellow citizens demonstrably save innocent lives. To give one of countless examples, in 2007, a man in Colorado named Matthew Murray wrote online, quote, "All I want to do is kill and injure as many Christians as I can," close quote. Murray then went on a shooting rampage, first killing 2 young students at a missionary training center outside Denver, and then at a gathering of over 7,000 people in and around the New Life Church in Colorado Springs, Colorado. With a rifle and a backpack full of ammunition, Murray entered the church and opened fire, killing 2 sisters. Murray was ultimately stopped and killed by Jean Assam, a church member and a voluntary security guard who once worked in law enforcement and who had a concealed carry permit. Apart from this armed hero's actions, Madam Chair, many more innocent citizens would have died that day. H.R. 822 includes a number of provisions intended to retain the state's ability to regulate firearms use in their own states and increase public safety. Nothing in the bill affects a state's ability to set the eligibility requirements for its own residents, nor does it affect any state laws or regulations regarding how, when, or where concealed firearms can be carried. It also requires people who want to take advantage of the federal grant of reciprocity to be properly permitted or licensed by a state to carry a concealed weapon, and to be able to produce both the permit or license and a government-issued identification document. To reiterate Chairman Smith's comments, studies have shown that concealed carry laws are very good public policy for our country, Madam Chair. The NRA has estimated, based on FBI crime report data, that right-to-carry laws, which widely allow concealed carry, have 22% lower violent crime rates, 30% lower murder rates, and 46% lower robbery rates than states that prohibit or greatly restrict concealed carry. H.R. 22 will help further extend this trend. And with that, Madam Chair, I urge my colleagues to support this bill and yield back the balance of my time.
Gentleman from Michigan.
For 1 minute.
Gentleman's recognized for 1 minute.
Thank you. And I thank the gentleman. Mr. Speaker, for all of the talk of states' rights in this chamber, H.R. 822 obliterates the rights of state governments to pass their own gun rules and protect their own citizens from illegal gun violence. In my own state of Florida, we have a right to carry law, but we require those who seek such concealed permits to prove basic competency. To protect our families, we deny concealed carry permits to those convicted of felonies, to those committed to mental institutions, or those with a history of illegal drug use. H.R. 822 denies Floridians the right to protect their own families and set their own standards. If Floridians wanted gun laws as lax as those in Utah, they would adopt their own. I'm disappointed the Rules Committee blocked my own attempt to amend this bill to ensure that individuals with concealed weapons could only cross state lines into states that maintain a national law enforcement database. Without a database system accessible 24 hours a day with criminal background information on individuals holding concealed weapons permits from other states, Florida's law enforcement will be unable to adequately protect the public under this bill. It is the safety of our communities and our families that are at risk as a result.
Chairman, I yield 3 minutes to the gentleman from Florida, Mr. Stearns, who is the writer, author, creator of this legislation. I make that 5 minutes.
Gentleman from Florida is recognized for 5 minutes.
I would say to my colleague, I'm from Florida, and so I'm supporting this bill. In fact, I'm the proud sponsor of this bill, ladies and gentlemen. I have sponsored this legislation since 105th Congress. It's almost 14 years ago, because I believe it's long overdue that we take action to enhance the fundamental right of self-defense for all law-abiding citizens of this country. I want to thank Mr. Trent Franks of Arizona for his assiduous and hard work in pushing this through the full committee and subcommittee, and also thank Chairman Lamar Smith for his efforts too. My colleagues, the simple right to defend yourself and your loved ones from criminal is fundamental, and it's not extinguished when you simply cross a state border. This bill recognizes this important fact by establishing the interstate recognition of concealed carry permits in much the same way driver's licenses are recognized. Now, under this legislation, lawfully issued carry permits will be recognized in all states that also issue carry permits. There are now 49 states that issue these permits. Most of these states also recognize permits issued from at least some other states, while some states recognize all valid permits issued by any state. But herein simply lies the problem. The non-uniformity of the laws regarding reciprocity makes it difficult for law-abiding permit holders to know for sure if they are obeying the law as they travel from state to state, while preserving the power of the states to set the rules on where concealed firearms can be carried. This legislation will establish interstate carry permit recognition in the 49 permit-issuing states. So this legislation will simply make it easier for law-abiding permit holders to know that they are simply in compliance with the law when they carry a firearm as they travel this wonderful country of ours. Now, consider the outcome if states administered driver's license as they currently do carry permits. Drivers would have to stop at the state line to determine whether their license was valid before proceeding. Each state would recognize some licenses, but of course not all of them. Some states would insist that others had precisely the same requirements for issues of a license before offering reciprocity. And the status of such reciprocity would be constantly changing, literally day to day. So that is the reality of the current state reciprocity agreements for carrying permits today. And only the Congress can remedy this interstate muddle. Our union is a strong one, and we are proud to be citizens of a nation who need not present papers to cross internal boundaries. But the holders of carry permits must indeed today worry whether their permits are valid before they can safely venture out of their home state while exercising a fundamental right. Our system of federalism beckons this body to remedy this disparity in due process and equal treatment under the law. So, Mr. Chairman, over the past 20 years, 17 states have passed right-to-carry laws. In each of these states, opponents of firearm ownership have made dire predictions of mayhem in the streets if we simply dare to allow law-abiding citizens to carry a firearm for their own self-defense. But in each case, these predictions were proven to be completely false. In fact, during that period, violent crime has dropped 51% to a 46-year low, 1991 to 2011, and these are according to the FBI Uniform Crime Reports. Statistics don't lie in this case. They're actually showing violent crime has dropped, and this is one of the reasons. Mr. Chairman, this legislation will not strip states of the ability to prohibit dangerous persons from carrying a firearm. Federal law already prohibits a convicted felon or someone shown to be a danger from the mere possession of a gun, and the carry regulations set up in each state will apply to all permit holders, both residents and non-residents. This bill does not set up a federal carry permit system or establish any federal regulations of concealed carry permits. That power remains with the states. Additionally, this legislation does not include any new federal gun laws, nor does it call for additional federal regulation of gun ownership. In fact, it does not allow for new federal regulation, for it amends the part of the Gun Control Act that allows only such regulation as are necessary. Additional 1 minute.
Mr. Chairman, I'd like to yield the gentleman an additional 1 minute.
Gentleman's recognized.
In fact, it does not allow for new federal regulation, for it amends the part of the Gun Control Act that allows only such regulation as are necessary, and in this case, none, my colleagues. This legislation simply guarantees citizens constitutional rights as affirmed by two Supreme Court cases, D.C. versus Heller and McDonald versus Chicago, which simply ruled the Second Amendment is an individual right. This bill will allow law-abiding citizens who already have valid carry permits to carry firearms when they travel to protect themselves and to protect their families. These people who have proven themselves to be among the most responsible and safe members of our communities, and we should not deprive them of this fundamental right when they simply cross a state border. So I urge my colleagues to support this important legislation. It's a long time in coming. I'm pleased it's on the floor, and I look forward to its passage. Thank you, Chairman.
Gentleman from Michigan.
I yield myself 30 seconds.
Gentleman's recognized.
I want to just say to my dear friend from Florida, Cliff Stearns, you cannot compare licensing concealed carry permits to driver's licenses, and that's why this idea of yours, with all due respect, has never been passed by the Congress before. The reason is that no states have the same way to automatically check a driver's license for concealed carry. They can, I yield myself 15 additional seconds. You cannot compare carrying concealed weapons check with a driver's license because they are checkable. A concealed carry weapon, there are states that don't even permit the information to be revealed from their database. So you're making a huge error that I hope can be corrected. And with that, Mr. Speaker, I'd yield to the distinguished gentlelady from California, a member of the Judiciary Committee, 1 minute.
Gentlelady is recognized for 1 minute.
This bill is a blatant attempt to override and weaken states' laws on an issue that could endanger people's lives. It hurts my home state of California, which developed laws to protect residents by developing criteria on those who could carry concealed carry weapons. With this bill, that all goes away. This bill is so bad that it even allows drug dealers convicted of selling drugs to a minor to carry a concealed weapon. California would not allow it because such permits can only go to those of good moral character. But under this law, we would have to accept the concealed weapon permit for every other state that allows weapons to these drug dealers. I offered an amendment in Judiciary Committee to stop this, but those on the other side of the aisle voted it down. With this bill, a person who endangers the lives of our children will be allowed to carry a concealed loaded gun nationwide, and you would be powerless to stop it. It is the individual states that are in the best position to determine how to best protect its citizens. I strongly urge my colleagues to vote no on this dangerous bill.
I'd like to yield 15 seconds to the gentleman from Arizona, Mr. Franks.
Gentleman's recognized for 15 seconds.
Thank you, Mr. Chairman. Mr. Chair, I just would suggest to my friend, Mr. Conyers, that he is correct. One cannot compare this with strictly with people and driver's licenses. The fact is, first of all, a driver's license or driving a car is not a fundamental right to defense as enshrined in our Constitution. Secondly, cars kill many more people than guns. And third, we don't usually defend ourselves with cars.
Gentleman from Texas.
Mr. Chairman, I'll yield 1 minute to the gentleman from Ohio, Mr. Austria.
Gentleman's recognized for 1 minute.
Thank you, Mr. Chairman. As a former chairman in the Ohio Senate Judiciary Committee, I helped lead the fight to pass the first concealed carry law in the state of Ohio. And I can tell you, even with this law and this right, and as one of the thousands of Ohioans with a concealed carry permit, I understand the need to reinforce our Second Amendment rights by resolving the confusion and the problems that exist when traveling between states. The National Right to Carry Reciprocity Act does just that. It allows Ohioans and others with valid CCW permits issued by their home state to conceal carry while visiting any of the 49 states where it's not expressly prohibited. H.R. 822 is not a federal takeover. The bill preserves states' rights by requiring residents to comply with their home state's rules for getting a permit. The bill also maintains reciprocity agreements the states have already entered into with other states. The bill simply strengthens and protects our constituents' Second Amendment rights, and that's why I've co-sponsored this legislation and look forward to its passage. Thank you, and I yield back the balance of my time.
Gentleman from Michigan.
Thank you, Mr. Speaker. I yield myself just 30 seconds, Mr. Scott. I just want, when we decide how we're going to cast our vote on this bill, to realize you cannot compare a concealed weapon carry permit with a driver's license. The states do not have the ability, they do not have the automated machinery to do that. Many will not even release this information. It's considered a private matter. Concealed carry permit information cannot be revealed in many states. And I now turn to the former chairman of the subcommittee on crime, the distinguished member of Judiciary Committee, Bobby Scott of Virginia, for 3 minutes.
Gentleman recognized for 3 minutes.
Thank you, Mr. Chairman. I thank the gentleman for yielding. Mr. Chairman, H.R. 822 will harm public safety. That's why law enforcement organizations such as the International Association of Chiefs of Police, Major Cities Chiefs Association, and many other law enforcement organizations oppose this bill. This bill will allow people to use their concealed weapons permit in any state in the Union without regard to the standards and requirements of those other states. This bill even allows people who are ineligible to get a concealed weapons permit in their home state to go out of state and get a permit and use that permit anywhere in the country except their home state. Some states have minimum standards for those who may be eligible to carry a concealed weapon. For example, some states require firearms training. Others deny permits to those who are under 21 or those with certain convictions for assaulting police officers, selling drugs to kids, sex offenses against children, or domestic violence. Standards such as these would be overridden by this bill because permits from states without these standards would have to be recognized. Now, many states already recognize concealed weapons permits from other states. My home state of Virginia recognizes many states' concealed weapons permit, but it requires a 24-hour verification. And for this reason, many states do not enjoy reciprocity with Virginia because 24-hour verification is not available. In fact, one state, Colorado, didn't even maintain a database, a statewide database, so there can be no out-of-state verification. As it's been indicated, a driver's license any time of day, you can verify the validity of a driver's license. But the concealed weapons permit, many states do not have 24-hour verification. In overriding the ability of states to control the carrying of concealed weapons by non-residents, this bill would create a situation where the weakest state laws essentially become the national law. We will be creating a race to the bottom in public safety. Now, consideration of this legislation has been a challenge because apparently many people in this body believe that if more people carried guns, the crime rate would go down. Reliable studies, however, point out that the possession of a firearm is much more likely to result in the death of a family member or neighbor than being used to thwart a crime. This bill will undermine public safety. We should let the states decide whether or not or under what conditions to allow people who are in their state to carry concealed handguns, and I urge my colleagues, therefore, to vote against this legislation. I yield back.
Gentleman from Texas.
Mr. Chairman, I'll yield 1 minute to the gentleman from Indiana, Mr. Stutzman.
Gentleman's recognized for 1 minute.
I thank the gentleman for yielding. Mr. Speaker, rights do not come from the government. We are, in the words of the Declaration of Independence, endowed by our Creator with certain unalienable rights. Mr. Speaker, the right to self-defense goes deep and cannot be taken away. The right to self-defense is the cornerstone for the Second Amendment. It is also the foundation for concealed carry laws across this country. I'm proud that my home state of Indiana has established a responsible process for obtaining a lifetime permit. Today, 49 states have some sort of right to carry law. Mr. Speaker, this bill ensures that permit holders in Indiana, like myself, can exercise our right to self-defense when our families travel across our great country. If you follow the law, your permit from one state will be honored by another. Thank you, Mr. Speaker. I'll yield back.
Gentleman from Michigan.
Mr. Speaker, I yield myself 15 seconds, please. Ladies and gentlemen, Forgive my passion on the discussion of this subject, but almost 300 young people of African American descent are injured or killed by gunfire from ages 15 to 24 every week. And with that, I would yield to my colleague, Mike Quigley, distinguished member of Judiciary from Illinois, 2 minutes.
Gentleman's recognized for 2 minutes.
Thank you, Mr. Chairman. I rise in opposition to this measure. I, too, offered an amendment which failed in committee. My amendment would have prevented individuals convicted of assaulting a police officer or impersonating a police officer from carrying concealed loaded guns. Several states that allow permits also deny them to those who have assaulted or impersonated cops. The law enforcement officials of these states have decided that that is what's best for their communities. This bill will wipe those protections away and then will go further. May I remind my friends here who are citing the Constitution as their nexus for this law that the right to keep and bear arms in the interest of self-defense of a person at home is not unlimited. As the justices wrote in the District of Columbia versus Heller, quote, "The right is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose," end quote. But frankly, that's what the National Right to Carry Reciprocity Act purports. So if we're interpreting the 14th Amendment, deeming the Bill of Rights applicable to the states in this manner as to the right to bear arms, then doesn't that argument also dictate that each state interpret other states' decisions on other laws and statutes in the same manner? Does this mean that states should acknowledge abortion rights from one state to the next? Does this mean that states should acknowledge alcohol laws from one state to the next? Does this mean that states should acknowledge marriage licenses from one state to the next, particularly when it comes to same-sex marriage? I have a feeling that many of my friends here today would answer those questions with a simple no. You see my trouble with today's premise, then. I urge my colleagues to oppose this bill, and I yield back.
Gentleman from Texas.
Now I yield 1 minute to the gentlewoman from North Carolina, Ms. Elmers.
Gentlewoman is recognized for 1 minute.
Thank you. I rise today in favor of H.R. 22. The right to bear arms is a staple of our Constitution as a basic American right, and we should continue to protect it while making sure our laws remain efficient. I am one of 268,000 permit holders in North Carolina. This is not only a right issue, more importantly, it is a safety issue. As millions of American families can attest, there is no greater threat to our families than the ability to protect. We must protect our families, and it cannot stop at states' borders. H.R. 822 also does not impact state laws governing how concealed firearms are possessed or carried. Again, it does not jeopardize the state's rights. I call on my colleagues to support this important piece of legislation, and I yield back the remainder of my time. Thank you.
15 seconds. There are, my colleagues, over 65 million handguns in the United States. And in each year, nearly 100,000 people in America every year are shot or killed with a firearm. And I now yield to our distinguished judiciary colleague, a former magistrate from Georgia, Hank Johnson, 2 minutes.
Gentleman is recognized for 2 minutes.
Thank you, Mr. Chairman. Mr. Speaker, I rise today in opposition to this dangerous bill, the National Right to Carry Reciprocity Act. The 10th Amendment of the Bill of Rights of the United States Constitution provides as follows: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Mr. Speaker, this bill would override the laws of almost every state by forcing them to accept concealed carry gun permits from every other state, even if the permit holder would not be allowed to carry a handgun in the state where he or she is traveling. This is ridiculous. Each state should decide who may carry a concealed loaded gun within their borders, and the federal government should respect the state's rights to do so. The irony here is that my friends on the Tea Party Republican side of the aisle claim to respect states' rights, but then they rush this legislation to the House floor, which tramples over states' rights. These Tea Party Republicans claim they want to create jobs for the millions of unemployed Americans in our nation, but they are not focusing on creating jobs. Instead, they're bowing down to the National Rifle Association by moving this piece of special interest legislation forward. I urge my colleagues to oppose this dangerous bill, and thank you, and I yield back the balance of my time.
Gentleman from Texas.
Mr. Chairman, I'll yield a minute to the gentleman from Minnesota, Mr. Klein, who is also the chairman of the Education and Workforce Committee.
The gentleman's recognized for 1 minute.
I thank the gentleman for yielding. Mr. Chairman, I rise today in strong support of H.R. 822, the National Right to Carry Reciprocity Act. This bill provides important protections for gun owners, and its time is past due. As a retired Marine and avid outdoorsman, I'm an experienced firearms owner and user. I hold a concealed carry permit in the state of Minnesota, and I believe individuals have the right to keep and bear arms for the protection of their home, property, family, and person. They have that right. Unfortunately, there have been a lot of mischaracterizations surrounding this legislation. I've heard a lot of it here today. To be clear, this bill does not create a federal licensing or registration system. It does not create federal standards or infringe on the ability of states to make laws for a carry permit, and it does not negatively affect states that have permitless carry systems. Mr. Chairman, this bill will protect law-abiding gun owners from current confusion caused by the wide array of state laws and preempt the threat of frivolous lawsuits they could face simply by traveling outside of their home state. National Right to Carry Reciprocity provides critical recognition that the Second Amendment rights of our constituents do not end when they cross state lines, and this will enhance public safety. I urge my colleagues to stand for the Second Amendment, to stand for the rights of responsible gun owners who engage in gun safety, and I urge them to support H.R. 822. I yield back.
Gentleman from Michigan.
Thank you, Mr. Speaker. I yield to our dear friend Jim Moran of Virginia of 1.5 minutes. I apologize to him for that.
Mr. Speaker, the first reason this bill should be defeated is that it usurps state authority and replaces it with a lowest common denominator federal directive. This is a radical piece of legislation. In fact, today, 43 states are not in compliance with this law. 38 states today prevent people from carrying concealed weapons if they have certain dangerous misdemeanor criminal convictions. 35 states require the completion of a short gun safety program. The Commonwealth of Virginia has weakened its gun laws over the past 2 years, allowing concealed guns in bars and renewal of permits by mail. I disagree with these actions, but I would never question the General Assembly's authority to make these decisions. But this bill makes our state legislature's judgment irrelevant. This is a federal power grab, coming from a majority that claims to be a defender of states' rights. The second reason that this bill should be defeated is that our law enforcement professionals oppose it. The International Association of Chiefs of Police, the Major Cities Police Chiefs Association, the Virginia Association of Chiefs of Police all oppose this bill. Why? Because they know that it will be nearly impossible for police to verify the validity of 49 different carry permits, placing officers in potentially life-threatening situations. Some states don't even keep verifiable databases of those who have been issued concealed carry permits. Law enforcement is trying to curb illegal gun smuggling, but this bill allows traffickers with concealed carry permits to transport firearms into destination states and present an unverifiable permit if stopped by police. This is a blatant legislative overreach, presumably because it was next on the NRA's legislative wish list. We should defeat this bill, Mr. Speaker.
Gentleman from Texas.
Arkansas, Mr. Ross.
Gentleman from Arkansas is recognized for 1 minute.
Thank you, Mr. Chairman. I rise today in strong support of H.R. 822. If you get a driver's license in Arkansas, it's recognized in every state in the country. And if you have a concealed carry permit, the same rules should apply. Our Second Amendment rights to own and bear arms are universal, and our laws should reflect that as best they can. The National Right to Carry Reciprocity Act would allow every American citizen with a valid concealed carry permit to carry a concealed firearm in all states that allow them for lawful purposes. Let me be clear. If your state bans concealed firearms, then this law will not affect that ban. This bill does not change any state laws about when and where you can carry a concealed firearm. This bill does not create a new federal licensing system. It simply reinforces our Second Amendment rights and makes the laws more fair for law-abiding gun owners. As a strong supporter of the Second Amendment, I believe we must pass the National Right to Carry Reciprocity Act now, and I urge my colleagues to join me in voting for the bill.
Mr. Speaker, I yield to the distinguished gentleman from New Jersey, Bill Pascrell, 1.5 minutes.
Gentleman is recognized for 1.5 minutes.
Thank you, Mr. Speaker, Mr. Ranking Member, Mr. Chairman. I had to make a choice on this bill, whether I would support a disputable constitutional issue about whether you can, by law, carry a concealed weapon, or move towards the other side to those who oppose this. Now, who opposes this legislation besides me? Mayors Against Illegal Guns, the International Association of Chiefs of Police, the Major Cities Chiefs Association, and the Police Foundation oppose this bill. Doesn't this mean anything to you at all? Doesn't it? Or does it? I prefer community policing than try to put more guns into the hands of those people who we don't even know are going to be trained to even use them. That's my preference, Mr. Chairman. This means my home state of New Jersey. This is not Idaho. This is not Montana. We're pretty close. In fact, we have the most densely populated state in the Union. There is a different culture. When Clinton argued in behalf of gun possession when he was the President of the United States, he always made this point about the cultural differences in different parts of the country. We respect that. I'm not against the Second Amendment. I support the Second Amendment. But I don't want those folks in the street who are armed and are gunned are police officers. 12,000 less police officers we have in this country. Thank you. Mr. Speaker.
Gentleman's recognized.
Thank you. 12,000 less police officers in our streets. We should be worried about that as a priority rather than this as a priority. So I made the decision. The evidence is like this against doing this. We haven't had any legislation which took away one gun in the past 20 years from anybody in this country. Not one. So we have made the perception being that we want to take guns away from people. How dare you even say it? Protect our police. Don't vote for this.
1 minute to the gentleman from Illinois, Mr. Kinzinger.
Gentleman's recognized for 1 minute.
Well, thank you, Mr. Speaker. The right to keep and bear arms is a real simple phrase, but it seems to, in some people, have only negative thoughts. When the words gun or firearm are heard, thoughts immediately turn to criminals. But that's the problem, because the debate we're having today isn't about criminals. It's about the rights of law-abiding citizens to bear arms for self-defense. Look, Illinois is the only state without concealed carry, but I'd argue we already have concealed carry. There are people that are killed in Chicago very often by guns that are already concealed, but not concealed by law-abiding citizens. Illinois is the only state that doesn't allow any form of it legally.
I want H.R. 822 to be a clear sign to the governor of Illinois that now is the time to join the rest of the country in allowing citizens the right to conceal a firearm on their person. We hear so much about if we allow people to carry guns, more people are going to be killed, but that flies in the face of statistics. After 2008, there was a record number of guns purchased, but we saw crime drop almost everywhere, bar none. My point is that law-abiding citizens in this country are not the problem. Illinois needs to join the rest of the country in supporting concealed carry for its citizens, and I believe that this is a sign that it's time to do so now, and I yield back.
Gentleman from Michigan.
Mr. Speaker, I'm pleased to yield to the distinguished gentlelady from Florida, Debbie Wasserman Schultz, a former member of the Judiciary Committee, 2 minutes.
Gentlelady is recognized for 2 minutes.
Thank you, Mr. Speaker. I rise in opposition to H.R. 822, the National Right to Carry Reciprocity Act. This ill-conceived bill is yet another distraction from what should be the most pressing concern of this Congress, putting Americans back to work. What's more disturbing is that this bill jeopardizes public safety by mandating that states honor even the most lax concealed weapons laws of other states. The gentleman from Illinois is incorrect. This is about criminals. For my constituents in South Florida, gun control is a serious issue. Miami-Dade County has one of the highest rates of gun violence in the country, and in the entire state of Florida, there are almost 800,000 permits for concealed firearms. Florida's process for issuing concealed carry licenses is problematic enough, and I would certainly not suggest foisting it on any other state that has stronger safeguards to protect its citizens. But this bill will do exactly that. For states that require age minimums or safety training before getting a concealed weapons permit, or that prohibit certain violent offenders from getting a permit in the first place, that all goes out the window if this bill is passed into law. What we get in return is the worst of the worst, a lowest common denominator of all these state laws. For example, in just one 6-month period in 2006, Florida gave concealed carry licenses to more than 1,400 individuals who had pleaded guilty or no contest to felonies. 216 of them had outstanding warrants. 128 of them had active domestic violence injunctions. And under this bill, other states will be mandated to honor these permits. They'll be mandated to allow Florida's self-admitted felons to carry concealed weapons in their states. This is why the nation's leading law enforcement organizations strongly oppose this bill. It's also opposed by more than 600 members of the bipartisan Mayors Against Illegal Guns, including many of my local mayors of both parties in South Florida. Why would this bill be a higher priority than creating jobs? This is the 11th straight month of this Congress, and the House majority still has no jobs agenda. Regardless of how Americans feel about guns, the overwhelming majority would agree that gun policy is not a higher priority than job creation is right now. I urge my colleagues to vote no on this bill, and I urge my friends across the aisle to stop putting American lives at risk and start putting them back to work. Thank you. I yield back the balance of my time.
Gentleman from Texas.
Mr. Chairman, I yield 1 minute to the gentleman from North Carolina, Mr. Coble, who is also the chairman of the Court Subcommittee of the Judiciary Committee.
Gentleman is recognized for 1 minute.
I thank Mr. Smith. Mr. Chairman, I rise in support of H.R. 822. Conceal and carry permits may be one of the most scrutinized permits for gun owners to receive. Unfortunately, the manner in which these permits are recognized by various states is confusing and inconsistent. H.R. 822 will help resolve this dilemma, Mr. Chairman. For example, in my home state of North Carolina, conceal and carry permits from South Carolina and Georgia are recognized, but not permits from New Mexico. Meanwhile, New Mexico readily recognizes conceal and carry permits from North Carolina. If enacted, there would be no discrepancy over which permits are valid. Another reason for supporting H.R. 822 is that it protects state sovereignty. States are not required to issue conceal and carry permits, and state laws regarding the use and ownership of firearms are explicitly preserved. I firmly believe that the Second Amendment confers a constitutional right for individuals to own a firearm, Mr. Chairman. I also believe that ownership and use of a firearm carries a special level of personal responsibility. This bill promotes both of these ideals, and if enacted, it will help make America safer, which probably explains why this bill has 245 co-sponsors. I thank the chairman and yield back.
Gentleman from Michigan.
Speaker, I am pleased to yield to the distinguished gentleman from New Jersey, Rush Holt, 2 minutes.
Gentleman's recognized for 2 minutes.
I thank the gentleman. Mr. Speaker, this is another great example of legislation in search of a problem. Driven by ideological fervor of its sponsors rather than by any practical approach to safety, H.R. 822 would amend existing federal law to establish a national standard for carrying concealed firearms. As the sponsors well know, these matters have long been the province of the states. It's fascinating how quickly the majority ignores the 10th Amendment when the gun lobby comes calling. Why needlessly create a conflict, or should I say a shootout, between the Second and the 10th Amendments? Passage of the Law Enforcement Officers Safety Act of 2004, which I voted for, and which permits qualified law enforcement officers to carry concealed firearms across states, makes this essentially redundant and unnecessary. The bill before us would have the effect of overriding New Jersey's own laws in this area, which police officers and hunters and other citizens tell me works well and keeps our citizens safe. Ask our law enforcement officers. They'll tell you New Jerseyans live well within our gun safety laws. We don't need more lax laws. Now, others have said today, but maybe it's worth repeating, this body should be focusing on creating jobs, not passing ideologically driven special interest legislation that would endanger public safety, subvert the constitutional order, and go against the interests and the declared recommendations of law enforcement officers all across the U.S. I yield back my time.
Chair would inform the managers. The gentleman from Texas has 9 1/4 minutes remaining. The gentleman from Michigan has 2 1/2 minutes remaining. Gentleman from Texas.
Mr. Chairman, I will yield 1 minute to the gentleman from California, Mr. Lundgren.
Gentleman's recognized for 1 minute.
Thank you very much, Mr. Chairman. I strongly support the Second Amendment. For that reason, I signed on to the amicus briefs in the Heller case and the McDonald versus City of Chicago case, upholding the right to bear arms as an individual constitutional right. I believe that. At the same time, as the former Attorney General of California, I continue to have a deep and abiding commitment to preserving states' rights in the manner that the founders envisioned the notion of federalism. And under the 10th Amendment, it is obvious that the Constitution allocates what are known generally as police powers to the states to protect public safety and health. That's why I object to some of our legislation to expand the federal role in tort law and in marriage law, because it's not just those things you necessarily agree with, but it's tougher when it's those things you may disagree with that are left to the states. Some people have talked about licenses here. You don't have a right to take your license to practice medicine or law to the next state. We have not required that. We allow states to do that. And here's the other thing. My state's one of the most liberal. We have too liberal a law with respect to concealed weapons. But the only way the liberal state legislature in California will respond to this is by following Illinois, because it's the only way they can get a limit, as they see it, on these sorts of things. Would the gentleman give me a little more time?
I'll give you 15 seconds.
And so my suggestion is those who are concerned about it in my state might have to worry about this, because our legislature will now be tempted to get rid of all concealed weapons permits, because unfortunately under this legislation that's the only thing they can do to police the eligibility of those who get concealed weapons permits. So this does cut both ways, and at least I think we ought to understand that states' rights are a legitimate argument here on this floor.
Gentleman from Texas.
Mr. Chairman, I'll yield 1 minute to the gentleman from Utah, Mr. Matheson.
Gentleman from Utah is recognized for 1 minute.
Thank you, Mr. Speaker, and I'd like to thank my colleague, Mr. Stearns, for introducing the bill before us today. I support this bipartisan legislation for 2 reasons. 1, I believe that our gun laws should ensure that a responsible, law-abiding individual is able to exercise the Second Amendment right to carry firearms. And 2, this bill simplifies what is now a piecemeal system of existing reciprocal agreements among the states. There are millions of concealed carry permit holders in this country, including thousands in my state. They comply with state law to gain a state permit so they can legally carry a weapon for self-defense. By passing this bill, we will assure that when they travel to other states, they'll be able to exercise their right to self-defense while away from home. This bill does not create a federal licensing or registration system. It does not allow concealed weapon permit holders to carry concealed weapon in states like Illinois that do not allow concealed carry. I think that addresses the criticism of this legislation that would override a state's ability to determine who can carry concealed weapons within that state's borders. Permit holders who want to take their weapon with them to another state are required to be aware of and abide by that state's rules. As a strong supporter of Second Amendment rights, I support this legislation and I urge its adoption. I'll yield back my time.
Gentleman from Texas.
Mr. Chairman, I'll yield 1 minute to the gentleman from New York, Mr. Gibson.
Gentleman is recognized for 1 minute.
I thank the chairman for yielding. Mr. Speaker, I rise today in strong support of H.R. 822, the National Right to Carry Reciprocity Act. This bill is about freedom. It's about the Constitution and our Bill of Rights. This bill is about the Second Amendment right. As with all the amendments contained in the Bill of Rights, these were born out of our experiences with King George and a desire to prevent such abuses of power in our republic. Indeed, at the outset of hostilities during the Revolution, the British Army marched on Concord to confiscate our guns and extinguish our freedoms. The Founders put the Second Amendment in the Bill of Rights to assure our right to keep and bear arms and safeguard our liberty. This is a nonpartisan bill, at least in my district. Republicans, Democrats, and Independents alike support the Second Amendment and hold dear our Bill of Rights. The premise of 822 is very simple. If a citizen is permitted to carry a concealed weapon in one state, other states that have a concealed carry law will honor and recognize it, supporting and strengthening the Second Amendment. I urge my colleagues to support it, and I yield back.
Gentleman from Texas.
Mr. Chairman, I'll yield 2 minutes to the gentleman from Virginia, Mr. Goodlatte.
Gentleman from Virginia is recognized for 2 minutes.
I thank the chairman for yielding and for his leadership on this issue. Mr. Speaker, I rise today in strong support of H.R. 822, the National Right to Carry Reciprocity Act of 2011. This bipartisan bill has 245 co-sponsors and enhances Americans' right to self-defense by enabling millions of permit holders to exercise their right to self-defense while traveling outside their home states. You know, the Second Amendment is in the United States Constitution, and we are all taking an oath in this body to uphold the United States Constitution, including rights under the Second Amendment. And the 10th Amendment is certainly an important right as well, but it does not trump the right or the responsibility of this body to protect rights under the Second Amendment. 49 states have laws that permit their citizens to carry a concealed firearm in some fashion or another. Unlike driver's licenses, however, concealed carry permits in one state are not always authorized to carry their firearms when traveling outside their home state. H.R. 822 remedies this problem by granting concealed carry permit holders reciprocity between states. The firearm owner must abide by all applicable state laws when carrying in a foreign jurisdiction. This bill affirms the Second Amendment, that the Second Amendment protects the fundamental individual right to keep and bear arms, and that the states cannot unreasonably infringe upon that right. In McDonald v. Chicago, the Supreme Court concluded that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized by the Supreme Court in the District of Columbia v. Heller. This bill does not create any kind of federal bureaucracy that may concern some people. It simply extends to them their Second Amendment rights when they travel in other states. H.R. 822 recognizes that right, and I urge my colleagues to support this measure. Yield back the balance of my time.
The gentleman from Texas has 4 1/4 minutes remaining. The gentleman from Michigan has 2 1/4 minutes remaining. Gentleman from Michigan.
Mr. Speaker, I yield the balance of our time to the distinguished gentleman from Georgia, Mr. Rob Woodall.
The gentleman is recognized for 2 1/4 minutes.
Thank you, Mr. Chairman. I thank the gentleman for yielding. I love the Second Amendment. I got my first gun from Santa Claus when I was 6 years old. First handgun I ever fired wasn't my dad or my uncle's or my grandfather's, it was my mother's. I got my first concealed carry application filled out as a freshman in law school, lived in a bad neighborhood, needed it for self-protection. I've had it for the last 20 years. I love the Second Amendment. But if the Second Amendment protects my rights to carry my concealed weapon from state to state to state, I don't need another federal law that says, yeah, I really mean it. It's already protected. And if the Second Amendment doesn't protect my right to carry a concealed weapon from state to state to state, then the 9th and 10th Amendments leave that responsibility to individuals and the states to regulate on their own. I came to Congress to protect freedom. I don't believe the Second Amendment was put in the Bill of Rights to allow me to shoot targets. I don't believe the Second Amendment was put in the Bill of Rights to allow me to hunt for deer in Turkey. I think the Second Amendment was put in the Bill of Rights so that I could defend my freedom against an overbearing federal government. I don't want the federal government in any issue of the law where the Constitution does not require it. And it does not require it here. Don't tell me it's an interstate commerce clause issue. We dismiss that on my side of the aisle regularly. Don't tell me it's necessary and proper. We dismiss that on our side of the aisle regularly. And don't tell me it's full faith and credit, because we dismiss that on our side of the aisle regularly. The temptation to legislate is great. The temptation is great. I absolutely believe in the intent of this legislation. I want the right to carry from coast to coast. Georgia has already orchestrated reciprocity agreements with 25 states. We've got 24 more to go. The Second Amendment exists so that we can keep and bear arms to defend ourselves against government, no matter how well intended. Rather than arms, I ask my colleagues to use their voting cards today to defend us against the overreach of federal government, no matter how well intended. And I thank the gentleman for yielding.
Gentleman from Texas.
Mr. Chairman, I'll yield 1 minute to the gentleman from Alaska, Mr. Young.
Gentleman from Alaska is recognized for 1 minute.
Thank the gentleman for yielding, and I've listened to this debate. This is a reciprocity vote. It allows me to carry my weapon, as I've carried for the last 50 years, from one state to another as long as I have a permit, and they do also. But more than that, I'm a little bit resentful when I hear on the floor that this is the will of the NRA. Now, I'm proud to have been a member of the NRA, lifetime member since I could vote. I am a member today. I participate in their board meetings, and I'm proud of that organization. It's probably one of the leading organizations. But cast that in the form of they are not the people of America is wrong. The greatest strength the NRA has is its members. They talk about how strong they are as a lobbying group. The lobbying group is the citizen that wants to carry his arm as permitted across state lands as they do with a driver's license. This is a good piece of legislation. I'm glad we're having this discussion. There can be differences of opinion. But don't take the right for myself to go from Alaska with my permit and go into the other 38 states to have, or I believe it's 30 or 48 states that have permits, and I can't use my permit. That's wrong. Let's vote for this legislation. I thank the gentleman.
The gentleman from Texas has 3 1/4 minutes remaining.
Mr. Chairman, I'll yield 1 minute to the gentlewoman from Florida, Ms. Adams, who is also a member of the Judiciary Committee.
Gentlewoman is recognized for 1 minute.
Thank you, Mr. Chairman. I rise in support of 822. As a former law enforcement officer and a state representative, I've dealt with issues relating to our Second Amendment rights. It's interesting when I hear some of the blurring between gun purchasing and a concealed carry permit. I have done both. And as a law enforcement officer, I would like to know if someone would tell me, hey, I have a concealed carry permit and I have a weapon, rather than finding it either by accident or having it pointed at me. So I stand in great support of this piece of legislation. I do believe that it is good legislation. It will not harm the people, as I've heard here on the floor. And I've heard that we aren't working on jobs. Well, I beg to differ that issue, because we have passed over 20 bills sitting in the Senate that have not been heard that would relate to jobs. So yes, we are working on jobs and the economy, and we also are working on other issues that are brought to us from our constituents. And I stand in great support of 822. Thank you. I yield back.
Gentleman from Texas.
Mr. Chairman, I yield myself the balance of my time.
Gentleman is recognized for 2 and 1/4 minutes.
H.R. 822 is important legislation that recognizes that Americans' ability to exercise their fundamental constitutional rights should not disappear at their state's border. The parade of horribles that have been alleged by some of my colleagues on the other side of the aisle are simply not true. Federal law already prohibits felons, domestic abusers, and illegal drug users from possessing a firearm. This legislation does not change that. If a person is prohibited from possessing a firearm under federal law, they cannot carry a concealed weapon under this bill. The arguments we have heard so often today against this legislation are against guns in the hands of violent criminals, generally, not against legally permitted concealed weapons. Concealed carry laws have shown that concealed weapons actually lower violent crime rates in a jurisdiction. H.R. 822 simply permits law-abiding Americans to take their Second Amendment rights with them when they travel. I urge my colleagues to support this bipartisan piece of legislation, and I'll yield back the balance of my time.
All time for general debate has expired. Pursuant to the rule, the amendment in the nature of a substitute printed in the bill shall be considered as an original bill for the purpose of amendment under the 5-minute rule and shall be considered read. No amendment to the committee amendment in the nature of a substitute shall be in order except those printed in House Report 112-283. Each such amendment may be offered only in the order printed in the report by a member designated in the report, shall be considered read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to an amendment, and shall not be subject to a demand for a division of the question. It is now in order to consider amendment number 1 printed in House Report 112-283. For what purpose does the gentleman from Georgia seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 1, printed in House Report number 112-283, offered by Mr. Woodall of Georgia.
Pursuant to House Resolution 463, the gentleman from Georgia, Mr. Woodall, and a member opposed, each will control 5 minutes. The Chair recognizes the gentleman from Georgia.
I thank the Chairman. The amendment I've introduced today, because I have such appreciation for the goal of H.R. 822, says, understanding what we're trying to get is reciprocity across the nation for all of those states and for all of those citizens that have already labored in the vineyards to achieve reciprocity, let's leave those state agreements in place. If we must take more federal responsibility, let's not take it from those areas where the states are working, where the process is working. If you live in my next-door neighbor state in Alabama, you already recognize 22 other states' permits. In Georgia, we recognize 23. In Florida, to our south, 33. The system is working today. Legislatures are working out these agreements today. If we must expand the size and scope of the federal reach into gun law legislation, let's not trample on those agreements that already exist to achieve this goal that so many share. I absolutely support the goal of H.R. 822, which is to ensure that all Americans have concealed carry reciprocity across the nation. That is already happening today, Mr. Chairman, through state legislatures, through state attorney generals, through state governors negotiating these agreements. My amendment would leave those agreements in place and preserve the rights of states to continue to legislate and regulate in this area, and I reserve the balance of my time.
The gentleman reserves the balance of his time. For what purpose, the gentleman from Texas?
Mr. Chairman, I oppose the amendment.
The gentleman is recognized for 5 minutes.
Mr. Chairman, this amendment undercuts the uniform eligibility standard that forms the foundation of this legislation. The underlying bill allows individuals with valid state-issued permits to carry a concealed firearm in other states that also authorize concealed carry. This Second Amendment right to bear arms is therefore limited by this amendment. 49 states authorize concealed carry, and 40 of those states have reciprocity agreements with all or some of the other concealed carry states. But these agreements vary from state to state, creating a patchwork of laws that limits reciprocity, creates confusion for gun owners, and undermines the Second Amendment. The amendment offered by the gentleman from Georgia keeps this patchwork in place by exempting states with reciprocity agreements from the bill. The amendment prevents individuals from taking advantage of nationwide concealed carry reciprocity unless the state they reside in has a separate agreement with the state they wish to travel to. While I appreciate my colleague's dedication to the concept of states' rights, I think it is misapplied to this legislation. H.R. 822 upholds states' rights in several important ways. First, it does not apply to those jurisdictions that prohibit concealed carry, such as Illinois and the District of Columbia. Second, the bill does not affect a state's right to set eligibility requirements for its own residents. Third, H.R. 822 does not impact state laws governing how concealed firearms are possessed or carried within the various states. All state, federal, and local laws that prohibit, for example, carrying a concealed handgun in a public building or a place of worship apply equally to a non-resident concealed carry holder. And fourth, this legislation does not create any authority for the federal government to regulate concealed carry permits. No federal agency has any role in the implementation or oversight of this bill, which is left rightfully up to the states. But most importantly, this bill respects and protects an individual's right to bear arms while they are traveling. In two recent decisions, the U.S. Supreme Court affirmed that the Second Amendment endows individuals with the right to keep and bear arms. And this right is based in large part on the right to defend oneself. Americans don't need to simply defend themselves in their homes. They must also be able to defend themselves outside their homes and while traveling to other states. 80% of violent crime occurs outside the home, according to the Justice Department. Americans cannot fully be empowered to defend themselves if they are prevented from exercising all their Second Amendment rights. H.R. 822 advances the Second Amendment right to bear arms, and I believe that this amendment infringes upon that right. For these reasons, I oppose the amendment, and I'll reserve the balance of my time.
Reserves the balance of his time. Gentleman from Georgia.
Thank you, Mr. Chairman. I thank the chairman of the committee for his work on these issues. And I agree with so much of what he had to say. It is absolutely true that the merit of this legislation is that it eliminates the patchwork of reciprocity agreements that go on across this country. And the price we pay for eliminating that patchwork is trampling upon the work of the states. Now, I'm a freshman in this House, Mr. Chairman, and I think small government conservatives in previous Congresses have lost their way. Particularly during the Bush administration, they went along with a huge expansion of government regulation with the very best of intentions. They went along with a huge expansion of the size of government with the very best of intentions. They increased the regulatory burden of the federal government with the very best of intentions. And this bill today is brought with the very best of intentions. But when previous Congresses have gone along with the very best of intentions, personal freedom and liberty have been eroded, even with the very best of intentions. Mr. Speaker, the only thing that happens if the Woodall Amendment passes today is that agreements that already exist for reciprocity and any future agreements made for reciprocity will be held supreme over a unified federal standard. I ask my colleagues, my Republican colleagues and my Democratic colleagues, isn't it worth it? Isn't sacrificing a uniform framework worth it to protect the rights of state legislatures and the work of citizens across this country that they have put in to protect, preserve, and promote Second Amendment rights across this nation? And I yield back the balance of my time.
The gentleman yields back the balance of his time. Gentleman from Texas.
May I ask the chairman how much time I have remaining?
The gentleman has 2 minutes remaining.
Mr. Chairman, I'll yield 30 seconds to the gentleman from Georgia, Mr. Johnson.
Gentleman's recognized for 30 seconds.
Thank you, Mr. Chairman, for yielding the time. Mr. Speaker, I rise in support of Congressman Woodall's amendment. I would point out that currently states have the ability to enter into reciprocity agreements with other states. This legislation, should it pass, would take that ability away. It would mandate that there be this reciprocity agreement. And that's a usurpation of states' rights. I have no problem with the Second Amendment, by the way, and the NRA is a lobbying organization, which is quite powerful here in Washington, D.C. I'll say that. Thank you.
Gentleman from Texas.
Mr. Speaker, I yield myself the balance of my time.
Gentleman's recognized.
Mr. Speaker, the whole point of this bill is to allow those that have concealed carry permits to freely carry their weapons into other states that also have and recognize concealed carry permits. If we were to accept this amendment, we, in my judgment, would be infringing upon the Second Amendment. I feel that the Second Amendment should be enforced. We ought to interpret it broadly. We ought to allow individuals to take advantage of their Second Amendment rights, travel freely from one state to another without restrictions, except for the restrictions that are required locally by their state and local governments. I mentioned a while ago that one recognition of state prerogatives that we have in the bill is that, for example, if one state does not allow individuals with concealed carry permits to go into a public building or a sports event or some other type of location, they are not going to be allowed to do so even if they have a concealed carry permit from out of state. So once again, we need to respect the right that is given to us by the Second Amendment in a complete, full way. We need to allow individuals with concealed carry permits to travel freely from state to state. This underlying bill does that with one exception. The state of Illinois does not recognize concealed carry permits. You would not be able to carry a weapon into that state. But except for that one state, we need to embrace the Second Amendment in every way that we can practically, recognize the Supreme Court has done the same thing, allow individuals to travel with those concealed carry permits. I'll yield back to balance of my time.
Gentleman yields back to balance of his time. The question is on the amendment offered by the gentleman from Georgia. All those in favor say aye. Aye. All those opposed, no. Opinion of the Chair, the ayes have it.
Mr. Chairman, I'll ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Georgia will be postponed. It is now in order to consider Amendment Number 2, printed in House Report 112-283. For what purpose does the gentlewoman from New York rise?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment Number 2, printed in House Report Number 112-283, offered by Mrs. McCarthy of New York.
Pursuant to House Resolution 463, the gentlewoman from New York, Mrs. McCarthy, and a member opposed, each will control 5 minutes. The Chair recognizes the gentlewoman from New York.
Thank you, Mr. Chairman, and I would also like to thank my colleague from Michigan, Mr. Conyers, for working with me on this issue. I rise totally in opposition to H.R. 822. It saddens me, but it does not surprise me that we're here having this debate today. H.R. 822 is unnecessary and seriously flawed piece of legislation. This bill overrides the decisions and forces them to recognize concealed carry gun permits from every other state. Almost every state currently allows carry permits, but states differ substantially in regards to the permitting requirements. They have different minimum age requirements. Some states require safety training before receiving a permit, and some states bar people convicted of certain crimes. These different requirements have been put in place by the elected legislators of the states, who did so with an understanding of the specific needs of their communities. H.R. 822 erases all of that and creates an unworkable system. Under this bill, states with strong gun safety laws, such as New York, California, Massachusetts, would allow out-of-state visitors, potentially as young as 18, to walk down our streets armed and dangerous. There are states in our nation that don't require a background check before issuing a concealed carry permit. There are states in our nation that don't require any firearm training before letting people walk around with a concealed weapon. These are decisions that those states made for themselves. I don't want those decisions imposed upon the communities I represent, and neither should anybody else. Also, police officers would be faced with the task of attempting to determine the authority of permits from 48 other states on the fly, and certainly in tense situations. Simply put, this bill is anti-community, anti-safety, and anti-police. And finally, the bill attempts to solve a problem that simply does not exist. Many states have chosen to enter into these agreements with other states to honor each other's concealed carry permits. Nothing is stopping a state from recognizing a permit from any other state. The fact that states have not done so represents a deliberate choice to only enter into agreements with states that they feel have the proper approach to issuing concealed carry permits. The federal government should not be second-guessing the decision of the states in this matter. It saddens me but does not surprise me. They were here today discussing not how to make Americans safer and reduce gun violence, but instead we are talking about how to weaken our gun laws and considering a bill that takes local decisions out of the hands of the local officials. The gun manufacturing lobby will try to say otherwise, but I fully support the Constitution, as my colleague had mentioned before. I believe in the rights affordable to the Second Amendment, and I support law-abiding gun owners. It's the absence of a perfect nonviolent society, however, we must make laws to protect the public. I know this firsthand. After all, it was with a man with a concealed handgun that took the life of my husband and gravely wounded my son on the Long Island Railroad back in 1993. Now you may hear arguments today about interstate commerce as a justification for this bill, but this bill has nothing to do with interstate commerce. This bill is simply about the federal government overriding a state's laws about who can carry a concealed weapon. You may also hear comparisons to state-issued driver's license, again, which is recognized nationwide. But if we want to compare guns to cars, as the gun lobby often likes to do, let's have this conversation. Cars use are among the most heavily regulated consumer products and activities in the United States due to the safety risk they pose. One thing that does surprise me, though, is why so many of the supporters of this bill, who have been so vocal about defending state rights in the past, are now choosing, in this instance, to trample on state rights. Federalism dictates that some things should remain in the states and some things should be addressed at the national level. And going back to the matter of interstate commerce, I'm sure all Americans would love to see the House address interstate commerce in a more direct way, which is getting Americans back to work and growing the economy. We should be talking about how to create jobs and prepare the next generation to succeed in a global economy. Instead, we're talking about how to trample on states' rights, weaken gun laws, and make America less safe, all to please our country's powerful gun lobby. So I said, it saddens me, but it does not surprise me that we're having this debate today. I have an amendment under which states would be required to proactively opt in to the agreements called for by H.R. 822. The intent of this amendment is to require that states affirmatively pass legislation enacting the provisions of H.R. 822 before the bill can go into effect in that state. This would restore state rights, something I believe in, and I urge my colleagues to support this amendment and oppose H.R. 822.
Gentlelady's time has expired. Gentleman from Texas.
Mr. Chairman, I oppose the amendment.
Gentleman is recognized for 5 minutes.
Mr. Chairman, this amendment frustrates the basic purpose of H.R. 822. It requires that states pass legislation to implement the bill's provisions. The Supreme Court, in 2 recent cases, has recognized a fundamental individual right to bear arms that is largely based on the right to defend oneself and one's family. Over 80% of violent crime occurs outside of one's home, according to the Department of Justice. This means that for the right to bear arms in self-defense to have any meaning, law-abiding citizens with permits should be able to carry firearms outside of their homes and sometimes across state boundaries. Under current law, 40 states have established a patchwork of reciprocal agreements that can be confusing for concealed carry permit holders to navigate. H.R. 822 provides uniformity to our concealed carry laws by creating nationwide reciprocity for concealed carry permit holders. By contrast, this amendment allows states to opt out of H.R. 822's federal grant of reciprocity, and it provides that only states that choose to pass laws implementing the legislation must recognize out-of-state concealed carry permits. This amendment would, in effect, just continue the status quo, and so would be of no help to individuals with concealed carry permits. Since 2004, police officers have enjoyed the right to use a concealed carry permit to take a firearm across state lines.
Would the gentleman yield?
And I'd like to complete my statement, Mr. Chairman.
Gentleman from Texas controls the time.
Since 2004, police officers have enjoyed the right to use a concealed carry permit to take a firearm across state lines. And in 2010, President Obama signed legislation to include other law enforcement personnel who could take advantage of this ability. It is ironic that some of these groups now want to deny the same right to law-abiding citizens with concealed carry permits. According to a 2009 Zogby poll, 83% of those polled said they supported concealed carry laws. 83%. Over 4 million Americans across the country have qualified for concealed carry permit. They most likely endorse this legislation. I appreciate the gentlewoman from New York mentioning states' prerogatives, and I hope she will express the same sentiments about other pieces of legislation. H.R. 822 retains the state's ability to regulate firearms in their own states by making clear that all state regulations regarding how a firearm is carried continue to apply to both residents and non-residents, and by keeping in place the state's own permitting process. I urge my colleagues to join me in opposing this amendment, and I'll yield back the balance of my time.
Gentleman yields back the balance of his time. Question is on the amendment offered by the gentlewoman from New York. Those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the noes have it.
And I'd like recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on this amendment offered by the gentleman from New York will be postponed. It is now in order to consider Amendment Number 3 printed in House Report 112-283. For what purpose does the gentleman from Florida rise?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 3, printed in House Report number 112-283, offered by Mr. Hastings of Florida.
Pursuant to House Resolution 463, the gentleman from Florida, Mr. Hastings, and a member opposed, each will control 5 minutes. Chair recognizes the gentleman from Florida.
Thank you, Mr. Chairman. My amendment would exempt states from right to carry reciprocity when the state does not require individuals to apply for and complete a carry permit application at their local law enforcement station. The United States Congress should never be in the business of stripping states of the right to make their own decisions about whether to recognize other states' permits. States have put forward a considerable amount of time trying to determine just what is best for their citizenry in reference to safety. By overriding state-based concealed carry laws and forcing states to recognize concealed carry permits from every other state, we are putting our state and local law enforcement in grave danger. 2 nights ago, with the sheriff in my county, we discussed this matter. I might add a Republican sheriff who is a friend of mine. We discussed this matter, and we concluded that it's going to be very difficult to get people to want to become police officers. Not only are they being attacked in reference to their organizing efforts, but now we're going to make it difficult for them to do their jobs. This amendment closes that loophole that would otherwise be created by H.R. 822. Almost every state allows concealed carry in some form, but states differ in how they implement their concealed carry policies, including having, as has been mentioned, different age requirements, training requirements, and excluding individuals guilty of certain crimes. One of these major discrepancies is addressed in this amendment and will force a state wishing to enforce H.R. 822's state reciprocity requirement to make certain carry permit applications or make sure that they are completed at an individual's local law enforcement station. In my home state of Florida, concealed carry permits may be granted to non-residents, and all applicants are allowed to apply by mail. It is so easy that a staffer in one of our offices was able to complete the form in less than 30 minutes. If H.R. 822 passes, residents and non-residents of Florida would be able to apply by mail from almost anywhere in the country and use their concealed carry permits throughout the country. Mr. Speaker,
Gun violence continues to grow at astounding levels in the United States. When the Surgeon General was Mr. Hatcher, he called it an epidemic and even said that it was a health crisis. So many people were killing each other with weapons. I certainly will.
I thank the gentleman for his amendment. I rise in support of it and observe that last year 70%, over 70% of Utah's concealed carry permits were issued to non-residents. And so I ask unanimous consent to add my statement to the record, and I commend the gentleman.
Thank you so much. And the last
Gentleman's
thing
statement will be covered under general leave.
Excuse me?
Gentleman's statement will be covered under general leave.
Thank you, Mr. Chairman. Mr. Chairman, the last thing we need is to tell sovereign states that they are no longer free to make the decision to require an in-person interview when making a gun permit determination. At least 10 states grant law enforcement broad discretion to deny permits to carry concealed loaded guns based on an applicant's record or other factors. 14 other states grant law enforcement more limited discretion. In addition, at least 14 states require applicants to show good moral character. Many of these states require applicants to present themselves in person for interviews. For example, applicants in New York must complete an in-person interview to receive their carry permit. By contrast, Utah applicants, as has been pointed out by the ranking member, can submit their application by mail and can complete the fingerprinting and firearm safety training requirements outside of the state. In comparison, Utah's driver's license application specifically requires, and rightly so, that applicants submit the application in person, that it be notarized, and that the employee initial the application upon submission. Utah also grants permits to non-residents, potentially allowing individuals nationwide to apply for permit by mail. Supporters of H.R. 822 claim that concealed carry permits should be treated like driver's licenses. My amendment, however, points out that this is yet another instance of my friend's hypocrisy. The rest of my statement will be included, and I thank the chairman for the term.
For what purpose, gentleman from Ohio rise?
Mr. Chairman, I rise in opposition to the amendment.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment would effectively gut the bill, though the intent is actually somewhat unclear. As written, the amendment allows a visitor to carry a handgun under the provisions of the bill only in states that require applications to be completed and submitted in person. However, few states have such a requirement for non-residents. This amendment would create unnecessary confusion. For example, Florida accepts applications by mail, but the state of Washington does not. If this amendment were adopted, a Virginia resident who held a valid permit could carry a handgun in Washington, which requires everyone to apply in person, but not in Florida, which has no concerns about issuing permits by mail. It is possible that the amendment was intended to allow interstate carry under the bill's provisions only for holders of permits that were issued in person. The problem is that isn't how the amendment is drafted. If it were, it would still effectively gut the bill because so few states require in-person application. The fact is that any application or fingerprinting requirements for a resident or a non-resident to obtain a concealed carry permit are in addition to all the other requirements, including a national instant background check that the applicant must go through first to legally purchase the gun. Despite what some opponents of H.R. 822 would have you believe, not everyone who owns a gun is a criminal. And in fact, there is overwhelming evidence to show that concealed carry laws have resulted in lower crime rates in most states. Typically, most criminals don't bother with legally purchasing a gun and then making sure they have a valid permit before they carry it concealed. They just do it. That's why we call them criminals. I urge my colleagues to oppose this amendment, and I reserve the balance of my time.
Gentleman from Florida's time has expired. Gentleman from Florida's time has expired.
Out of time. Would the gentleman? Okay, we'll yield back our time.
Yields back the balance of his time. The question on the amendment offered by the gentleman from Florida. All those in favor say aye. Aye. All those opposed, no. Opinion of the chair, the ayes have it.
Chairman, we'd like to vote on that.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Florida will be postponed. It is now in order to consider Amendment Number 4, printed in House Report 112-283. For what purpose does the gentlewoman from Texas rise? Clerk will designate the amendment.
Amendment Number 4, printed in House Report Number 112-283, offered by Ms. Jackson Lee of Texas.
Pursuant to House Resolution 463, the gentlewoman from Texas, Ms. Jackson Lee, and a member opposed, each will control 5 minutes. The chair recognizes the gentlewoman from Texas.
Mr. Chairman, I am hoping that there will be no member that will oppose a common-sense amendment that allows our law enforcement officers to be more protected. One might think, as I point to this picture of a nurse giving a young man an immunization shot and the young man squinting, that I would be more in tune with this legislation to have a law enforcement officer or a policeman dressed in their uniform. I put a child here because I wanted to emphasize the fact that can we have any disagreement that if we put our law enforcement officers in jeopardy, many of them leave behind families. Or I might use as an example, this young child is squinting in pain for immunization. That won't harm them. But a person recklessly having stolen maybe someone's gun that comes with the national concealed law, the right to carry law, may not have a squinting child but rather a dead child. Let me give you an example of the legislation or the amendment that I have in real time. A North Harris police officer in 2008 had a traffic stop. Before he bothered or before he went to this individual that he was stopping, he dutifully went to the dispatcher, a database, to find out who this might be. Tragically, it was not soon enough because a gun was taken and he was shot dead. He leaves behind a wife and 2 children, albeit the fact that I have a child here, because I'm simply trying to create a simple amendment to this bill that would protect our law enforcement. What does my amendment do? It ensures that a comprehensive database is created to provide a listing of individuals from each state who possess permits and licenses to carry concealed weapons. This amendment would also require that the concealed weapons database be available to law enforcement officers in all states 24 hours a day. Thank goodness, because of federal funding, many of our law enforcement officers have their laptops, maybe some of them even their iPads, and so this database is a simple process. It is interesting, or it should be known, that 36 states are especially adversely impacted by this bill because 36 states do not grant any reciprocity. 27 states recognize concealed carry permits from only select states. So a 24-hour database, I believe, would do what Republicans and Democrats say they want to do, protect law enforcement officers. Failing to implement a national system that would allow law enforcement officials to check the status of individuals who are legally allowed to carry a concealed gun will result in a routine situation, such as a traffic stop, becoming a life-threatening situation. If an officer discovered a gun during a routine traffic stop, the officer might quickly and accurately determine this guy is legal as to whether the driver or lady possesses a valid out-of-state permit. Oh, yes, we can offer reciprocity, but does the officer on the street walk around and look at the car that's coming across the border of their state and the sign says, "We have reciprocity, I am from such and such, I'm okay"? It is nearly impossible task for the officer to verify the validity of 48 different carry permits. Are we going to have a national carry permit in the middle of what could be a tense situation, even if that person is legally carrying it based upon the permit from another state? According to the majority's report on this bill, only 18 states maintain an electronic database of concealed carry permits that are immediately accessible to other law enforcement agencies. 7 states cannot provide any real-time access to this basic information to out-of-state agencies, and 2 states do not even maintain a database for their own purposes. This amendment gives our local law enforcement a plausible chance to verify whether out-of-state concealed carry permits are legitimate. I'd love to offer a moment to my ranking member on this amendment. How much time do I have?
The gentlelady for...
Gentlelady has 1 minute remaining.
for yielding, and I am in full support of the logical and rational approach that she is taking in supporting a database. I plead with my colleagues to join us in a bipartisan sense to support an amendment that would create a comprehensive mechanism so that all permits and licenses for carrying concealed weapons would be available on a 24-hour-a-day basis. And I congratulate the lady on her amendment.
I thank the gentleman for his kindness. Who can oppose such a simple amendment, particularly when it is noted that some states do not have this electronic database? The officer who went to his dispatcher was doing the right thing. He lost his life. He left behind children. Do we want squinting children getting an immunization shot or getting shot? I ask my colleagues to support this amendment.
What purpose?
I yield back.
Gentleman from South Carolina rise.
Mr. Chairman, I rise in opposition to the amendment.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment seeks to require states to maintain a database of all concealed carry permits that would be accessible to law enforcement officers 24 hours a day. This amendment, aside from being a version of NCIC for law-abiding citizens, is unnecessary for a number of reasons. The state issuing authority already maintains a database of concealed carry permits, and a number of states make these databases accessible to law enforcement through the inlet system, which law enforcement in all 50 states can use to determine whether someone visiting from another state is carrying a valid concealed permit. This system is available to law enforcement officers 24 hours a day, 7 days a week. Law enforcement officers can also contact other states to determine whether a person has a criminal background, a warrant out for their arrest, or other information that will help determine whether someone poses a safety threat to themselves or the general public. But the fundamental flaw of this amendment is that it continues to place conditions and restraints on law-abiding citizens, all the while ignoring the obvious, which is that people intent on doing harm do not register their firearms, nor call ahead to report their travel schedule. No database has yet been created which can determine whether a person with a firearm intends to use it in a criminal matter, whether the firearm is carried illegally or not. So officers are trained to be careful in every situation and have the authority to take necessary precautions to ensure the safety of those on the scene of an investigative stop. This amendment, as is true with many other amendments that we have and will consider today, is premised on the flawed view that concealed carry permit holders pose a threat to public safety. People intent on committing illegal acts will not go to the trouble of obtaining a concealed carry permit, and statistics back that up. I oppose the amendment, Mr. Chairman, and I yield back.
The gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Texas. Those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. Gentleman from, pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentlewoman from Texas will be postponed. The chair understands that amendment number 5 will not be offered. It is now in order to consider amendment number 6, printed in House Report 112-283. For what purpose does the gentleman from Georgia rise? Clerk will designate the amendment.
Amendment number 6, printed in House Report number 112-283, offered by Mr. Johnson of Georgia.
Pursuant to House Resolution 463, the gentleman from Georgia, Mr. Johnson. Any member opposed, each will control 5 minutes. The chair recognizes the gentleman from Georgia.
Thank you, Mr. Speaker. I rise in support of my amendment to this dangerous bill, the National Right to Carry Reciprocity Act. My amendment is about protecting a state's right to decide who may carry a concealed loaded handgun within its borders. It would require the possession of or carrying of a concealed handgun in a state be subject to that state's law regarding firearm safety training, including live fire exercise. Currently, at least 34 states require applicants to complete a firearm safety training course or present proof of equivalent experience in order to obtain a concealed carry permit. 19 states require live fire instruction to obtain a carry permit. However, some states only require minimal training, such as an internet-only instruction. Even worse, however, are the states that do not require any firearm training to obtain a concealed carry permit. This bill would override state laws and require states to allow out-of-state residents to carry loaded concealed weapons in public, even if they have not met basic licensing or training requirements mandated for carrying in that state. This does not make any sense. By federally mandating recognition of all out-of-state concealed handgun permits, H.R. 822 would allow individuals who do not meet a state's live firearm training standards to carry concealed weapons within their borders and prohibit states from ever restricting carrying by those individuals. According to the Violence Policy Center, since May 2007, at least 385 people, including law enforcement officers, have been killed by individuals with concealed carry permits. None of these incidents involved self-defense. Some of these incidents included mass shootings, the most recent occurring in July at a child's birthday party at a Texas roller rink, claiming the lives of 89 innocent victims. This illustrates why states should have the right to determine who is eligible to carry firearms within their borders. They know what is best for their communities. This bill is all about the National Rifle Association and its needs, not about the American people and putting them back to work. Congress should not put its stamp of approval on this dangerous and misguided legislation. States that require a person to demonstrate that they know how to use a firearm or meet minimum training standards before obtaining a concealed carry permit should not be forced to allow out-of-state visitors to carry concealed weapons if they do not meet that state's concealed licensing requirements, especially if a state requires that individuals undergo live fire training to ensure they know how to properly operate a firearm. This is common sense. This is a common sense amendment, and it will keep Americans safe. It simply would require the possession or carrying of a concealed handgun in a state be subject to that state's law regarding firearm safety training, including live fire exercises. I urge my colleagues to support this amendment and oppose the underlying bill. Thank you, and I'll reserve the balance of my time.
Gentleman reserves the balance of his time. For what purpose? Gentleman from Texas rise.
Mr. Chairman, I oppose the amendment.
Gentleman's recognized for 5 minutes.
Mr. Chairman, this amendment allows states to prohibit non-residents from carrying a concealed firearm if they did not take part in a firearm safety class that included a live fire exercise as part of the permitting process. This amendment would, for the first time ever, insert the federal government into the state's concealed carry permitting process. H.R. 822, by contrast, protects each state's ability to set its own eligibility requirements for concealed carry permits. 37 states require some degree of firearms training. The gentleman from Georgia's home state, interestingly, does not require any training, and thus, under this amendment, its citizens would not be able to enjoy the federal grant of reciprocity provided by H.R. 822. The states carry out their training requirements in a number of ways. Some states allow applicants to certify their proficiency through classroom training, while other states recognize prior military or police service to meet these requirements. Virginia, for example, provides 8 different ways to meet the training requirements. This amendment is silent on a number of important issues. Is prior military or law enforcement service sufficient to meet the live fire requirement? Does an applicant need to go through this training each time they renew their permit, or is it sufficient to have completed a course the first time they applied? These ambiguities give us more reason to oppose this amendment. We know that concealed carry laws do reduce crime. A study by John Lott and David Mustard found that when concealed carry laws went into effect, murders fell by over 7%, and rapes and aggravated assaults fell by 5% and 7% respectively. These findings have been confirmed by 18 other studies, but none have found that concealed carry increases crime. The benefit of concealed carry laws should not be measured only by the instances of self-defense, but also by the number of crimes that are prevented from occurring in the first place. I urge my colleagues to oppose this amendment, and I'll reserve the balance of my time.
The gentleman reserves the balance of his time. The gentleman from Georgia has 1 minute remaining.
Thank you, Mr. Speaker. I agree wholeheartedly with my colleague from Texas, Chairman Smith. This legislation does in fact insert the federal government into state licensing of firearms, and it does it in a big way. It actually eviscerates the state's ability to regulate how or the qualifications for applicants to be able to receive a concealed carry permit. As I stated earlier, 34 states require applicants to complete a firearm safety training course. Unfortunately, Georgia does not, but that does not mean that that is right or proper. I believe that other states can certainly have a more conscientious approach to gun licensing, and certainly states have had a right to do that, and I want to preserve that right. And so with that, I'll yield back the balance of my time.
Gentleman's time has expired. Gentleman from Texas.
Mr. Chairman, I'll yield myself the balance of my time.
Gentleman's recognized for
Mr. Chairman,
3 minutes.
Mr. Chairman, I am glad that the gentleman from Georgia agrees with me that this amendment does insert the federal government into the state's concealed carry permitting process. And I would simply say that that admission and the fact that that is the case is enough reason to oppose this amendment. And I'll yield back the balance of my time.
Gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Georgia. All those in favor say aye. Those opposed, no. Opinion of the Chair, the ayes have it.
Chairman, I request a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Georgia will be postponed. For what purpose? Oh, it is now in order to consider amendment number 7 printed in House Report 112-283. For what purpose does the gentleman from Tennessee seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 7, printed in House Report number 112-283, offered by Mr. Cohn of Tennessee.
Pursuant to House Resolution 463, the gentleman from Tennessee, Mr. Cohen, and member opposed, each will control 5 minutes. The Chair recognizes the gentleman from Tennessee.
Thank you, Mr. Chairman. Before I came to Congress, I was a member of the Tennessee Senate for probably an inordinate amount of years before I graduated to this august body. It took me 24 years to matriculate. But during those 24 years, I worked on much important legislation that helped the people of Tennessee. And one of the things I helped the people in Tennessee with is I wrote the Right to Carry bill in Tennessee. The fact is, this was a difficult bill to pass. It was a difficult bill to craft. There were people with different opinions of what should be in the bill. And we debated it, and we went back and forth on what should be in it. It took votes, and certain things passed and certain failed, and we came up with a bill that we thought was a good bill. I always felt that people who could take a gun and have enough vision and calmness of hand and hit a target at some pace, not have a criminal record, and pass a written test of limited challenge should have a right to carry a gun. And in fact, in Tennessee, very few people with the right to carry a gun have committed crimes and used their guns improperly. But the fact is, we worked on this law and we had certain restrictions, and one of the restrictions is you had to be 21 years of age. 21 years of age, the same age that you have to buy a beer or to drink. And 36 other states came to that same decision, that you should be 21 before you can get a permit to carry a gun. 8 states have differed. 8 states: Alabama, Delaware, Indiana, Iowa, Maine, Montana, New Hampshire, and South Dakota. So you've got a southern state in there, you've got an eastern state, a couple of Big Tens, a couple out in the Big Sky world, and some in the east. And they decided you only be 18, those 8 states. This bill, if passed, would tell the citizens in those 37 states and the legislators in those 37 states that argued and determined that 21 was the right age, that it would be the right age in your state for the people who are residents of your state, but if somebody from one of those other 8 states came into your state and was less than 21, they could carry a gun when your citizens couldn't. Because their state decided 18 was sufficient, your laws made no difference. And you'd have teenagers carrying guns in states that had determined that it was not the appropriate age. 21's the right age to drink, and I'm not submitting it should be less at this time. But the fact is that a brain doesn't really develop to a certain extent until you're out of your teens, and that's why much of the crime and the violent crime is committed by people 18 to 20. They are only 5% of the population, but 20% of the homicides and violent crime are committed by people from 18 to 20. And if you pass this bill, you'll have people 18 to 20 going into states and having a right to carry a gun when the citizens of that state won't have it. That makes no sense. In 2007, the most recent year in which we have data, there were 13,000 people who lost their lives in this country to accidents involving alcohol. But there were 31,000 people, over twice as many, who lost their lives because of gunfire. It doesn't make sense that we would not only trample on the laws of the different states and the works of the legislature, such as me, who worked hard within the legislative bodies, within the give and take of Senate and House and conference committees to come up with what we thought was the policy of our state, to have that overridden by the folks here in this United States House of Representatives, the Senate would be concurring, to pass a bill to say your laws make no difference and 18 and 19 and 20-year-olds from Alabama and South Dakota and Maine and New Hampshire are going to be able to come in your state and carry a gun when your citizens won't be able to. It should be up to each of the states to decide that. And what we're getting to is the lowest common denominator, which isn't right. So the fact is, these laws should be left up to the states. The states right now can have reciprocity agreements. Tennessee didn't have one when we passed our bill in 1996, but in 2003 they got one. But the state of Tennessee decided on its reciprocity, not the United States Congress. And states have reciprocity agreements, and they're all going to be overridden. Some are more liberal than others. Tennessee is the most liberal, but other states have got restrictions. They're all going to be set aside because of this. I would hope that the members who come from the 37 states that require your citizens to be 21 would not allow people under 21 to come into your state and have teenagers who are most likely to commit crimes with guns to come into your state with a concealed carry permit. I'd yield to the distinguished gentleman from Michigan.
Thank you. Your experience in your state legislature and your legal experience really have impressed me that your amendment, and we haven't talked about this today on 822, is extremely important. I hope my colleagues will join with you, and I'm going to, at the proper time, introduce my statement into the record.
Thank you, sir. Has my time expired?
Gentleman's time has expired.
Then I yield back to the remainder of my time.
For what purpose, the gentleman from North Carolina rise?
I am opposed to the amendment. I rise in opposition.
South Carolina. South Carolina. The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm opposed to this amendment. This amendment prohibits persons who are legally permitted to carry a concealed weapon between the age of 18 and 21 from taking advantage of H.R. 822's grant of reciprocity. We continue to believe, Mr. Chairman, that adults who reach the age of 18, which is the age of majority for well-nigh everything in this country, save alcohol, are capable of being responsible just as 19-year-olds and 20-year-olds are. They can vote, and more importantly, they can serve in the military, where they are highly trained to handle firearms in very critical situations. Fewer than 10 states allow people under 21 to receive a concealed carry permit. One state allows this if the weapon is necessary for a person's job, such as law enforcement, and another if the person gets permission from law enforcement. This amendment eliminates the current practice of many states, including the amendment-sponsored home state of Tennessee, of recognizing concealed carry permits of non-residents between the ages of 18 and 21, even though their own residents must be 21 to conceal carry. In fact, 14 states recognize all valid permits issued by any states, including those states that permit persons between the ages of 18 and 21. As many as 10 additional states recognize 18-year-old permit holders from other states with which they have reciprocity. Mr. Chairman, America trusts our brave men and women under the age of 21 to volunteer for duty and to defend our country. What this amendment says, however, is you can carry a gun and defend this country overseas, but you can't carry a gun and defend yourself once you get back. This is not consistent with the Second Amendment, nor is it reflective of our views with respect to what 18-year-olds can and should be permitted to do. What is good enough to defend the foundations of this republic, and us, I hasten to add, should be sufficient to defend
Would the gentleman
oneself.
from South Carolina yield? Would the gentleman yield for question?
Be happy to yield to the gentleman from Tennessee.
Thank you, sir. Based on your argument, and you would think that the state that the laws that the 37 states have that limit gun owner permits to people that are 21 should be abolished. Why does your legislation not go further and trample on the states' rights and say that you can only have a limitation of age 18 and say that you cannot have a limitation of age 21?
The only thing that this debate today has given me cause for celebration for is I now know my colleagues on the other side of the aisle are familiar with the concept of states' rights, because I have not heard them talk about it for the first 11 months. Do you suppose Tennessee should have a different version of the First Amendment, or the Fourth Amendment, or the Fifth Amendment, or the Eighth Amendment? So why are we treating the Second Amendment like it is in the constitutional trash heap?
No, what I'm saying to you, sir, is that your belief is obviously that the Second Amendment is an individual right, so that the states that have laws that say you have to be 21, those laws should be abolished, and we should limit it to 18. For the record, I have talked about states' rights on medical tort liability, and I've talked about states' rights on medical marijuana, and I've found nobody on the other side of the...
Reclaiming my time, the gentleman from Tennessee is right. He has from time to time mentioned states' rights, which puts him in a very lonely position on his side of the aisle. And with that, I would yield back.
The gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Tennessee. Those in favor say aye. Those opposed, no. Opinion of the Chair, the noes have it.
Roll call, sir. Please, thank
Pursuant
you.
to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Tennessee will be postponed. It is now in order to consider Amendment Number 8, printed in House Report 112-283. For what purpose does the gentleman from Texas rise? Clerk will designate the amendment.
Amendment Number 8, printed in House Report Number 112-283, offered by Ms. Jackson Lee of Texas.
Pursuant to House Resolution 463, the gentlewoman from Texas, Ms. Jackson Lee, and a member opposed, each will control 5 minutes. The Chair recognizes the gentlewoman from Texas.
Mr. Chairman, I thank you for your courtesies, and I am delighted to have seen my good friend engage in a dialogue and colloquy with my friend from Tennessee, and maybe I might even get the same courtesies, because this is a very important issue that also deals with constitutional questions, and I'm back with my young man and getting his immunization shot with a nurse looking over him, because I want people to know that this is about family. It's about the fact as to whether or not we make a statement on behalf of protecting law enforcement, protecting our families, and not fall upon the spear of the Second Amendment and the National Rifle Association. To my ranking member and dear friend, even the super committee is not without ghosts riding through. I understand they had a deal, and then Mr. Norquist comes riding through. Whenever we want to talk about getting together on the NRA, getting together on guns and the Second Amendment, the NRA comes riding through. So we've got the NRA, we've got Mr. Norquist, and we can't ever get any bipartisanship because the ghosts keep riding through. But my amendment is a very simple one, and it speaks to, again, protecting the lives of our officers. And what it says is to the state, having the state have a designated entity, a designated agency that requires an individual coming into another state with a concealed carry permit must provide at least 24 hours advance notice to law enforcement agencies of their intention to carry or possess a concealed handgun in another state. States must retain their ability to know which individuals are allowed under this newly proposed bill to possess and carry a concealed weapon. Now, my friend engaged with me a dialogue, a gentleman, I believe, from South Carolina engaged with me, or did not engage in a discussion. But just imagine a trooper with a traffic stop on, say, for example, I-45, that's in the state of Texas. It could be I-95 in Maryland. At 3 a.m., the car has a Colorado license plate. The driver supplies a Colorado driver's license. The state trooper goes back to his car. He can instantly validate this person is from Colorado with respect to their license plate and their license. Upon returning to the car, the trooper notices that the driver has a concealed weapon on his hip. The driver hands over his Colorado concealed carry permit. The trooper has no ability to determine the validity of that permit. Therefore, if that person had been required to notify a state agency in Texas or in Maryland, that might be readily accessible. I heard a comment about the inlet process. You can go to the inlet. Only 12 states have allowed electronic access to their concealed carry database known as inlet. It does not respond, in essence, to the other 38 states. My friends, we are recklessly passing a bill that we think is sorely needed. It does not in any way have anything to do with jobs. It doesn't have anything to protect innocent children. It has nothing to do with making sure our law enforcement are safe. But I'm simply adding an amendment that would make it better. Let's know when you're coming into our state. Let's let our law enforcement know. Let's provide safety to the American people. I reserve my balance of my time.
Gentleman reserves the balance of her time. For what purpose the gentleman from South Carolina rises?
Mr. Chairman, I rise in opposition to the amendment.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment is based on the premise that any person who possesses a gun, including an American who legally purchases a gun and obtains a concealed carry permit, is a criminal and must seek permission to exercise his or her constitutional rights. It would be nice, indeed, Mr. Chairman, if we could get those who harbor criminal intentions to call ahead of time and inform local law enforcement of their plans. It would, in fact, Mr. Chairman, be ideal if they would let us know which store they were going to rob, which home they were going to invade, which car they intended to steal. That typically doesn't happen, Mr. Chairman. To require law-abiding citizens to have to call ahead is mind-boggling. Do we have to call ahead when we plan to assert our First Amendment rights? Do we have to call ahead and inform states we're traveling through of our intention to rely upon our Fourth Amendment rights? What about Miranda? Do we call ahead and reserve our Miranda reservations? Do we need to tell them which road we'll be traveling on, Mr. Chairman? And who do they call and what do they tell them when they call? Do they describe the gun? Do they tell them what caliber? And what is law enforcement supposed to do with this information? Does anyone really think criminals ever call ahead and announce their intentions? And what happens if a person fails to provide notice, Mr. Chairman? What is the designated law enforcement agency expected to do with this information? Maintain a database of all entering non-residents? Track the person's movement inside the state? Should a non-resident with a concealed carry permit engage in criminal activity in the state, is the state then liable for not preventing it? Would a person who lives in Maryland but works in Virginia be required to call every day, Mr. Chairman? And what if it's an emergency trip, the birth of a grandchild, a sickness in the family? Do we just postpone our trip so we can meet the requirements of this amendment? Or do we sacrifice our right to travel in self-defense because we didn't call quick enough? This is a practical nightmare. It's a constitutional abomination. I urge my colleagues to oppose it, and I yield to my friend in law enforcement, the gentlelady from Florida, Ms. Adams.
Gentlelady is recognized.
Reserving time.
I yield back.
Gentleman yields back the balance of his time. Gentlelady from Texas has 1.5 minutes remaining.
I'm so glad my dear friend rose to speak to the new phenomenon of apples and oranges. My friends, I am not coddling criminals. We know this is a distinctive bill that is not addressing the question of criminals who come to do us harm. What we are suggesting that guns kill, and we are suggesting that people use guns to kill. And on that lonely dark road at 3 a.m., when that trooper identifies your driver's license but can't identify whether or not you have a legitimate concealed weapons permit to carry, then we are asking for you to have help. We're asking for there to be 24-hour notification. I'm sure there will be the possibility of waivers, but don't tell me that a law enforcement entity, once known that they can go to the documentation that has the notification that someone is coming in from another state with a concealed weapon, it will not be useful. In fact, it will help It will help this law enforcement officer tell this individual carrying legally, on your way, sir, on your way, ma'am, thank you. Or in essence, we might catch someone who has a concealed weapon and a permit from another state, but they are rushing across the state to get a wife or a husband that they're in a violent domestic abuse or a domestic violent altercation. And so let me just say, for all of the laughers, guns kill. And it is a shame that we allow the ghost of the NRA to ride into this place and just smack down common sense. Save the lives of children, because guns kill. Save the lives of law enforcement officers who leave behind children, because guns kill. And don't fool around with the inlet process that doesn't even work. Let's notify. Let's notify. I ask
all
for,
those in favor say aye.
I ask for the
all those
support of my
opposed,
amendment.
no. Okay, and Chair, the noes have it. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentlewoman from Texas will be postponed. It is now in order to consider Amendment Number 9, printed in House Report 112-283. For what purpose does the gentleman from Rhode Island seek recognition? Clerk will designate the amendment.
Amendment Number 9, printed in House Report Number 112-283, offered by Mr. Cicilline of Rhode Island.
Pursuant to House Resolution 463, the gentleman from Rhode Island, Mr. Cicilline, and a member opposed, each will control 5 minutes. The Chair recognizes the gentleman from Rhode Island.
As a founding member of the bipartisan Mayors Against Illegal Guns, co-chaired by Mayor Menino of Boston and Mayor Bloomberg of New York, I rise today in strong opposition to the National Right to Carry Reciprocity Act. This dangerous legislation threatens public safety by undermining the ability of states and localities to reduce gun violence by limiting the carrying of loaded, concealed weapons within their borders. This bill has nothing to do with honoring the Second Amendment, but instead completely dishonors the rights of local communities and state governments to make decisions to protect the well-being and safety of their citizens. This bill prevents states from responding to the unique needs of their communities as they determine the eligibility criteria for carrying a loaded, concealed weapon, and instead forces them to accept standards set in other states. As a result, this bill strips away reasonable limitations properly enacted by states and imposes upon every state except Illinois the least restrictive standard in the country for carrying a concealed loaded gun. The implications of this bill are drastic and a radical departure from well-settled practice and law that assigns primary responsibility for public safety to states and localities. In Rhode Island and in many states like it, this bill would decimate the strong concealed carry framework developed by duly elected officials within the state. These officials enacted requirements that they believe most effectively prevent dangerous individuals from carrying a concealed firearm within their borders. Rhode Island does not have any reciprocity agreements recognizing any other state permits, and our heightened standards require applicants to be at least 21 years old, of good character, not an abuser of alcohol, to complete a firearms safety training course that includes live fire examination, and to show good cause for needing a concealed carry permit. To further provide for our unique public safety needs, Rhode Island also grants broad discretion to local law enforcement officials in the process of approving or denying a concealed carry permit. As a result, Rhode Island ranks among the states with the lowest gun death rates, less than half the national average. Under this bill, Rhode Island would be forced to recognize concealed carry permits from all states, regardless of how lax the other states' standards. This would leave my fellow Rhode Islanders subject to the whims of other states' concealed carry permits, and actually prioritize the rights of out-of-state concealed carry permit holders over the rights of Rhode Islanders within our own borders. For example, while Rhode Island requires safety training that includes a live fire exam in order to acquire a concealed carry permit, there are 10 states that have no training requirements whatsoever. While Rhode Island prevents alcohol abusers from obtaining these permits, only 28 states have such a standard in place. The common sense provisions of Rhode Island state law and the laws of similarly situated states prevent dangerous individuals from carrying loaded, concealed weapons. Such protections would be completely undermined by this law. This bill is a clear and undeniable threat to public safety and will facilitate a new path that allows more and potentially dangerous individuals to carry concealed loaded guns within our borders and against our will. This must not be allowed. Because this bill presents such an indisputable threat to public safety in many states, I've introduced this amendment, which would require that at the very least, prior to granting reciprocity in a state, the Attorney General, the head of the state police, and the Secretary of State jointly certify that the laws of a non-resident permit holder state are substantially similar to its own. This would provide states an opportunity to preserve adherence to its core requirements that restrict concealed carrying weapons, but not allow them to deny permits from states that match its standards. It would at a minimum ensure that we respect the decisions and judgments made by local and state governments on this key public safety issue. The certification process will not be burdensome to states. In fact, some states, including South Dakota and Nebraska, already incorporate this type of process in determining eligibility for engaging in reciprocity agreements with other states. I urge my colleagues to support my amendment and protect the citizens of this country from the imposition of dangerously lax standards for the carrying of concealed weapons in direct contradiction to the decision of local and state governments charged with protecting the lives and safety of their citizens. I reserve the balance of my time.
The gentleman reserves the balance of his time. For what purpose does the gentleman from Texas rise?
Mr. Chairman, I oppose the amendment.
The gentleman is recognized for 5 minutes.
Mr. Chairman, this is one of 3 amendments under consideration today that would allow the states to opt out of the nationwide concealed carry system that H.R. 822 seeks to establish. This undermines the bill's goal of creating national uniformity in our concealed carry laws. This amendment provides that every state attorney general, head of police, and secretary of state must certify that the concealed carry eligibility laws of every other state are substantially similar to their own before the state can participate in this legislation's grant of reciprocity. This is obviously intended to be overly burdensome both to those with concealed carry permits and to the states themselves. It is also simply a way for state officials who do not support the Second Amendment right to bear arms to decide that their state will not recognize out-of-state concealed carry permits. The amendment also incorrectly assumes that there are critical differences between the state's eligibility requirements, which is simply not the case. Each state has a vested interest in making sure that those with a propensity towards violence are not granted a concealed carry permit. Every state conducts a thorough background check so that unqualified individuals will not be able to carry a concealed firearm. The eligibility standards used by the states are more similar than not. The fact that there may be small differences among the state's eligibility laws should not allow a state to prohibit the exercise of Second Amendment rights within its boundaries. Also, federal and state laws governing the purchase of a firearm must be complied with before a person can even apply for a concealed carry permit. In order to purchase a firearm or take advantage of the reciprocity extended by H.R. 822, a person convicted of a felony or a domestic violence misdemeanor cannot legally purchase a firearm under federal law. A person must also be cleared through the Federal Bureau of Investigation's National Instant Criminal Background Check System, or NICS, before they can purchase a firearm. Data from the FBI's annual Uniform Crime Report shows that right-to-carry states, those that widely allow concealed carry permits, have 22% lower total violent crime rates, 30% lower murder rates, 46% lower robbery rates, and 12% lower aggravated assault rates as compared to the rest of the country. This amendment allows the current patchwork of concealed carry laws to continue and ignores the right to bear arms guaranteed by the Second Amendment. For those reasons, I oppose this amendment, and I'll reserve the balance of my time.
The gentleman reserves the balance of his time. The gentleman has 30 seconds remaining.
Just very quickly, the purpose is not, of course, to overly burden state governments, but instead to respect the judgments and decisions they've made in weighing the equities and making determinations as to what is the right criteria, to give respect to the duly elected officials in states who have made those judgments. It happens in South Dakota. It happens in Nebraska. It's not unduly burdensome. It's really about respecting the people in state government and in local governments who have the responsibility to protect the public health, safety, and well-being of residents of states, and I yield back the balance of my time.
Gentleman yields back the balance of his time. Gentleman from Texas.
Mr. Chairman, if you respect and support the full right of individuals to enjoy the rights under the Second Amendment to the Constitution to bear arms, you will oppose this amendment. I'll yield back the balance of my time.
Gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Rhode Island. Those in favor say aye. Those opposed, no. Opinion of the Chair, the ayes have it.
a recorded
Pursuant to Clause
vote.
6 of Rule 18, further proceedings on the amendment offered by the gentleman from Rhode Island will be postponed. It is now in order to consider Amendment Number 10, printed in House Report 112-283. For what purpose does the gentleman from Washington seek recognition?
I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 10, printed in House Report number 112-283, offered by Mr. Reichert of Washington.
Pursuant to House Resolution 463, the gentleman from Washington, Mr. Reichert, and a member opposed, each will control 5 minutes. The Chair recognizes the gentleman from Washington.
Thank you, Mr. Chairman. Today we're here considering a national reciprocity law for concealed firearms licenses and permits. I've always supported the Second Amendment rights for people to carry and keep firearms. I come at this from a little bit of a different perspective. I was a police officer for 33 years. Worked the streets for 6 years in a patrol car, SWAT commander, hostage negotiator. I've had guns pointed at me. I've looked down the barrel of a shotgun. I've looked down the barrel of a rifle. I've heard the shots fly by. I've been at the other end of the gun, too. Fortunately, not had to fire at anyone, but in the protection of people in my community, I've experienced being at both ends of a firearm. So I understand and I get the concerns of cops, my brothers and sisters in law enforcement. What we want to make sure today is that those law enforcement officers across this country that protect us, and here protecting us while we're in the Capitol today, are equipped and prepared to enforce this law. I have a concern. So my amendment would require that the GAO look into whether or not law enforcement officers are able and have the ability to verify the validity of out-of-state concealed firearms permits and licenses. Within 1 year of enactment, results of this study will be reported to the House Judiciary Committee and the Senate Judiciary Committee. Our state and local law enforcement across this country every day put their lives on the line. They put the badge on, they put their uniforms, they walk out into the street, they walk out into their patrol cars, and they're putting their life on the line. It's a risk and responsibility that they gladly accept. They want to come home safely, of course, to their families, but they know the risks when they leave their home. They know the risks when they put on the badge. We owe it to them to ensure the underlying bill does not create any unintended consequences or additional safety concerns. Right now, it's unclear whether every cop in every jurisdiction across this nation can efficiently determine the validity of concealed firearms permits. Each state decides how best to store that information and have access to its own concealed carry permit information, but maybe not that of other states. I only have so much time, so I apologize, not yet. Only 12 states are right now participating in a program that allows electronic access to Joint Concealed Carry Database. In the remaining 38 states, law enforcement officers are required to contact appropriate local officials over the phone or by email. This method is not timely enough and not effective. We must understand how long it takes for law enforcement officers to determine whether an out-of-state concealed carry permit is legitimate or fraudulent. This is critical to both the safety of the cops in patrolling our neighborhoods and to protecting the rights of law-abiding citizens. This GAO study will help us better understand the impact of national reciprocity for concealed firearms on our nation's law enforcement and their ability to effectively enforce the law. We must pass this amendment to ensure that our cops have the adequate tools to enforce this law, and I'd like to give the rest of my time, reserve the balance of my time.
Gentleman reserves the balance of his time. Who claims time in opposition?
I do, Mr. Chairman.
Gentleman from Michigan.
I thank you very much, and I merely wanted to ask our distinguished colleague from Washington if I understood correctly that the GAO would conduct a study about the ability of the state and local law enforcement to verify the validity of out-of-state concealment after this bill was passed? And I yield to the gentleman.
Thank you for yielding. The question is whether or not the study is tied to the passage of the bill. No, the study is not tied to the passage of the bill. The study will begin upon passage of the bill and will last, and the report must be filed before 1 year is up.
I see. Could I ask the gentleman why we wouldn't conduct the study in front of the bill rather than after the bill?
Well, the way that this amendment is presented, it's presented allowing the study to go on. As law enforcement encounters this new law, we'll then know, of course, what challenges they face as they look to enforce the law. We won't know all of those things until the law is in place.
Well, could I suggest that perhaps our responsibility as federal legislators might be to determine the impact of this proposal on public safety before we pass it, not years later after we've passed it. Would the gentleman concede that that might be the more appropriate path that we normally take?
Yes, sir. You're yielding once again. Thank you. Yes, sir. That's what my amendment is intended to do, is to gather that information so that we can appropriately revise the current policies that may exist in police departments across the country and sheriff's offices across the country.
I thank the gentleman.
Appreciate it. Thank you.
I yield back the balance of my time, and
Gentleman yields back the balance of his time. Gentleman from Washington has 1 minute remaining.
Yes, sir. I'd like to yield the balance of my time to the distinguished chairman of the Judiciary Committee.
Mr. Chairman, I want to thank the gentleman from Washington, a former sheriff himself, for yielding me time. And I appreciate his offering this amendment, which requests a study by the Government Accountability Office on the ability of state and local law enforcement agencies to verify the validity of non-resident concealed carry permits. The study requested by the gentleman's amendment will provide additional assurance that non-resident permit information can be verified by law enforcement officers across the country. So I urge my colleagues to support his amendment, and I'll yield back as well.
Back to the balance of his time. Question occurs on the amendment offered by the gentleman from Washington. All those in favor say aye.
Aye.
Those opposed, no. Chair, the ayes have it. The ayes have it. The amendment is agreed to. Pursuant to Clause 6 of Rule 18, proceedings will now resume on those amendments printed in House Report 112-283, on which further proceedings were postponed in the following order. Amendment number 1 by Mr. Woodall of Georgia. Amendment number 2, Mrs. McCarthy of New York. Amendment number 3 by Mr. Hastings of Florida. Amendment number 4 by Ms. Jackson Lee of Texas. Amendment number 6 by Mr. Johnson of Georgia. Amendment number 7 by Mr. Cohen of Tennessee. Amendment number 8 by Ms. Jackson Lee of Texas. Amendment number 9 by Mr. Cicilline of Rhode Island. The Chair will reduce to 2 minutes the time for any electronic vote after the first vote in this series. The unfinished business is the request for a recorded vote on Amendment number 1, printed in House Report 112-283 by the gentleman from Georgia, Mr. Woodall, on which further proceedings were postponed and on which the ayes prevailed by voice vote. The clerk will redesignate the amendment.
Amendment number 1, printed in House Report number 112-283, offered by Mr. Woodall of Georgia.
A recorded vote has been requested. Those in support of the request for a recorded vote will rise and be counted. Sufficient number having arisen, a recorded vote is ordered. Members will record their votes by electronic device. This will be a 15-minute vote.
Much of the afternoon, the House has been working on a bill that would allow gun owners with the proper permits to carry firearms across state lines. They've spent an hour on general debate and a number of hours on some 9 amendments to the bill. So a series of amendment votes here on the House floor. And we're going to open up our phone lines to get your thoughts on this bill. Here's how to call. If you're a Democrat, it's 202-585-3885. Republicans, 202-585-3886. Independents and others, 202-585-3887. Please make sure you mute your television when you call in, and if you've called in C-SPAN in the last month or so, give others a chance to call in this afternoon. Again, this is the First Amendment vote on a a bill that would allow gun owners to carry firearms across state lines. This is Rob Woodall's amendment. He, a Republican of Georgia, actually opposes the bill and offered an amendment that would allow states that have existing what they call reciprocity agreements to continue to enforce those agreements. Rob Woodall made the closing arguments against the bill in general debate. Let's go to your phone calls. We have Harry in Houston, Texas on our Democrats line. You're first up, Harry. Go ahead.
Hi, this is Harry Matthews, and I do vote for the license to carry.
Harry, do you yourself own a gun, and do you carry it? Are you permitted to carry it as a concealed weapon?
No, sir, I'm not permitted, but I was going to go to the class and get one.
All right, let's hear from Fritch, Texas. This is Dale on our Republican line. Just a reminder, folks, make sure you mute your television when you call in. Hi there, Dale.
Hi, how you doing?
Doing just fine. Go ahead with your comments.
Yes, sir. I think the concealed carry weapons law ought to pass without any amendments. I think people ought to be able to carry across the states and to protect ourselves.
Dale, do you yourself carry, or do you know folks who have firearms who
Yes, sir. I carry myself.
All right. Here's Arizona calling. This is Tom on in Milana, Arizona. Tom, I hope I have the town name right. Independent line.
Yes, I would very much like to see this bill pass without the amendments. I do carry a gun, not from Arizona, but from my home state. I'm a snowbird out here, and the reason I would like to see the bill pass is a lot of times I deal in precious metals, and I would love to see this bill pass because I carry a great amount as far as precious metals are concerned.
Sure.
And I would like to see it pass.
So
I get into states where it's really flaky as to what you're doing.
Well, what do you do when you go into a state, for example, that where you though you're permitted in Arizona to carry, you can't carry in a state? What do you do for your security?
I have to unload my gun and put it in a locked box, separate from the ammunition. And what I do for security, pray.
Let's hear from our Democrats line. This is Edward in Floydsville, Texas.
Yes, it's a first step, but I believe in uniformity gun laws. Every gun you have, you register. And in Texas, for example, if you get pulled over by a police officer, as he runs your license plates, he knows that you have a concealed carrying weapon.
So that comes up automatically when he pulls up the information.
And that should be countrywide.
Thanks for taking part. We have more calls, more of your calls coming up during this first 15-minute vote. But first, let's get an update on the bill itself. All right, we'll try to show you that, bring you that conversation in just a moment. Let's hear from Houston on our Republican line. Keith, go ahead.
Good afternoon to you. I support the legislation of H.R. 822. I have a concealed weapon carry permit in Texas, and the training requirements, first there's a class of 8 hours, and then you have a shooting exam as well by a licensed instructor. Normally it's a police officer or a sheriff, and at least when I took it in Harris County in Texas.
When you say a shooting exam, you have to be able to hit your target?
Pretty much, you have to hit. They score it depending on the target, but it's at different intervals. But basically, you have to show at least a proficiency to be able to shoot your weapon. So.
All right, Keith in Houston, Texas, and more of your calls coming up, as we said. Let's hear that update now from a Capitol Hill reporter. Now we're having some technical problem. We will continue with your phone calls. Patchogue, New York, independent line. Here is James.
Hi, yes.
You're on, James. Go ahead with your thoughts. Just don't listen to the television. Go ahead and Make your comment.
No, I absolutely agree that this bill should have been passed. There is absolutely no laws in this country that say that constitutionality varies from state to state. We don't have the ability to say you're allowed to have a freedom of religion in New York, but you can't have it in New Jersey, and vice versa. Having this law would greatly increase the ability of the average person to carry out their Second Amendment constitutional right from state to state without having to worry about reciprocity laws. Now, what I think has been skipped is that they still have to obey the laws of those the states that they're going into, which I think is actually something that we should work from moving away from. We should be moving towards a more universal national constitutionally driven gun laws, especially when it comes to the right of self-defense. You know, having state-to-state laws means that you pretty much need to have a minor in law degree in order to understand half of them, especially New York, which has convoluted laws. California has them as well. So I think while this is a good step in the right direction, I think we can do more for having more open and broader carry laws throughout the United States without infringing on the Constitution or the law.
Let's go to our next caller, Reading, Pennsylvania. Bruce is on our Democrats line. What do you think of the idea of the concealed carry bill that the House has been debating this afternoon?
I think it's a wonderful bill to have, considering that if you're concealed carry within whatever state that you're in, that should not stop wherever you go in these United States. So I believe that a national reciprocity, if you're qualified to carry in your own state, you should be able to carry anywhere within the 48 contiguous states, or the other two that are not exactly attached to the others.
If you're still on the line, hang on. We will get to your calls momentarily. The House is in the first of 8 amendment votes. They considered 9 amendments, 8 amendment votes to this concealed carry bill. And this first amendment by Rob Woodall of Georgia, his amendment would allow states that have existing reciprocity agreements to continue to enforce those agreements. Representative Woodall, a Republican, joined Democrats in opposing the bill. We want to show you his statements, his comments as he closed the general debate on the bill this afternoon.
Thank you, Mr. Chairman. I thank the gentleman for yielding. I love the Second Amendment. I got my first gun from Santa Claus when I was 6 years old. First handgun I ever fired wasn't my dad or my uncle's or my grandfather's, it was my mother's. I got my first concealed carry application filled out as a freshman in law school. Lived in a bad neighborhood, needed it for self-protection. I've had it for the last 20 years. I love the Second Amendment. But if the Second Amendment protects my rights to carry my concealed weapon from state to state to state, I don't need another federal law that says, yeah, I really mean it. It's already protected. And if the Second Amendment doesn't protect my right to carry a concealed weapon from state to state to state, then the 9th and 10th Amendments leave that responsibility to individuals and the states to regulate on their own. I came to Congress to protect freedom. I don't believe the Second Amendment was put in the Bill of Rights to allow me to shoot targets. I don't believe the Second Amendment was put in the Bill of Rights to allow me to hunt for deer in Turkey. I think the Second Amendment was put in the Bill of Rights so that I could defend my freedom against an overbearing federal government. I don't want the federal government in any issue of the law where the Constitution does not require it. And it does not require it here. Don't tell me it's an interstate commerce clause issue. We dismiss that on my side of the aisle regularly. Don't tell me it's necessary and proper. We dismiss that on our side of the aisle regularly. And don't tell me it's full faith and credit, because we dismiss that on our side of the aisle regularly. The temptation to legislate is great. The temptation is great. I absolutely believe in the intent of this legislation. I want the right to carry from coast to coast. Georgia has already orchestrated reciprocity agreements with 25 states. We've got 24 more to go. The Second Amendment exists so that we can keep and bear arms to defend ourselves against government, no matter how well intended. Rather than arms, I asked my colleagues to use their voting cards today to defend us against the overreach of federal government, no matter how well-intended. And I thank the gentleman for yielding.
And that's Rob Woodall, who represents the suburbs just outside of Atlanta, talking about the closing moments of the general debate and his amendment up for a vote here, the first one on the House floor. We have an Atlanta caller on the line. This is Doug on our Republican line. Thanks for waiting. Go ahead with your comments.
Okay, thanks. The comments from Mr. Woodall are particularly eloquent and indicative of the actual problem I see here. We have a lot of Democrats advocating on states' rights and states' decisions in this particular matter, even though this is a Bill of Rights delivered right that is guaranteed for all citizens. Meanwhile, on other issues such as the health care issue, which is not anywhere mandated that the government has the ability to create or manage or deliver or force health care, states' rights are completely thrown out in favor of a federal mandate. So it's just really indicative and I think example of the problem we have in the lack of standardization as far as where states get to decide what is regulated, where the federal government gets to decide. In this particular case, I think it's perfectly adequate for the federal government to make sure that those of us who have gone through the entire process of getting our permits, which is really much more intensive than, say, a driver's license or the ability to go and buy beer, is protected no matter where we go in the United States.
Again, the underlying legislation would allow gun owners with the proper permits to carry firearms across state lines. This is the first of 8 amendment votes to the bill. We expect a motion to recommit and final passage still ahead. Here's Chicago on our independent line. It's Greg. Hi.
Hello?
You're on the air, Greg.
Oh, hi. Yes. I do want to say right up front, I'm an NRA instructor. I teach handgun and personal protection classes. I'm also certified by the state of Utah to teach their concealed carry classes, me and my wife also. I'm all for less government. Believe me, I don't want the government involved in a lot of the things I do. But what's wrong with defending ourselves? There's nothing wrong with that. And apparently the states can't come all together for these things. Yeah, the laws are different from state to state. And you'll still have to follow those laws. If they don't want you carrying in a church in let's say, Ohio or whatever, you can't do that. So you're still going to have to follow state laws. I don't see anything wrong with this at all, and I'm all for the bill. I think it's a good law.
Let's go to Nashville next, and on our Democrats line, Annette is with us.
Yes, I think we should be able to carry guns because the criminals are carrying them, and if something happens, like in a restaurant or somewhere where you are, and the criminals got guns, that means that, you don't have no protection because nobody in the restaurant is going to protect you. So I feel that they...
Annette, how do you feel? Your representative, Steve Cohen, has an amendment coming up. His amendment would have an age limit, would limit it to individuals over the age of 21. What do you think about that idea?
Well, I think it should be, I think it should be over the age of 21. I agree with that because kids shouldn't be able to carry guns. I think it should be grown-ups, just like the drinking law.
We're going to get a few more of your phone calls as this 15-minute vote continues. The First Amendment vote of 8 to be considered, to be voted on, rather, in this concealed carry bill. First, though, I want to get you the closing thoughts and general debate of the bill's sponsor, Lamar Smith of Texas.
H.R. 822 is important legislation that recognizes that Americans' ability to exercise their fundamental constitutional rights should not disappear at their state's border. The parade of horribles that have been alleged by some of my colleagues on the other side of the aisle are simply not true. Federal law already prohibits felons, domestic abusers, and illegal drug users from possessing a firearm. This legislation does not change that. If a person is prohibited from possessing a firearm under federal law, they cannot carry a concealed weapon under this bill. The arguments we have heard so often today against this legislation are against guns in the hands of violent criminals, generally, not against legally permitted concealed weapons. Concealed carry laws have shown that concealed weapons actually lower violent crime rates in a jurisdiction. H.R. 822 simply permits law-abiding Americans to take their Second Amendment rights with them when they travel. I urge my colleagues to support this bipartisan piece of legislation. Now I yield back the balance of my time.
Lamar Smith from the House floor. Earlier, we're taking your phone calls and your thoughts on this concealed carry bill that the House has been debating this afternoon. As this First Amendment vote continues, it's Rob Woodall's amendment. He's a Republican from Georgia. Let's go to Hawthorne, New York. Richard is on our Republican line. Thanks for waiting.
Yes, hi. I'm a former lawman, police officer, both in New York and in the state of Virginia, and I have never, ever seen anyone with a license permit get themselves into an issue. So to stop someone that is legally responsible, they've done all the formats that were necessary for the states that they live in, they should be allowed to carry. That's the bottom line. You can drive across state lines. It's with your driver's license, it doesn't matter. And even with a handgun, you were required to take more courses to think responsibly. And these are the people who own permits. Otherwise, they wouldn't be allowed. You go through a psych exam up here in New York. They put you through some serious hoops to get your permit, and you should be allowed to carry.
Richard, as an ex-law enforcement officer, do you still carry a weapon, firearm?
Yes, sir, I do.
The Senate yesterday was met by a number of handgun control lobbyists or folks who are interested in handgun legislation. Tamara Audi from the Wall Street Journal writes that the lobbying effort yesterday, which included private meetings with lawmakers and an appearance before a Senate subcommittee, was organized by a coalition of mayors pushing for tighter gun control. The mayors led by New York Mayor Michael Bloomberg and Boston Mayor Thomas Menino and the Tucson survivors are lobbying for a bill that would require states to supply more complete mental health and criminal records to federal databases used for background checks on gun buyers. Let's go to Omaha, Nebraska. Next up, this is Alex, Independent Line.
Hello, how are you?
I'm doing fine, thank you.
I'd like to weigh in as a state-certified instructor, much like the guy from Illinois. I also do Utah, and I'm also certified to teach the non-resident for Florida. It's possible right now for a law-abiding citizen to receive up to, I believe, 36 states worth of reciprocity if you're willing to jump through the hoops to go through a non-resident class for a variety of states. And each state has roughly $100 to $150 registration for each permit. So right now, as it stands, you can get up to 36 states, but it's unduly punishing the law-abiding citizen to get his reciprocity, and it's really unfair.
Has it inhibited your travel as you go from state to state?
I honestly have not experienced the issue because it's not been a situation outside of the state of Hawaii where I go to visit my sister. I have not run into a state that doesn't allow me with a Nebraska or a Utah or a Florida permit. But
here's Pittsburgh. Thank you, Alex, for your comments. Here's Pittsburgh, and Carlos is on our Democrats line.
Hello, it's great to talk to you today. As a Army vet, I'd like to say that gun laws are a little too lax, honestly. I don't agree that all veterans should be, able to get a gun under law because there are many mental things that go on, for veterans. Going through war and combat, I have seen many things, and I oppose guns in residential areas because I've seen the violence it has, the many effects of violence, and it attributes to a lot of people. And also, being retired, I've lived in Miami, and I had a friend who lived in my condo. He had obtained a permit to have a concealed weapon. Mm-hmm. He would go down to his bar, on the block with the weapon. Local bars in the area with the weapon, drinking, and this is not something that's being stopped by law.
We'll get a couple more calls here, and this is Bill on our Republican line. He's in Rancho Cucamonga, California. Hi there.
Yeah, how you doing?
Doing well.
Yeah, I agree with the concealed weapon permit. I don't know if you've ever been in California or not, but the bad guys and the cops are the only ones allowed to carry them, and especially the cops, which makes I'm fearful for my family to be out there when they're driving or out in the public with the police around here. So I believe that we should be able to take care of our own selves because when something does happen, the police aren't there.
So, given the opportunity, Bill, you would apply for a permit to carry concealed there in California?
Yes, sir.
All right, here is West Hempstead, New York. Elliot, Independent Line. Hi.
Hello.
You're on the air.
This is Elliot. I would like to introduce myself to you. I'm 88 years old. I'm a veteran of the Air Force for World War II. I flew a full tour over Germany in a B-24 Liberator bomber. And my assessment of all of this nonsense that we put ourselves through about guns should be taken away, because the only people that are capable and should hold guns are our police forces and our armed forces. I do not believe that my average normal neighbor should be packing a gun, because we do not understand what the human condition is.
Bill,
and until we know about that, let them prove that to the population. Then you can let them have guns, but not a moment before that. I'm absolutely against all of this that you're presenting about guns. Not you, of course, but our Congress.
Understood, Elliot, and thank you for your opinion. One more call here. Here's Beverly in Littleton, North Carolina, on the Democrats' line.
How are you doing today? I am really opposed to it. I am opposed to it. I had a sister who, at the age of 25, had a hypothyroid that went up on her. And this gun law they're talking about, has really no, people in life change. And if this law had been in effect then, my sister may have killed a lot of people. I do not like the law. I think it's very dangerous, and it's a very dark law, and it's very dangerous. I think it's dangerous for the public.
Beverly, we appreciate your input, and thanks for all the calls. Again, this is an amendment vote, the first of 8 recorded votes on amendments to the concealed carry bill. This is Rob Woodall's amendment. This has been a 15-minute vote, and obviously went a bit longer. The rest of the amendment votes, anyway, will be 2-minute votes. You're watching live House coverage on C-SPAN.
The yeas are 140, the nays are 280. The amendment is not adopted. The unfinished business is the request for recorded vote on amendment number 2, printed in House Report 112-283 by the gentlewoman from New York, Mrs. McCarthy, on which further proceedings were postponed and on which the ayes prevailed by voice vote. The clerk will redesignate the amendment.
Amendment number 2, printed in House Report number 112-283, offered by Mrs. McCarthy of New York.
A recorded vote has been requested. Those in support of the request for a recorded vote shall rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members shall record their vote by electronic device. This is a 2-minute vote.
Carolyn McCarthy, Democrat from New York, has an amendment that would allow the bill to only take effect in states that have enacted legislation affirming that the provisions of the bill apply within their jurisdiction. Again, the underlying bill would allow gun owners with the proper permitting to carry firearms across state lines. This is the second of 8 roll call votes on amendments to the legislation.
On this vote, the yeas are 147, the nays are 274. This amendment is not adopted. The unfinished business is the request for a recorded vote on Amendment Number 3, printed in House Report 112-283 by the gentleman from Florida, Mr. Hastings, on which further proceedings were postponed and on which the ayes prevailed by a voice vote. The clerk will redesignate the amendment.
Amendment Number 3, printed in House Report Number 112-283, offered by Mr. Hastings of Florida.
A recorded vote has been requested. Those in support of the request for a recorded vote shall rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members shall record their vote by electronic device. This is a 2-minute vote.
An amendment from Alcee Hastings, Democrat of Florida, that would exempt states from issuing a permit to an individual from another state if that state does not require them to apply for a permit in person with local law enforcement. Again, a series of roll call votes here on amendments to the concealed carry bill.
$148. The noes are 274.
Mr. Hall. Mr. Hall votes no. Mr. Schock. Mr. Schock votes no.
77. The amendment is not adopted. The unfinished business is on the request for recorded vote on Amendment Number 4, printed in House Report 112-283 by the gentlewoman from Texas, Ms. Jackson Lee, on which further proceedings were postponed and on which the ayes prevailed on a voice vote. The clerk will redesignate the amendment.
Amendment number 4, printed in House Report number 112-283, offered by Ms. Jackson Lee of Texas.
Recorded vote has been requested. Those in support of a recorded vote shall rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members will record their votes by electronic device. This is a 2-minute vote.
This is Sheila Jackson Lee's amendment to the concealed carry bill. Her amendment would require states to create a database of all concealed carry permits issued for weapons within their jurisdiction. The House now voting on amendments to that bill. Motion to recommit coming up, and then the final passage. Again, the bill itself would allow gun owners with the correct permits to carry firearms across state lines. Tomorrow in the House, they're going to take up the conference report 2012 spending, the so-called minibus, combining a number of agency spending bills into one package. They'll take that up, and also likely to take up the rules for debate for the balanced budget amendment. That is tomorrow in the House. That'll be live, of course, here on C-SPAN. We're also covering tomorrow a House Energy and Commerce hearing. Their subcommittee on oversight will hear from Stephen Chu, the Secretary of Energy. He's going to be testifying specifically on the Solyndra loan guarantee. This after the Obama administration, it was reported today by Associated Press that the administration wanted the failing solar energy company to delay announcing an early round of employee layoffs until after the 2010 midterm elections, according to newly released emails. That hearing tomorrow, the oversight hearing, will be at 10 a.m. Eastern, and we will cover that live for you on C-SPAN 3 and also on C-SPAN Radio.
On this vote, the yeas are 139, the nays are 284. The amendment is not adopted. The unfinished business is the request for a recorded vote on Amendment Number 6, printed in the House Report 112-283 by the gentleman from Georgia, Mr. Johnson, on which further proceedings were postponed and on which the ayes prevailed by a voice vote. The clerk will redesignate the amendment.
Amendment number 6, printed in House Report number 112-283, offered by Mr. Johnson of Georgia.
Recorded vote has been requested. All those in support of the request for a recorded vote shall rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members shall vote by electronic device. This is a 2-minute vote.
Hank Johnson's amendment to the concealed carry bill would subject individuals who carry a concealed handgun to a state's requirement for firearms safety training, including live fire exercise requirements. It's another 2-minute vote, and there are 4 more amendment votes coming up after this, and following that, motion to recommit and final passage. 3 more amendment votes following this one. Also, the House will be voting just a bit later on the bill they debated earlier, the repeal of the 3% tax withholding from government contracts. It's the changes that the Senate made to the House bill from last week, or the week before.
On this vote, the yeas are 143. The nays are... Ms. Hirono. Ms. Hirono votes aye. Mr. Kaufman of Colorado. Mr. Kaufman of Colorado votes no. Mr. Hall. Mr. Hall votes no. On this vote, the yeas are 144, the nays are 281. The amendment is not adopted. The unfinished business is a request for a recorded vote on amendment number 7, printed in House Report 112-283 by the gentleman from Texas, gentleman from Tennessee, Mr. Cohen, on which further proceedings were postponed and on which the noes prevailed by a voice vote. Clerk will redesignate the amendment.
Amendment number 7, printed in House Report number 112-283, offered by Mr. Cohen of Tennessee.
Recorded vote has been requested. Those in support of a request for a recorded vote shall rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members will vote by electronic device. This is a 2-minute vote.
Steve Cohen of Tennessee has an amendment that would put an age limit on this bill that would allow gun owners to carry firearms across state lines. With proper permits, this would raise the age. The minimum age would be 21. Jim Abrams of the Associated Press writes about this. We talked to him earlier, and we hope to bring you that conversation in an upcoming vote. He wrote that the measure, this bill, has 245 sponsors in the 435-member House. He writes that under the legislation, people with a concealed carry permit in one state could carry a concealed weapon in every other state that gives people the right to carry concealed weapons. While states have various standards for issuing permits, currently only Illinois and the District of Columbia prohibit the concealed carrying of weapons.
vote, the yeas are 150, the nays are 276. The amendment is not adopted. The unfinished business is a request for recorded vote on amendment number 8, printed in House Report 112-283 by the gentlewoman from Texas, Ms. Jackson Lee, on which further proceedings were postponed and on which the noes prevailed by a voice vote. The clerk will redesignate the amendment.
Amendment number 8, printed in House Report number 112-283, offered by Ms. Jackson Lee of Texas.
Recorded vote has been requested. Those in support of the request shall rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members shall record their votes by electronic device. This is a 2-minute vote.
Sheila Jackson Lee of Texas, her amendment would require an individual to notify law enforcement of a state that they are visiting at least 24 hours in advance of bringing a concealed weapon into the state. 2-minute vote. One more amendment vote will follow this.
On this vote, the yeas are 123, the nays are 299. The amendment is not agreed to. The unfinished business is a request for a recorded vote on amendment number 9, printed in House Report 112-283 by the gentleman from Rhode Island, Mr. Cicilline, on which further proceedings were postponed and on which the ayes prevailed by voice vote. The clerk will redesignate the amendment.
Amendment number 9, printed in House Report number 112-283, offered by Mr. Cicilline of Rhode Island.
Recorded vote has been requested. Those in support of the request for recorded vote will rise and be counted. A sufficient number having risen, a recorded vote is ordered. Members shall vote by electronic device. This is a 2-minute vote.
And this is the last amendment vote on this bill that would allow gun owners with proper permits to carry firearms across state lines. David Cicilline of Rhode Island has an amendment which would prevent the bill from taking effect in a state until the state's Attorney General, the head of the state police, and Secretary of State have certified that the concealed weapons laws of another state are substantially similar to their own. It's a 2-minute vote. We expect a debate on a motion to recommit and that motion to recommit vote and final passage after that.
On this vote, the yeas are 146, the nays are 277. The is not adopted. The question is on the committee amendment in the nature of a substitute as amended. Those in favor, please say aye. Those opposed, no. The ayes have it. The amendment is adopted. Accordingly, the committee rises.
Right over there.
Madam Speaker, the Committee of the Whole House on the State of the Union has had under consideration H.R. 822. And pursuant to House Resolution 463, I report the bill back to the House with an amendment adopted in the Committee of the Whole.
The Chair of the Committee of the Whole House on the State of the Union reports that the committee has had under consideration the bill H.R. 822 and pursuant to House Resolution 463 reports the bill back to the House with an amendment adopted in the Committee of the Whole. Under the rule, the previous question is ordered. In a separate vote demanded on the amendment to the amendment reported is a separate vote demanded on the amendment to the amendment reported from the Committee of the Whole. If not, the question is on the committee amendment in the nature of a substitute as amendment. Those in favor say aye. Those opposed, no. The ayes have it, and the amendment is agreed to. The question is on engrossment and third reading of the bill. Those in favor say aye. Those opposed say no. The ayes have it. Third reading.
A bill to amend Title 18 United States Code to provide a national standard in accordance with which non-residents of a state may carry concealed firearms in the state.
Would the House come to order? The House come to order. For what purpose does the gentleman from Rhode Island rise?
I have a motion to recommit at the desk.
Is the gentleman opposed to the bill?
I am opposed.
The gentleman qualifies. The clerk will report the motion.
Mr. Cicilline of Rhode Island moves to recommit the bill H.R. 822 to the Committee on the Judiciary with instructions to report the same back to the House forthwith with the following amendments. Page 5, after line 3, insert the following section. Limitations on reciprocity for child sex offenders, domestic violence offenders, and known or suspected terrorists.
What purpose does the gentleman from South Carolina rise?
Madam Speaker, I ask unanimous consent to dispense with the reading.
Without objection, so ordered. The gentleman from Rhode Island is recognized for 5 minutes.
Madam Speaker, with nearly 14 million unemployed Americans and our nation's economy continues to struggle, it's disheartening that we stand...
The gentleman's correct. The House is not in order. Will members take their conversations from the floor? Gentleman may resume.
It is disheartening that we stand here today divided, engaging in heated debate about expanding the ability of people to carry concealed weapons, and ignoring the most important issue confronting our country, the jobs crisis. We're debating an effort to undermine the ability of states to protect residents from the scourge of gun violence. And we have before us a bill that will effectively preclude...
That's correct. The House is not in order. Will members please take their conversations from the floor? The gentleman deserves to be heard. Will members please cease their conversations on the floor? Gentleman may resume.
We have before us a bill that will effectively preclude states from limiting who can carry a concealed weapon within its borders and for what purpose. While many of my colleagues and I are seriously opposed to the passage of the underlying bill, there still remains an opportunity for us to find common ground. There's a chance for us to unite around a reasonable and common-sense amendment which would prevent the privileges in this bill from being extended to some of the most dangerous individuals in our society. individuals who have or intend to inflict great harm upon our communities and our nation. Let me be clear, this is the final amendment, and passage of this amendment will not kill the bill. It will be incorporated into the final language and immediately voted upon. While many of us may disagree with the underlying intent of this bill, it's hard to imagine anyone would disagree that there are certain individuals that should not be afforded the right to carry concealed, loaded weapons across state lines. It's hard to imagine that anyone would advocate for preserving a path for terrorists, child sex offenders, stalkers, and domestic abusers to transport a loaded gun into another state. Yet these glaring loopholes are present in the underlying bill. And if my amendment is not passed by this body, this dangerous and appalling pathway for violence will remain. For far too long, terrorism has inspired fear in our country and threatened the happiness and safety of our citizens. And while we continue to live in a world that requires constant vigilance and full awareness of the danger of future terrorist attacks, there is not a single provision in H.R. 822 that would prevent suspected or known terrorists who acquire concealed carry permits in one state with lax regulations from carrying that same concealed loaded weapon into another state with more stringent regulations. In addition, many current state concealed carry laws do not sufficiently protect victims of domestic violence. A 2007 investigation found that Florida's...
This is not in order. Gentleman may continue.
A 2007 investigation found that Florida's licensing system had granted concealed carry permits to more than 1,400 people who had pleaded guilty or no contest to a felony, 128 people with active domestic violence injunctions, and 6 registered sex offenders. In fact, in 2010, Gerardo Regalado, a man who had a record of violent behavior against women, was able to obtain a concealed handgun permit in Florida. He then went on to commit the worst mass killing in Hialeah, Florida's history, when he killed his estranged wife and 3 other women at a local restaurant. H.R. 822 will force other states to recognize Florida's concealed carry permits, the same permit held by Gerardo Regalado. Finally, there's no protection in H.R. 822 to prevent individuals convicted of a sex offense against a minor from carrying a concealed loaded gun into a state whose requirements might have otherwise prevented that individual from acquiring a concealed carry permit. Child sex offenders, individuals who create unimaginable, lasting harm in our communities, should not be allowed to continue to perpetuate fear in the hearts of our children and families. H.R. 822 will force other states to recognize permits issued to these individuals who pose danger to our children. All too often, guns legally end up back in the hands of criminals, and nothing in this underlying bill would impede child sex offenders or domestic violence offenders from carrying their loaded, concealed guns across state lines. In the simplest of terms, my amendment would preclude child sex offenders, domestic violence offenders, and known or suspected terrorists from enjoying the privilege of concealed carry reciprocity authorized in the underlying bill. We owe this common-sense amendment to our brave law enforcement officials and first responders who bear the greatest responsibility in protecting us from terrorist attacks. We owe this to our nation's children, whose innocence is threatened by dangerous individuals who prey on them. We owe this to the victims of abuse who deserve some consolation that the law will not send their abusers legally armed into another state to continue stalking, threatening, and perpetuating abuse. Now is the time for our chamber to unite. Let's demonstrate to the American people that we can use common sense and come together to do what is right. While there is no question that the Second Amendment embodies the right to bear arms, our citizens also enjoy the right to be free from the terror of gun violence. I urge all members to support this motion.
Does the gentleman from South Carolina rise?
I rise in opposition to the motion to recommit.
The gentleman is recognized for 5 minutes.
Thank you, Madam Speaker. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed.
Ben, I'd like to remind members that traffic in the well while another member is addressing the House is improper behavior. Gentleman may continue.
Thank you, Madam Speaker. The Second Amendment to our Constitution was drafted, debated, and ratified in precisely the same manner as the First Amendment, the Fourth Amendment, the Fifth, the Sixth, and other amendments our colleagues on the other side of the aisle find so sacrosanct. And consistent with this belief that liberty and the right to arm oneself are inextricably linked, it is settled law that our Constitution protects the right to travel. It protects the right to self-defense. It protects the right to defend the lives of others. Not once, Madam Speaker, but twice, the Supreme Court has held the right to keep and bear arms is a fundamental individual right, and those rights do not know any geographic boundary.
Gentleman's correct. The House is not in order. Members, please take their conversations from the floor. Gentleman may continue.
Thank you, Madam Speaker. Not once but twice, the Supreme Court has held the right to keep and bear arms as a fundamental individual right, and those rights do not know any geographic boundary, and our right to defend ourselves does not ebb and flow with the vicissitudes of travel or because we transverse a state line. Despite the fact that these rights are protected in the Constitution, there are still those who seek to treat the Second Amendment as a constitutional second-class citizen. Sometimes those efforts, Madam Speaker, to denigrate the constitutional status of the Second Amendment are overt, and sometimes they are obscure. And as much as we appreciate the renewed, and I am sure short-lived, infatuation with states' rights embraced by some of our colleagues on the other side, let me ask you simply this: what limits are you willing to accept with regard to the First Amendment? Does your state want reporters to have to pass a test so they can exercise their First Amendment? Do you want 50 different versions of freedom of religion? What about the Fourth Amendment? Is one state free to dispose of the exclusionary rule because it doesn't agree with it? Do we have 50 different versions of what's a reasonable search and seizure? What about the Fifth Amendment? Do we have 50 different versions of Miranda? What about the Eighth Amendment? Are there 50 different versions of cruel and unusual punishment? We are delighted, Madam Speaker, to have our colleagues rediscover the beauty of the 10th Amendment and the concept of state rights. Eventually, we hope the same for the Second Amendment. This motion to recommit is offered to jettison the underlying bill and further relegate the Second Amendment to a constitutional scrap heap. All of these amendments were dealt with in committee, Madam Speaker, and the matters of state law classifications are just that, state law. The fact that certain state legislatures refuse to protect their citizens does not mean this body will refuse or abdicate its responsibility to defend the Second Amendment. This bill, Madam Speaker, H.R. 822, has 245 co-sponsors, more than half the members of this body, and it enjoys that wide and diverse support because it is emblematic of our forefathers' genius. They gave us the fundamental right to travel. They gave us the fundamental right to protect ourselves. They gave us the fundamental right to protect others. And they gave us the fundamental obligation to defend liberty. I urge my colleagues to oppose this motion, and I yield back the balance of my time.
Without objection, the previous question is ordered. The question's on the motion to recommit. Those in favor say aye. Aye. Those opposed say no. No. The noes have it.
I ask for a recorded vote, please.
Gentleman from Rhode Island has asked for a recorded vote. Those favoring a recorded vote shall rise. A sufficient number having risen, recorded vote is ordered. Members will record their votes by electronic device. Pursuant to Clause 8 and Clause 9 of Rule 20, the 15-minute vote on the motion to recommit will be followed by 5-minute votes on passage, if ordered, and the motion to suspend the rules on H.R. 674. This is a 15-minute vote.
And Democrats here with one final chance to amend the bill, a bill that would allow gun owners with the proper permits to carry firearms across state lines. This is the motion to recommit. It's a 15-minute vote. We spoke earlier this afternoon to a Capitol Hill reporter for some details on this concealed carry bill. Covering the concealed carry bill is Jim Abrams with the Associated Press. Why have House Republicans brought this gun bill to the floor?
Well, they believe that there's a certain lack of
reciprocity among the states, that there's some confusion about what people with concealed weapon permits can do when they visit another state. And this is something they've been pushing for some years, and it just happened that they decided to take it up now.
Well, what's the current law? How would it affect a person, say, who has a concealed carry permit in Montana and traveling to a state like Florida?
Well, right now there are 49 states that have one form of concealed carry permit. The only state that does not is Illinois, plus District of Columbia. But there's kind of a hodgepodge of reciprocity agreements where different states have reciprocity agreements with other states, but there's no national reciprocity system. And this bill would say that if you have a permit from any state, you could use that permit in any of the other 48 states except Illinois.
Well, we've heard opponents raise the issue of states' rights in opposing this bill. Explain that line of thinking for us.
That line of thinking is that a state such as New York, which has very tough standards for giving out permits, would have to allow someone from another state that has more lax standards to go into the states. And the states' rights argument is that, well, the states should be able to determine what the qualifications are for eligibility for permits, and that it's kind of a rush to the bottom for allowing people from states with more lax standards to visit their states with concealed weapon permits.
Well, unlike many other House bills, we've seen pockets of Democratic supporters for the bill and Republican opponents. So when the vote happens, how do you think things will shake out?
I think it'll easily pass the House. I think just about every Republican will vote for it. And of course, there's a fairly large contingent of gun rights advocates among the Democrats as well. They have 245 sponsors right now for the bill.
In your Associated Press article earlier today, you wrote that the Democratic-controlled Senate has no parallel bill, but is there any consideration of taking this bill up in the Senate?
Well, 2 years ago, it nearly passed as an amendment to a larger bill. And that always can happen in the Senate, where it does happen with issues such as social issues such as guns or abortions, where members in the Senate will try to attach legislation as amendments to other larger pieces of legislation, and that certainly could happen with this bill as well.
Jim Abrams with the Associated Press, thank you for that update.
Thank you.
And on the House floor, Democrats here with one last chance to amend the bill. This is the motion to recommit vote. It's a 15-minute vote, final passage vote after this, and then the vote on the bill repealing the imposition of 3% withholding of federal government contractors. That also will be a 5-minute vote, and that will wrap up the recorded votes, roll call votes, at least for this afternoon in the U.S. House. As this 15-minute vote continues, what we'll do is show you some of the floor debate from earlier today on this gun bill.
The first reason this bill should be defeated is that it usurps state authority and replaces it with a lowest common denominator federal directive. This is a radical piece of legislation. In fact, today, 43 states are not in compliance with this law. 38 states today prevent people from carrying concealed weapons if they have certain dangerous misdemeanor criminal convictions. 35 states require the completion of a short gun safety program. The Commonwealth of Virginia has weakened its gun laws over the past 2 years, allowing concealed guns in bars and renewal of permits by mail. I disagree with these actions, but I would never question the General Assembly's authority to make these decisions. But this bill makes our state legislature's judgment irrelevant. This is a federal power grab, coming from a majority that claims to be a defender of states' rights. The second reason that this bill should be defeated is that our law enforcement professionals oppose it. The International Association of Chiefs of Police, the Major Cities Police Chiefs Association, the Virginia Association of Chiefs of Police all oppose this bill. Why? Because they know that it will be nearly impossible for police to verify the validity of 49 different carry permits, placing officers in potentially life-threatening situations. Some states don't even keep verifiable databases of those who have been issued concealed carry permits. Law enforcement is trying to curb illegal gun smuggling, but this bill allows traffickers with concealed carry permits to transport firearms into destination states and present an unverifiable permit if stopped by police. This is a blatant legislative overreach, presumably because it was next on the NRA's legislative wish list. We should defeat this bill, Mr. Speaker.
Gentleman from Texas.
Arkansas, Mr. Ross.
Gentleman from Arkansas is recognized for 1 minute.
Thank you, Mr. Chairman. I rise today in strong support of H.R. 822. If you get a driver's license in Arkansas, it's recognized in every state in the country. And if you have a concealed carry permit, the same rules should apply. Our Second Amendment rights to own and bear arms are universal, and our laws should reflect that as best they can. The National Right to Carry Reciprocity Act would allow every American citizen with a valid concealed carry permit to carry a concealed firearm in all states that allow them for lawful purposes. Let me be clear. If your state bans concealed firearms, then this law will not affect that ban. This bill does not change any state laws about when and where you can carry a concealed firearm. This bill does not create a new federal licensing system. It simply reinforces our Second Amendment rights and makes the laws more fair for law-abiding gun owners. As a strong supporter of the Second Amendment, I believe we must pass the National Right to Carry Reciprocity Act now, and I urge my colleagues to join me in voting for the bill.
Gentleman from Michigan.
Mr. Speaker, I yield to the distinguished gentleman from New Jersey, Bill Pascrell, 1.5 minutes.
Gentleman is recognized for 1.5 minutes.
Thank you, Mr. Speaker, Mr. Ranking Member, Mr. Chairman. I had to make a choice on this bill, whether I would support a disputable constitutional issue about whether you can, by law, carry a concealed weapon, or move towards the other side to those who oppose this. Now, who opposes this legislation besides me? Mayors Against Illegal Guns, the International Association of Chiefs of Police, the Major Cities Chiefs Association, and the Police Foundation oppose this bill. Doesn't this mean anything to you at all? Doesn't it? Or does it? I prefer community policing than try to put more guns into the hands of those people who we don't even know are going to be trained to even use them. That's my preference, Mr. Chairman. This means my home state of New Jersey. This is not Idaho. This is not Montana. We're pretty close. In fact, we have the most densely populated state in the Union. There is a different culture. When Clinton argued in behalf of gun possession, when he was the President of the United States, he always made this point about the cultural differences in different parts of the country. We respect that. I'm not against the Second Amendment. I support the Second Amendment. But I don't want those folks in the street who are out armed and are gunned our police officers. 12,000 less police officers we have in this country. Thank you. Mr. Speaker.
Gentleman's recognized.
Thank you. 12,000 less police officers in our streets. We should be worried about that as a priority rather than this as a priority. So I made the decision. The evidence is like this against doing this. We haven't had any legislation which took away one gun in the past 20 years from anybody in this country. Not one. So we have made the perception being that we want to take guns away from people. How dare you even say it? Protect our police. Don't vote for this.
1 minute to the gentleman from Illinois, Mr. Kinzinger.
Gentleman's recognized for 1 minute.
Well, thank you, Mr. Speaker. The right to keep and bear arms is a real simple phrase, but it seems to, in some people, have only negative thoughts. When the words gun or firearm are heard, thoughts immediately turn to criminals. But that's the problem, because the debate we're having today isn't about criminals. It's about the rights of law-abiding citizens to bear arms for self-defense. Look, Illinois is the only state without concealed carry, but I'd argue we already have concealed carry. There are people that are killed in Chicago very often by guns that are already concealed, but not concealed by law-abiding citizens. Illinois is the only state that doesn't allow any form of it legally. I want H.R. 822 to be a clear sign to the governor of Illinois that now is the time to join the rest of the country in allowing citizens the right to conceal a firearm on their person. We hear so much about if we allow people to carry guns, more people are going to be killed, but that flies in the face of statistics. After 2008, there was a record number of guns purchased, but we saw crime drop almost everywhere, bar none. My point is that law-abiding citizens in this country are not the problem. Illinois needs to join the rest of the country in supporting concealed carry for its citizens, and I believe that this is a sign that it's time to do so now, and I yield back.
Gentleman from Michigan.
Mr. Speaker, I'm pleased to yield to the distinguished gentlelady from Florida, Debbie Wasserman Schultz, a former member of the Judiciary Committee, 2 minutes.
Gentlelady is recognized for 2 minutes.
Thank you, Mr. Speaker. I rise in opposition to H.R. 822, the National Right to Carry Reciprocity Act. This ill-conceived bill is yet another distraction from what should be the most pressing concern of this Congress, putting Americans back to work. What's more disturbing is that this bill jeopardizes public safety by mandating that states honor even the most lax concealed weapons laws of other states. The gentleman from Illinois is incorrect. This is about criminals. For my constituents in South Florida, gun control is a serious issue. Miami-Dade County has one of the highest rates of gun violence in the country, and in the entire state of Florida, there are almost 800,000 permits for concealed firearms. Florida's process for issuing concealed carry licenses is problematic enough, and I would certainly not suggest foisting it on any other state that has stronger safeguards to protect its citizens. But this bill will do exactly that. For states that require age minimums or safety training before getting a concealed weapons permit, or that prohibit certain violent offenders from getting a permit in the first place, that all goes out the window if this bill is passed into law. What we get in return is the worst of the worst, a lowest common denominator of all these state laws. For example, in just one 6-month period in 2006, Florida gave concealed carry licenses to more than 1,400 individuals who had pleaded guilty or no contest to felonies. 216 of them had outstanding warrants. 128 of them had active domestic violence injunctions. And under this bill, other states will be mandated to honor these permits. They'll be mandated to allow Florida's self-admitted felons to carry concealed weapons in their states. This is why the nation's leading law enforcement organizations strongly oppose this bill. It's also opposed by more than 600 members of the bipartisan Mayors Against Illegal Guns, including many of my local mayors of both parties in South Florida. Why would this bill be a higher priority than creating jobs? This is the 11th straight month of this Congress, and the House majority still has no jobs agenda. Regardless of how Americans feel about guns, the overwhelming majority would agree that gun policy is not a higher priority than job creation is right now. I urge my colleagues to vote no on this bill, and I urge my friends across the aisle to stop putting American lives at risk and start putting them back to work. Thank you. I yield back the balance of my time.
Gentleman from Texas.
Mr. Chairman, I yield 1 minute to the gentleman from North Carolina, Mr. Coble, who is also the chairman of the Court Subcommittee of the Judiciary Committee.
Gentleman is recognized for 1 minute.
I thank Mr. Smith. Mr. Chairman, I rise in support of H.R. 822. Conceal and carry permits may be one of the most scrutinized permits for gun owners to receive. Unfortunately, the manner in which these permits are recognized by various states is confusing and inconsistent. H.R. 822 will help resolve this dilemma, Mr. Chairman. For example, in my home state of North Carolina, conceal and carry permits from South Carolina and Georgia are recognized, but not permits from New Mexico. Meanwhile, New Mexico readily recognizes conceal and carry permits from North Carolina. If enacted, there would be no discrepancy over which permits are valid. Another reason for supporting H.R. 822 is that it protects state sovereignty. States are not required to issue conceal and carry permits, and state laws regarding the use and ownership of firearms are explicitly preserved. I firmly believe that the Second Amendment confers a constitutional right for individuals to own a firearm, Mr. Chairman. I also believe that ownership and use of a firearm carries a special level of personal responsibility. This bill promotes both of these ideals, and if enacted, it will help make America safer, which probably explains why this bill has 245 co-sponsors. I thank the chairman and yield back.
Gentleman from Michigan.
Speaker, I am pleased to yield to the distinguished gentleman from New Jersey, Rush Holt, 2 minutes.
Gentleman's recognized for 2 minutes.
I thank the gentleman. Mr. Speaker, this is another great example of legislation in search of a problem. Driven by ideological fervor of its sponsors rather than by any practical approach to safety, H.R. 822 would amend existing federal law to establish a national standard for carrying concealed firearms. As the sponsors well know, these matters have long been the province of the states. It's fascinating how quickly the majority ignores the 10th Amendment when the gun lobby comes calling. Why needlessly create a conflict?
The yeas are 161. The nays are 263. The motion is not adopted. The questions on passage of the bill. Those in favor say aye. Those opposed say no. The noes have it.
Madam Speaker,
Gentleman from
on that
Texas.
I ask for a recorded vote.
Recorded vote is requested. Those favoring a recorded vote will rise. A sufficient number having risen. Recorded vote is ordered. Members will record their votes by electronic device. This is a 5-minute vote.
And this is final passage on the bill that would allow gun owners with the proper permits to carry firearms across the state lines. It's a 5-minute vote.
Mr. Cummings. Off aye on no for Mr. Cummings.
On this vote, the yeas are 272, the nays are 154. The bill is passed. Without objection, a motion to reconsider is laid on the table. The unfinished business is the vote on the motion of the gentleman from Michigan, Mr. Camp, to suspend the rules and concur in Senate amendments to H.R. 674, on which the yeas and nays were ordered. The clerk will report the title of the bill.
H.R. 674, an act to amend the Internal Revenue Code of 1986 to repeal the imposition of 3% withholding on certain payments made to vendors by government entities, to modify the calculation of modified adjusted gross income for purposes of determining eligibility for certain health care-related programs and for other purposes.
The question is, will the House suspend the rules and concur in the Senate amendment? Members will record their votes by electronic device. This is a 5-minute vote.
And moments ago, the House passing the concealed carry bill, a bill that would allow gun owners with proper permits to carry firearms across state lines, that passed by a vote of 272 to 154. This is the final roll call vote of the day. This is on the repeal of the 3% withholding on government contractors. This is the changes that the Senate made, which includes provisions relating to promoting the hiring of veterans. This is a 5-minute vote, and again, it's the last recorded vote of the day. The House is expected to be in tomorrow at 10 a.m. for morning hour speeches, noon for legislative business, and tomorrow they'll take up the conference report, the 2012 spending, the first minibus of several spending packages tied together. They'll take that up tomorrow and also expected to take up the rules for debate to the balanced budget amendment. All of that tomorrow, beginning at noon Eastern, and live coverage here on C-SPAN.
Have all members voted? On this vote, the yeas are 422, the nays are 0. Two-thirds being in the affirmative, the rules are suspended, the Senate amendment is agreed to, and without objection, the motion to reconsider is laid on the table. For what purpose does the gentlewoman from North Carolina rise?
Mr. Speaker, I send to the desk a privileged report from the Committee on Rules for filing under the rule.
Clerk will report the title.
Report to accompany House Resolution 467, resolution providing for consideration of the conference report to accompany the bill H.R. 2112, making appropriations for agriculture, rural development, Food and Drug Administration, and related agencies ending September 30th, 2012, and for other purposes.
Referred to the House calendar and ordered printed. For what purpose does the gentleman from Pennsylvania rise?
Mr. Speaker, I ask unanimous consent to remove my name as a co-sponsor of H.R. 3086.
Without objection, so ordered. Pursuant to Clause 8 of Rule 20, proceedings will resume on the motions to suspend the rules previously postponed. Votes will be taken in the following order. H.R. 3004, de novo. H.R. 2660, de novo. H.R. 2415, de novo. H.R. 1791, de novo. The unfinished business is the question on suspending the rules and passing H.R. 3004, which the clerk will report by title.
H.R. 3004, a bill to designate the facility of the United States Postal Service located at 260 California Drive in Yountville, California, as the private first-class Alejandro R. Ruiz Post Office building.
The question is, will the House suspend the rules and pass the bill? So many as in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table. Unfinished business is the question on suspending the rules and passing H.R. 2660, which the clerk will report by title.
H.R. 2660, a bill to designate the facility of the United States Postal Service located at 122 North Holderrieth Boulevard in Tomball, Texas, as the Tomball Veterans Post Office.
The question is, will the House suspend the rules and pass the bill? So many as in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table. The unfinished business is the question on suspending the rules and passing H.R. 2415, which the clerk will report by title.
H.R. 2415, a bill to designate the facility of the United States Postal Service located at 11 Dock Street in Pittston, Pennsylvania, as the Trooper Joshua D. Miller Post Office building.
The question is, will the House suspend the rules and pass the bill? So many as in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table. The unfinished business is the question on suspending the rules and passing H.R. 1741, which the clerk will report by title.
H.R. 1791, a bill to designate the United States Courthouse under construction at 101 South United States Route 1 in Fort Pierce, Florida, as the Alto Lee Adams Sr. United States Courthouse.
The question is, will the House suspend the rules and pass the bill? So many as in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table. The Chair is prepared to entertain one-minute requests. Under the Speaker's announced policy of January 5, 2011, the gentleman from Texas, Mr. Carter, is recognized for 60 minutes as the designee of the Majority Leader.
Thank you, Mr. Speaker. Well, we're all glad to be back in the capital city to talk about the regulations that are drowning our country. And we have got some legislation that's going to try to do something about that. I see that some of my colleagues here are here to join me in talking about these things. I've been on the floor of this House now for the last 18 months explaining to people how these regulations are killing jobs in this country. And really, when it cuts down to what we need to turn this country around, we don't need big stimulus spending. That didn't work. We tried that. We don't need the government to tell us how to run our business. We need the people to be able to run their business with the government getting out of the way. And so we have today several bills that we think are going to be very important to tell us just exactly how we can make sense out of this overwhelming amount of regulations. Thousands of regulations just this year have been proposed, many of which will kill hundreds of thousands of jobs across the country. And I think that I have two of my colleagues that are here. I'll first recognize my friend from Kentucky. I think he has somewhere to go. And tell us a little bit about a solution that you have proposed.
Well, first, thank you, Judge Carter. I appreciate you holding this tonight and your flexibility and allowing me some time to share, as we've talked about before in times on the floor, various aspects of the growth of the regulatory state. And the issue is not being against regulation or for regulation. The issue is having transparency and accountability. We've seen in this administration, in the last administration, the administration before that, an ever-increasing reach in agencies where they're stretching the law, whether it's the Clean Air Act of 1972 that's being stretched to proportions far beyond the original intent of Congress, or issues related to the Clean Water Act that stretch beyond the bounds of science, to unfunded mandates and No Child Left Behind from the last administration. We can think of a wide variety of these issues. And for me, I think the American public wakes up when it hits them in the pocketbook, when it hits you and me in the pocketbook. In our case, you probably experienced the same thing in Texas. The year that I was sworn into Congress, a consent decree was forced upon our local community for nearly $1 billion in stormwater compliance that was not only beyond the needs of the community, it was beyond the economic capability of the community to comply. That was based on a rule issued by an interpretation of a law that had been passed 8 years before in a different Congress, in a different political climate. And again, our citizens, the citizens of the 4th District of Kentucky, citizens of districts across the United States had no recourse but to comply with this. And one of my constituents walked in as we wrestled with different aspects of not limiting regulation, but providing accountability, providing the opportunity for the voters, our citizens, to be able to hold the government accountable for what it does, walked in and said to me, "Jeff, why can't you guys vote on this?" And we had a revelation in a different way to come back and address the issue of regulatory transparency. Standardization is important, but it needs to be at a place that the American people agree with and support and is practicable from the standpoint of cost. And the economic cost is often not incurred in this. We have towns across the United States, across the Ohio Valley, whose compliance cost with just that regulation alone is more than what the budgets of the communities are on an annual basis. It's unreasonable, and there's no recourse. So we went back and we researched and found a portion in the Congressional Review Act of 1995 that we suggested changing. And only one, to the shock of many of my constituents, only one regulation has ever been repealed in the history of the Congress. That was the Clinton-era ergonomics rule that had the House, the Senate, and a president who would sign that. So you have to get, in effect, a majority in the House, a supermajority in the Senate, and then have a chief executive who's willing to change that or to prevent that regulation from going into effect. What we wanted to do was something a little bit different. It's done in industry, it's done in business. You know, in effect, it's done in virtually all competitive sports. If something gets out of bounds or out of expectation, the game stops. In production, the assembly line, the red light comes on, the line stops, and people have to take an extra look at what the issue is. And in this case, what we wanted to do was have a simple process to restore transparency and congressional accountability of what the executive branch does. And that was the genesis of the REINS Act. And it's really a very simple thing. The REINS Act stands for the Regulations of the Executive in Need of Scrutiny. It's House Resolution 10. In this Congress, the number on the chart up there was from the last Congress, H.R. 3765. And basically what it does, it requires Congress to approve all new major rules. The major rule is defined as one that has $100 million or more in cumulative economic impact across our country. What our bill will do is really very simple. Once a rule comes to the end of the 60-day comment period, it would have to come back up to Capitol Hill for a standalone up or down vote under a joint resolution in the House, in the Senate, and then be signed by the President of the United States. And it's making the point that for any major rule, a rule that reaches into the pocketbook of all hard-working, tax-paying Americans, they have a right to be able to hold their elected representatives and senators accountable for the position that they take on that direct economic impact. And for me, I think it's fine. There are times that America will stand up and say, yes, we agree with this, this is the right thing to do. There are other times, particularly in hard economic times like today, the last thing that we want to do is increase that regulatory burden, that out-of-pocket cost on America's citizens. To give an idea of this, the cost in 2009 alone of regulation on our economy for compliance was $1.75 trillion. If that was taken away, some significant portion of that, where the regulatory process was streamlined, that would be creating jobs and more taxpayers ultimately.
If the gentleman would yield back for
Absolutely.
just a moment, let me point out that that $1.75 trillion is more than the entire income tax for that year that was collected by this country. So when you talk about a burden, it's more than the entire tax burden of our nation.
I think the gentleman has a great point. In fact, it comes down, I think, to about $10,000 for every man, woman, and child in the United States of America is the cost of regulatory compliance.
Yield back. Go ahead.
And why it's so critical now, to your point, we've seen agencies in the last administration and this administration who have gone into overreach. But most importantly, what we've seen happen in the last Congress, where there was a Democratic supermajority in the House, in the Senate, with a liberal Democratic president who was out to keep his campaign promises. And I can respect that. The American people spoke in that election, but they also spoke in the election that followed last year that they did not agree with the overreach, be it legislative or on the regulatory side, and made a change, certainly in this body. The administration proceeded at that point to attempt to enact cap-and-trade rules, an energy tax on every American by regulation when the Congress in a Democratic supermajority could not pass those bills to send them to the President's desk. They were intent on doing it by executive order. The same thing that we see happening potentially with the card check, forced unionization bill, could not pass in the last Congress. We see attempts to move that by regulation. There are issues with unfunded mandates on our schools, and even seeing an extension of that inside the Department of Education that further hamstrings already strapped local school districts. That could not get through the United States Congress. We're seeing attempts to do that by regulation. And what the REINS Act would simply do is say, stop, Mr. President, stop, Cabinet Secretary. You have to have the advice and the consent of the representatives of the American people before you're going to move for something that's going to hit us that hard. We have 197 co-sponsors on the bill so far. It's held 2 hearings in the Judiciary Committee. It was passed out of the Judiciary Committee 2 weeks ago. Had a markup in the Rules Committee to go over some technical pieces inside of the bill with the timelines on vote triggers. It's passed out of the Rules Committee, and we're looking for a vote here, hopefully in the very near future, to see it passed and sent over to the United States Senate. But I appreciate what you are doing to champion this move to not only awaken the American people to the huge economic impact of overregulation, but presenting a wide variety of legislative fixes that you and many of our colleagues have authored to stem this tide of reach of the government and to allow our economy to stand up in energy, in manufacturing, and agriculture. And with that, I thank you and yield back.
Well, I thank you, Mr. Davis, for reclaiming my time, and I thank you for the work you've done on the REINS Act. It's good. This is a good bill. This needs to be passed by the Congress. I hope that our colleagues over on the Senate side, when they grab a hold of this, that they get excited about it and realize that regulations impose more burdens on the American people than this Congress does. And in many instances, they come to us and say, why did you pass this law to put this burden on us, when their real issue is they don't understand it was done by regulations by people who were not elected to do, like members here. You know, we have to answer to our boss, and our boss is the American people. And unfortunately, these regulations done by the executive branch agencies, I guess the only boss they have to answer to is the president. But they don't. In many instances, they're designed to be even independent of the president. And some of these regulations are not thought out in the real world, but they're in fact thought out in the minds of somebody that sits at a desk and just thinks this has got to be a good idea. Sometimes these good ideas overwhelm us in cost and quite frankly interfere with our lives. And so we've been talking about this. The American people are talking about it. When you go home, they want to know, what are you going to do about allowing the business people to have an idea of what the playing field is going to look like, because these regulations are changing the rules every time we look up. And I think that leads us into what I think is another excellent piece of legislation that I'm proud to be a part of. Excuse me. But my friend Mr. Riddle is the actual originator of this bill, and I jumped on it with him because it was a good idea. And so I'm going to yield to my friend and let him have a chance to explain this to us and what your idea was and why we have both got into this mess of trying to make it clear for those who would make our economy grow just exactly what the playing field looks like.
Well, I want to thank my friend from Texas. Thank you so much for having me today. You know, I spent my entire adult life running my own business. And so this is something that I've had the opportunity, maybe the misfortune of having to deal with firsthand. And I found it interesting, just a few weeks ago, on October 25th, Politico ran an article and said right here, regulations top issue for small businesses. And in fact, they cite a Gallup poll that indeed 41% of small business owners said that government was somehow related to the biggest problem facing their companies. More small business owners view the cost, I'm quoting here, more small business owners view the cost of complying with government regulations as a bigger problem than any other issue. And I've heard this time and time again. And just recently, I was up in northern Wisconsin, in Rhinelander, Wisconsin, where 3 other members of Congress and myself, we held an all-day session with the timber industry. We invited Chief Tidwell to come in from the U.S. Forest Service to talk about harvesting timber in our national forests. And I had a timber manager come up to me who harvests timber up in Wisconsin Northwoods, and she said to me, Congressman, I want to show you something. If I do a timber sale here that's regulated by one of the counties here in northern Wisconsin. This is the contract that I have to fill out to harvest timber. That's the county contract. And then she said, but you know what, Congressman, if the state of Wisconsin manages that timber sale, the contract gets about twice as long, and I have to manage that contract. But however, if the federal government manages the timber sale, this is the contract that we have to fill out for the federal government. Pages and pages and pages of bureaucratic red tape just to allow them to harvest timber that's owned by the taxpayer. And so I thought, you know what, after hearing a lot of these things and after having run my business, that maybe what this country needs more than anything, and I certainly support Congressman Davis's REINS Act. I think it's exactly the right thing to do. But I want to take it a little step further. And you and I together put together a bill called the Regulatory Moratorium and Jobs Preservation Act. And this bill simply does one thing. It says that the government can't promulgate any new rules until unemployment goes below 7.8%. Because you and I know full well, in talking to all the businesses in our own districts, that unemployment and regulatory environment are connected. They're linked together. Now, I will have colleagues from the other side of the aisle say to me, well, Congressman, you know full well that this is all about demand, that demand is causing the problem, and without demand, people aren't going to hire. And I would say back that every single page of regulation, every single page of trying to comply, every single page has to be responded to by some business owner. And that means that response will have a direct cost to it. As you pile on cost after cost after cost, there have been 24,000 new rules promulgated on the American business owner since 2004, nearly 1 million pages of new regulations. Every single page, page under page after page, adds cost. And every single time the cost of any good or service goes up, there are fewer customers that can afford that product. And so demand must go down. So every time we add a new regulation, costs go up, demand goes down. Finally, we've come to a new end game here with over 9% unemployment. So we wanted to connect our bill to unemployment so that we can show the American people, prove to the American people the empirical evidence that if we would put a hold on new rules and regulations, if we would inject certainty in this regulatory environment where business owners knew what future costs were going to be, they can measure future costs because they know the government won't promulgate a new rule, they will begin to hire again. That new confidence will be there, new certainty will be there, and unemployment will go down. And then here's what I suspect will happen. As unemployment goes down, the American people will demand from Congress that we extend this rule until unemployment reaches 6%, or we get to full employment, as we find this out. Now, this rule does not remove a single safety net. This rule does not remove anything that's already there. I've heard people say, well, you're just trying to destroy the environment, as if I don't want to breathe clean air, as if I don't want to drink clean water, as if I want my grandchildren to swim in lakes and streams that are polluted. It's ridiculous on its face. I want to breathe clean air like every American. I want to drink clean water like every American. I want to eat safe food like every American. And this bill will do nothing to remove any of those protections whatsoever. What it will do, though, is stop the administration from, by executive fiat, creating rules and regulations that haven't been approved by this Congress. It'll stop. You know, I was listening as my colleague from Kentucky was speaking, and I was struck by something. I was struck by this. Article 1, Section 1 of the United States Constitution, it says, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a House of Representatives and a Senate. Now, that word all, 3 simple letters, are pretty inclusive. All. It means all of them. And what the REINS Act does, it says that any rule that gets promulgated, the Congress, the duly elected representatives of the citizens of the United States get to say whether that makes a law or not. We get to say, because the Constitution gave us, the members in this body, the members in the U.S. Senate, the authority to execute legislative power, not some federal agency. And this REINS Act will reel it in. My bill and your bill, Representative Carter, will extend this control by the Congress, and it will simply return the power back to our legislative, duly elected members of Congress. And with that, I yield back.
Reclaiming my time, you just said a magic word that I want to repeat. Responsibility. Our founders designed our form of government so that we defined rights in our Bill of Rights, but it also points out where the responsibility lies. And I would argue that when these creations of regulatory acts, it allows people to avoid being responsible. They pass a law in Congress for the timber industry, and they give the authority to a branch of the executive to write rules to implement that legislation. And it allows this Congress to hide from those regulations. That's one of the reasons I've been talking up here for a year and a half now about regulations. It's time for we all know our rights. It's time for those of us who have accepted a position of responsibility to be responsible. And when an unknown bureaucrat in a cubbyhole somewhere in the vast jungle of offices in this town can write a regulation that affects the very lives of American citizens, and he's going to get his paycheck. Nobody elected him. He's not going to get fired. He don't get run off for writing that regulation. He's been assigned to do rules and regulations. He doesn't take responsibility for it. He's hiding as a bureaucrat back there in the civil service. And it's time for the Congress to step back up based on the articles of the Constitution that you just read and take our responsibility. And then those of us who answer to the people every 2 years and every 6 years, they're our bosses. They're the people that hired us for this job. And when they have one of these regulations, they have somebody they can go to and say, you need to be responsible for implementing the regulatory moratorium and stopping these regulations. They are killing us. Let me just give you some examples real quickly that we've gathered on just some stuff these are current events, okay? This is like looking back at current events for the last 6 or 8 months. EPA greenhouse gas regulations, potential job loss as a result of those regulations, 1,400,000 jobs. New utility regulations, 1,400,000 jobs. Offshore oil and gas lease delays, 504,000 jobs. Offshore drilling permitatorium. They say they're going to introduce permits, but then they just don't ever get right around to doing it. 430,000 jobs. Reclassification of coal ash as hazardous. This affects this area right here, 316,000 jobs. The new boiler regs that are coming out, 60,000 jobs. The Alaska drilling delays, 57,000 jobs. The new cement kiln regulations, 15,000 jobs. Just that little block adds up to 4,182,000 jobs that regulations are going to add to the unemployment rolls at a time when we have got unemployment at 9%. And that, by the way, I like the concept that you introduced and explained to me. Go back to what the unemployment was at the time that this administration came into being, 7.8%. I think that's more than reasonable.
Yeah, would the gentleman yield?
I will yield.
I couldn't agree more. Matter of fact, unemployment has never been lower since the day President Obama has been sworn into office. And I remember, I'm a freshman member here at Congress. I had the privilege, really, of sitting in this chamber for the President's State of the Union address. And the President said in that State of the Union address that he was going to ask for a regulatory review of the executive branch. He wanted to know what they were going to be doing, and he even made jokes about some of the ridiculous regulations. And what we've done now, we've got one more president that has followed the traditions of dozens of presidents who have ordered another study. And in the meantime, the American people suffer while we study something that we already know. This is not so much about whether the government can create jobs. It's about whether the government is obstructing job creation, which is exactly what's happening. And that's why we decided to pick that number. And I yield back.
And I think that's creative thinking. That's basically saying, and we need to get unemployment below 7.8. But it's a good point to start. And it gives us an opportunity to target what I honestly believe, and a lot of economists agree with, that the real solution to this situation we're in with our country right now is to get Americans back to work. The President believes one more stimulus, the last one didn't work, the massive spending, the trillions of dollars of additional debt we've accumulated in the last 3 years didn't quite work. It wasn't quite big enough. We need to do it just one more time, and this time it'll push it over the top. Well, I just don't think that the American people, they're not buying that. They're watching the current events of today, where we loan money to companies that didn't have a concept that was going to pay for itself, and they're going broke. Where we threw money at a problem instead of putting some common sense into the problem. Let a businessman, you nailed it, and you were one, and for a while in my life I was a small businessman. You got to know what's around the corner. You can't hire somebody if there's unknown around the corner, because when you hire them, you get around the corner, you might have to fire them, because that unknown is going to make it to where it's not profitable for you to have this person who you hope will make your business more profitable. They would make it less profitable. People don't seem to understand around here. They think people hire people because somebody gives them a tax incentive, or there's some incentive that somebody gives them some little extra money this month. No. You hire someone to make your business more profitable. It's about prospering in your business. If you don't need somebody to prosper your business, you're not going to hire them. And all the incentives in the world are going to make you hire somebody that doesn't make your business work. Whether you're a little bitty business or whether you're the biggest business in the world. That's the way it works. And so the reality is, as they plan, and you know, there was a time, I read an article on this, there was a time where business planning was relatively short term. And in fact, one of the things that came out of the Great Depression was the concept of long-term planning, both short-term, mid-term, and long-term planning for a businessman, because you needed to know not only what was around the next 2 years or the next 5 years, but you need to know at least around the next 10 years. That's why one of the things when we've got these tax bills we have passed that will just end on a certain date. Well, if you know it's going to end, you got to plan around it. You plan to avoid it, but when that drop-dead date comes up, like we've got on the Bush tax cuts, they call them around here, businessmen are looking at those things and say, what is that going to mean to my bottom line? I don't know, so I'm not hiring anybody. I'm not expanding my business. I'm not building a building, because I don't know what that means. The regulations, unknown regulations in the minds of regulators could change my world, could absolutely shake my world. So this is and right at this time, in this economy, when the number one thing you hear from every businessman you talk to is the unknown, whether it be the new financial regulations which have made financing unknown, whether it be the hidden tax increases in the health care bill, or whether it be regulations that we don't understand and we were surprised to get, we don't know what's going to happen, so we're not doing anything. We're sitting with our hands in our pocket, hopefully a little money in those pockets while we sit there, and we're not doing anything until we know what's going on. That's why this moratorium is perfect. Really? Perfect. We yield back to my friend.
You know, I think there's something salient here that we really need to hit on. You and I believe, as do many of our colleagues, and more importantly, small business owners and large business owners alike, believe that this type of bill will actually increase employment. And the very interesting point about this is it doesn't cost the taxpayer a penny. What this will cause is that businesses who have now been putting their money in the bank and have been holding it because of fear. We will unleash that money back into the sector, back into the private sector, to create jobs and get this economy going, and not a single penny of taxpayer dollars will be expended as a result of this. This is a simple thing. And you know, since the President talked to us back in January, over 70,000 pages been added to the Federal Register. 70,000 pages. 539 rules have been deemed significant under the Executive Order 12866. Stop and think about these numbers. 116.3 million hours of annual paperwork burden being added. And all of this continues to create that uncertainty. Why would you as a business owner spend any money when you have no clue what that future cost will be? And just recently I was talking to some friends of mine in my district at Tilmany Pulp and Paper Company in Kaukauna, Wisconsin, hometown where my roofing company is. And they were sharing with me their concerns about the EPA clean air ruling in a new rule called Boiler Mat. And they said if that rule was promulgated, Wisconsin's paper industry would be decimated. But what's really most troubling is the fact that this is a revision of a rule that they just put in place a few years ago. So the entire paper industry in Wisconsin had to upgrade their boilers, spend millions of dollars of investment, and then a few years later the EPA comes back and said, oops, we made a mistake, we really need to move the bar up again. And rightfully so, these business owners are calling their congressman, and this time it's me, I'm sure you've heard from them in your own district, asking, well, if we spend another $50 million or $60 million, what assurance do we have that the EPA won't move the bar next year? And then we have to spend it again and again and again. At what point is clean air clean air? And that's the problem. And I'll tell you, it would be very simple. When you start talking in the millions and millions of dollars, it is very simple to lose thousands and thousands of jobs. And this is exactly where our national economy is at right now. There has been an onslaught of regulations dumped on the American entrepreneur. Let's talk a little bit about access to credit. You know, I've been very critical about the Dodd-Frank bill. I understand the intent was to get at Wall Street, and I appreciate the intent of getting at the things that caused our economic crisis back in 2008. But what actually happened is it got at Main Street. So small business banks in my hometown of Appleton, they are now spending money and investing money hiring regulatory analysts when they ought to be hiring commercial lenders. You know, most jobs created in this country are created by small businesses. But in reality, it's really small businesses under 5 years old, businesses that need access to credit. I often wonder, would somebody like Steve Jobs be able to emerge in this type of environment today, building computers in his garage? I'm sure there's some rule against that now, and you can't imagine. I chuckled the other day when I saw a famous television host on MSNBC standing with her hard hat by the Hoover Dam, saying, we need big projects like this. We need big thinking like this. You know, Franklin Roosevelt ushered in these great programs to create jobs and generate energy. This was the boom day of the American mind. And I had to chuckle, thinking there'd be no way with the current EPA that you could ever build the Hoover Dam today. It just wouldn't happen. The environmental rules alone wouldn't allow for it. And I yield back.
Absolutely, you'd be dealing with the EPA, you'd be dealing with fish, you'd be dealing with the situation on endangered species, and that's clear down to the microscopic animals that you can't even see. All that, there's no way the Hoover Dam would get built like that. You know, there was a thing on History 2, I guess it was night before last that I watched, about building of the Alaskan Highway. And we had gone to war with Japan, and everybody looked at the United States and said, my gosh, the Aleutian Islands, a part of the Alaskan, that time Alaskan territory, they're right close to the Japanese, and they're probably going to invade those islands. And how are we going to get materials, supplies, and men up to Alaska? There was no road between the United States and Alaska. Nobody checked a single regulatory act. Nobody did anything but say, get every bulldozer we got and head for the border. We're cutting the road straight up through Canada. We'll design it all the way up there. We'll direction it on the way up there. And they took off and they built a road. It was a gravel road, but it was the first road that connected the lower 48 to Alaska. And I looked at that thing and I said, my gosh, they wouldn't have gotten a mile and a half before they'd have been enjoined by every kind of group on God's green earth in this country under the present regulations we have in place, not even expanded regulations, which are getting worse, the present regulations. So when the President made that famous statement now that I enjoyed very much, he laughed and said, I found out that shovel-ready today is not really shovel-ready. And it's exactly the same regulations we're talking about here that keeps it from being shovel-ready. We're building about a 21-mile stretch of highway in my home county, trying to build one. We've been at it for 8 years. The money's in place. Section 1's got bulldozers sitting on the ground because Section 1's been approved, and we're still trying to get 21 miles of road built through regulations. I will say now, after a little work on our part, some regulators are being pretty reasonable, and we want to thank them for it. But the days of the Hoover Dam and the Alaskan Highway will never come back, not with the regulatory environment we have here. What we're trying to do is not let this thing expand any farther. We're not trying to kill species. We're not trying to mess up the air, like you said, or the water. We're trying to say we've got a good situation in place. And by the way, Mr. President, if it's a national security issue or a national emergency, submit it to us. Tell us what the emergency is. Let's visit with it. If that's the case, this Congress will be reasonable. I think that's very. If we need review of the courts and the individuals need review of the courts, we provide that in here. It's very respectful of other people's considerations on these rights. That's another. For a small bill, there's a lot of good thinking in this bill. And those are the things I want. Let me just read you something. This came out in the Columbus Dispatch. Okay, this is a quote from the President's regulatory push has usurped, paralyzed, and blocked the private sector decision making necessary for job creation. Decision making it is a dash. Obama's massive intrusion into the heart of the nation's economy have not helped. Buying auto manufacturers and running roughshod over bankruptcy laws and investors' rights in the process, taking over a sixth of the economy devoted to health care, imposing new regulatory regime on the financial sector, and spending hundreds of billions of borrowed dollars with no great benefit. Add to this the recent actions of the Democrat-controlled National Labor Relations Board. Perhaps its most damaging move has been to bring legal action against aircraft manufacturer Boeing Company for building a manufacturing plant in South Carolina. The NLRB seeks to punish a company for creating new jobs at a time when unemployment is more than 9% and the nation's economic growth barely registers. The chilling effect on other companies that are consuming the ideas of building plants is incalculable. These moves have cowed, usurped, paralyzed, and blocked the private sector decision-making that is necessary to get this nation moving again. That's a quote from the Columbus Dispatch, 9/5/11 this year. And that's a perfect statement of a big picture of the regulatory burden that's made the papers. But you can have just as much trouble with one bug. So we've got to, as we deal with this, we've got to have something that says King's X until we get this economy back rolling. And I will once again yield to my friend. And you tell me if you got other things you want to talk about.
Yeah, thank you for yielding back. I just thought it'd be interesting. The President was in here just a few weeks ago with his jobs bill, and I was struck. I actually came into the chamber, and with the intent of not really being critical, but to try to find out what is it that we could agree on, so we could maybe, for the good of the American people, move those things forward. But I'll tell you, I was struck that the President didn't mention energy a single time. Now, we've just lost millions of jobs in the energy sector. Just recently, the President decided to punt on Keystone, the Trans-Canada Pipeline, which would have created thousands of jobs, by even the lowest estimate, thousands of high-paying union jobs. Fully, labor was supportive of it and decided to kind of punt on that and not let jobs. It seems like the President's jobs plan is really at the regulatory agencies, where since he's been sworn into office, employment has increased 13%. While the private sector is shedding millions of jobs, the President has decided to hire thousands of people at federal regulatory agencies. And I guess it's maybe so that they can implement the 3,573 new rules that have been put in place since January 2010. You know, we have to get to a place where we understand the connection between employment, the connection between costs and jobs, and just American competitiveness. How in the world can we have businesses compete in this day and age when there's a constant onslaught from the federal government? I just thought I might read a quote from CNBC. We asked several CEOs leading up to the speech, the President's speech, what bold steps President Obama could take to reduce the 9.1% unemployment rate. John Schiller, Chairman and CEO of Energy 21, said, if the government would get out of the way from a regulation standpoint and let us 21 do what we do good, you'll see us continue to hire and grow this economy. I think that's a message from across the board, said Schiller. And I believe it is a message. For some reason, it just doesn't seem like the executive branch fully understands how this economy actually works. Obstacle after obstacle after obstacle, layer upon layer of new rules and regulations, and each one of them hurting job growth and employment in this country. David Park, President and CEO of Austin Capital. Regulations have companies running scared. They're coming at businesses, and some new regulations are already taking a toll, while others will soon. This could be a real deterrent to future entrepreneurs. And since most jobs are created by entrepreneurial companies under 5 years old, the difficulty of actually even forming and starting a company today is burdensome. It's hugely complex, all because of this endless stream of control and regulations, as if Washington, D.C., as if you and I, Judge, have all the answers. We don't have the answers. The answers are found in the private sector. The answers are found in the citizens of this great country. Recently, we passed a bill just the other day on ballast water. And I sit on the Transportation Committee, and I noticed while reading the bill that the federal government was going to promulgate rules for ballast water for ships that come into the United States and traverse throughout the Great Lakes. Now, my home is in Appleton, Wisconsin, just near Lake Michigan, just south of Green Bay, Wisconsin. We have the Port of Green Bay there. And the concern was, as I was reading the bill, that the federal government exempted themselves, that they were creating a whole new level of bureaucracy, red tape, and rules that they were going to promulgate on private shipping companies, but not on themselves. So a federal science ship or EPA vessel could traverse the whole globe and not have to manage ballast water the same way that everybody else did. So I added an amendment, and this body passed it, that said that if the federal government's going to promulgate rules on private shipping companies, they have to live by those same rules themselves. And it's high time that the federal government begins to treat the government the same way they treat the private sector. And I think if we start doing that type of thing, some of these problems will begin to go away, and I yield back.
That's good common sense. Thank you for doing that. We appreciate it. Congressman Ribble, I understand you have some support for this bill in the Senate. Would you like to tell us a little bit about that?
Yes, there's a companion bill that is going through the Senate right now. It's the identical piece of legislation. It was crafted by Senator Ron Johnson, a colleague of mine from the great state of Wisconsin. We thought, you know, it'd be good for us to do a project together, and we talk quite often. And the idea of attaching the moratorium to unemployment was Senator Johnson's idea. I thought it was a terrific idea, and he now has a companion piece of legislation. He told me that there's more than 20 co-sponsors in the U.S. Senate. This bill now has over 70 co-sponsors here in the House of Representatives, and it continues to move forward. I'm very optimistic that we're going to be able to pass this bill through this chamber and send it on over to the United States Senate, where I hope reason will rule the day, that they will see this doesn't remove a single safety, doesn't restrict any safety or put something out of the way that's currently in place. It just said, let's give the American entrepreneur, the American job creator, some breathing space. Let's give them some room to just have some certainty for the time being until unemployment starts to get going and the engine of our economy starts moving again. And I hope that, and I challenge the United States Senate, that after we send this piece of legislation over to them, that with most haste that they go ahead and pass it. And if they can't pass it, let's for sure let the U.S. Senate have a chance and the members of that chamber to vote on it. You know, they kind of have a method over there where they can protect members from having to make tough decisions. You know, they just table a piece of legislation and don't even vote on it. And I would challenge the Senate Majority Leader that when we send H.R. 2989 over there, that they would actually bring it to a vote, and let's have our U.S. Senate stand up and say whether they agree with this or not, and have them go officially on the record about whether they believe that regulations are a problem in this economy or not. And I yield back.
And when the American people hear that once again we've got over 20 bills that could have done something to turn this economy around that have been tabled, I hope they will ask themselves, why did the Senate table my job? Okay? Because everything's about jobs. When you table a piece of legislation, you're tabling somebody's job. One of the things that a lot of people don't understand, and that's just because they don't think about it. Once they start thinking about it, they can understand it. That they hear something like the pipeline. I happen to spend every summer of my life, from the time I was 15 until I graduated from law school, working on pipelines. I have worked in pipelines in Texas, Louisiana, and overseas in the Netherlands, in Europe, and in Belgium. So I'm an old laborer on the pipeline. When you hear pipeline, you think the pipeline of the pipeline, but you don't. The number of people involved in laying a pipeline and the number of assorted jobs you don't even think about that are involved in that are overwhelming. You got, in many instances, you've got to cut roads out to where the pipeline's going to be there. So you've got road builders involved. You've got gravel haulers. In some instances, asphalt layers, if the farmer will let you. You've got the pipe. The pipe industry's making pipe. The welders are welding the joints. The people that are surveying the project. The heavy machinery is digging the ditch. Many individuals are cleaning the ditch with hand shovels because it's got to be a certain way, or you get a process which can cause the pipe to have an electrical charge on it. Their engineers are engineering it. Scientists are studying it. People who are the product that's going to flow down that pipeline is being tested so that you see what stress levels you're going to have. It creates jobs, not just a pipe, but there's hundreds and hundreds of industries that are tied to just laying a pipeline. If you're drilling an oil well, the same thing. People, with those offshore drilling rigs, you know who got hurt bad on that? The guys that feed those people out there on those rigs. And the helicopter pilots that fly the food out there. I mean, these people, it shut down restaurants and closed down helicopter businesses in the Gulf Coast when we stopped moratorium on that. We forget those little guys that are providing those services to the big Exxon Mobil or something platform out there. But in reality, there's thousands of small businessmen connected to any major project like this. A minimum number of jobs for that construction on that pipeline that's been estimated is 25,000 jobs. I can tell you, unless the world has changed a whole lot since I was a kid, it's the best paying job for a laborer that I could find in the state of Texas for a kid my age. And I worked until I was 26 years old on those things in the summertime. And it still was the best paying job for a part-time job I could find anywhere in the state of Texas, or even better in Europe. So the point being that there is a domino effect when there is a big project like this, or the lumber industry you were describing in your state, or the shipping industry on the Great Lakes. It's not just ships that are involved in the shipping industry. It's hundreds of other professions are involved in the shipping industry. And when we start thinking that concept, and we see when you go out and hit the big guy, people around this country have got this idea that big people are bad, big things are bad. And they don't realize that it takes hundreds and sometimes thousands of little guys to keep the big guys' project going. And they're all making a living, and they're all raising their families and having their homes based upon that project. This is the concept of what capitalism does and free enterprise does for our country. And when the regulators stop something like that pipeline, or when they put a moratorium on it until after the election, so you don't have to talk about it during the election time, that hurts little guys as well as big guys. And it's a wrong concept. We've got to make this country once again prosper. And it takes a lot of things to make it prosper. So we're just asking for the government not to be one of the hindrances. And I think that's what makes this a great bill. I want to thank you for joining me. We're just about out of time, and I want to thank you for joining me and explaining the bill and allowing me to be the original co-sponsor with you on this bill so we can work this together. I will do everything within my power to assist you in getting this bill to this floor and pass through this House, and hopefully Senator Johnson will get it done over in the Senate, and we'll help him where we can. And it'll be good for America to say, time out on these regulations. Unless you have something further to say, Mr. Speaker, I'll yield back the balance of our time.
Under the Speaker's announced policy of January 5th, 2011, the gentleman from Texas, Mr. Gonzalez, is recognized for 60 minutes as the designee of the Minority Leader.
Mr. Speaker, thank you very much. And I first want to start off by asking for unanimous consent that all members may have 5 legislative days in which to revise and extend the remarks and include extraneous material on the subject of my special order tonight.
Without objection.
Mr. Speaker, again, thank you for recognizing me, and I thank the Democratic leader, Ms. Pelosi, for giving me this time. I thank my colleagues for listening and for joining me in a few minutes. But I am also very sorry to be here in a certain respect. I'm sorry because I stand here tonight to talk about threats to the right of American citizens in states across this great country to go to the polls and cast a ballot in our elections. The single most fundamental aspect of our democracy, or any democracy, is the right to vote, and that right is under attack. Mr. Speaker, there is no right mentioned more often in the Constitution than the right to vote. In the past 207 years, we have amended the Constitution 15 times. 7 of those amendments, almost half of the amendments over the last 2 centuries, are about protecting, in the words of the 14th Amendment, the right to vote. Minorities, women, adults over 18 years of age, poor citizens, and of course citizens of our nation's capital, at least if only for the presidential election, all of these groups' right to vote has been enshrined in our Constitution. That's why it is so troubling to see dozens of states passing laws that will make it harder for citizens of the United States to vote. Whether by denying them the opportunity to vote after church on Sunday before the election day, perhaps because they cannot take time off work on Election Day, or requiring them to spend time and money to procure a birth certificate and a photo ID. The only thing that these laws will do is to weaken our democracy. They are just plain wrong. Hopefully I will be joined by some of my colleagues, but I do want to spend a little bit of time explaining to the American public and to my colleagues what this is all about. And I am going to start off by the photo ID voter requirement, and which is being passed, obviously, out of the legislature in the state of Texas and to be enacted for the 2012 election. What is it exactly? Well, people will say, you mean you just have to have a photo ID. It is not just any photo ID. It has to be one that meets all the requirements of a particular state's laws. So you would say, well, how onerous could that possibly be? As I've said, it is just not any government-issued ID, photo ID, that will be accepted on Election Day. It has certain requirements. So, much to my surprise, I recently found out that basically my identification and my voting card that all members of Congress use would not be sufficient, would not meet the requirements in the great state of Texas. But it should not come as any surprise, because if you are a veteran and you have a photo ID that allows you to go to the Audie Murphy Memorial Veterans Hospital in San Antonio, Texas, in my district, that photo ID will not suffice under Texas law. If you're a student in one of our state-supported institutions that has your photo on there, has your name, all that information, that is not going to meet the requirements in the state of Texas. So you would ask, why would we pass these laws? What is the need? What is the requirement? Because we all know, whether you're in the state legislature or in this great House of Representatives at the federal level, we don't pass unnecessary laws. So there must be a purpose behind these photo ID laws, as well as other laws that are restricting the rights of individuals to exercise the right to vote. It is to stop fraud. The photo ID, its whole purpose is to stop people from impersonating an eligible voter. Now you would say, so that must be happening across this great country, and that's why we need this law. People are impersonating other people. People are impersonating other people. People that shouldn't be voting might be impersonating an eligible voter. So let's discuss that, the reason for the photo ID in these many states. I'm going to give you the example of the state of Kansas. The Secretary of State pushed an ID law on the basis of a list of 221 reported instances of voter fraud. This all is supposed to have occurred in Kansas since the year 1997. So from 1997, for about 13 years, there were 221 reported instances of voter fraud. When the newspaper, the Wichita Eagle, looked into the local cases cited by the Secretary of State, they found almost all of them were honest mistakes. None were attempted to be perpetrated by someone impersonating someone who they were not. A great example of that, and I have to read you the excerpt from the Wichita Eagle of October 29, 2010. Republican Chris Kobach, who has built his campaign for Secretary of State around the issue of voter fraud, raised the specter of the dead voting in Kansas. Kobach said in a news conference Thursday that 1,966 deceased people were registered to vote in Kansas. Quote, every one of those 1,966 identities is an opportunity for voter fraud waiting to happen, he said. Furthermore, he said, some were still casting ballots. Dead people in Kansas were voting. He gave an example of one person, Alfred K. Brewer, a Republican, registered in Sedgwick County with a birth date listed of January 1, 1900. Brewer, according to the comparison of Social Security records and the Kansas voter rolls, had died in 1996, yet had voted in the August primary, and that was the allegation. Reached Thursday at his home while he was raking leaves, Brewer, age 78, was surprised some people thought he was dead. Quote, I don't think this is heaven, not when I'm raking leaves. Those are example after example. No one can give you a specific example of voter fraud based on someone impersonating someone who they should not be on Election Day. Now, between the years 2002 and 2007, a major Department of Justice at the federal level, of course, had a probe into voter fraud. The result was failure to prosecute a single person for going to the polls and impersonating an eligible voter. Zero prosecutions. After tremendous amounts of manpower, time, energy, and money, nothing happened. Now, the Brennan Center for Justice, the cases for voter fraud. What is it? So if you have a law that is addressing a particular offensive type behavior that obviously hurts this great republic of ours, such as voter fraud, surely we must have demonstrated, tangible, verifiable cases out there. But the New York Times, in an editorial, I should say the Washington Post in an editorial, was looking at the number of alleged voter fraud. And these are not all predicated on voter ID. It could be some other type of fraud that's being perpetrated. But if you took all of the cases that have ever been alleged, this is the percentage of the total vote cast of those that might be suspect. Because you've got to remember, there's going to be a price we're going to pay for this law. And that is it's going to disenfranchise the eligible voter in pursuit of the phantom illegal voter. In Missouri, if you took all of their complaints, it would amount to, when compared to the total voter turnout, to 0.0003%. In New York, it would amount to 0.000009%. In New Jersey, it would be 0.0002%. So where is the voter fraud? What are we trying to address in passing these laws by the different state legislatures? We had a recent occurrence, and this was not even a voter ID case, but this is where the Secretary of State in Colorado, Mr. Gessler, was dropping voters from the voting list and not forwarding ballots for voting based on that particular voter not having voted in 2010. Didn't matter if they voted previously that. If they did not vote in 2010, then they were dropped from the rolls. And what was the reason for that? Well, there's potential voter fraud. Potential voter fraud. But they could not, that Secretary of State, when they finally went to court, could not address, could not demonstrate, could not offer into evidence one case of voter fraud. Not one, based on his suspicion or conjecture. In 2006, in the great state of Texas, my home state, the Texas Attorney General had a press release, and it was entitled, Let's Stamp Out Voter Fraud in Texas. Sounds good. Sounds like a good thing to do. He could not name one, not one single case of fraud that would have been stopped by a voter ID law in the state of Texas. I see that I've been joined at this time by one of my dear colleagues, and I'd like to recognize him, and I would yield at this time to my colleague, the great representative from the great state of New Jersey, Rush Holt, and as much time as he needs to consume.
I thank my friend from Texas, and I thank him very much for setting aside some time for this important issue. You know, more than a century ago, the Supreme Court described the right to vote as the most fundamental right in our government because it is the preservative of all other rights. Indeed, that's true. And many years later, half a century ago, President Lyndon Johnson said that, quote, "The vote is the most powerful instrument ever devised by man for breaking down injustice." The vote is the lifeblood of self-government, and it's one of the most powerful ways that citizens can effect change. The integrity of the electoral process is fundamental to ensuring that the voice of the people is heard. I often say that a self-governing country such as ours works only if you believe it does. And we must make sure that every American knows that every vote counts, that every vote will be counted, and that, you know, recognizing how complicated, it's not as simple as we would all like to believe, how complicated it is that we at the federal level and at the state level are doing everything we can to protect the franchise, to protect the franchise of each citizen to cast his vote. And it's not just that we want to protect this as a right, It's something we should desire for the sake of our country, that we get the diversity of opinion. Well, what's happening right now is in state after state, there's legislation that's intended to exclude some opinions, exclude some individuals, exclude some groups. Of course, this is something this country has seen in the past and worked diligently, yes, through federal law, to correct. It was known as a poll tax. There were also literacy tests, quite clearly intended to exclude African Americans from not just their right to vote, but from their obligation and their privilege of voting. What happens if laws are enacted to diminish the integrity and the accessibility of the ballot box for particular sectors of society? What happens if those disenfranchised voters typically vote for candidates representing one party? Well, I came of age in the throes of the civil rights movement, when our colleague, Representative John Lewis, then a young man who had been tapped by Martin Luther King Jr. to become a leader in the movement, was beaten. I often say he's the only member of this chamber who had his skull cracked literally to try to earn the right for everyone, every citizen, to vote. In the aftermath of those bloody confrontations, Congress said there is a role for the federal government. The Voting Rights Act of 1965 was passed, and it's made an enormous difference. But we can't sit back. We can't rest. Because right now, in state after state, there is effort to exclude some people. It is, if you require people to jump through a lot of hoops, maybe not a lot of money, but spend some money, to me, that's a poll tax. That is illegal, unconstitutional. We thought we had gotten away from it. We thought we had gotten away from so-called literacy tests, where people had to jump through some hurdles, truly unreasonable hurdles, in order to vote, where prospective voters were quizzed to ask, well, how many bubbles are there in a bar of soap? Hurdles that could not be crossed. Well, you know, it sounds reasonable when you say you don't want anyone with who's not eligible to be showing up to vote. But where are those people? In state after state, these ID requirements are put in place to deal with a problem that doesn't exist. And millions of Americans are being excluded from voting in order to deal ostensibly with this problem of fraud at the polling place. Now, I don't doubt that in some ways, subtle or otherwise, there is some fraud. But I have not heard of a single immigrant coming across the border, walking through the desert of our southern states so that they could sneak in and cast a ballot someplace. There are tough laws and severe penalties for people who vote fraudulently in the name or address that is intended to deceive. But very few people have been caught doing that. There are very few examples of prosecutions or apprehensions, or for that matter, even suspicions of this happening. And yet, all of these laws that are being passed are ostensibly to deal with that problem. It's a problem that doesn't exist in nearly 5 million Americans, by estimates from such people as the Brennan Center of the Law School of NYU. 5 million people might be excluded from this. So I thank my friend from Texas for engaging in this discussion tonight. Indeed, this is the right that preserves all other rights. What could be more important? It is cynical, it is disingenuous, it is un-American. What people are doing in a very systematic way to exclude large groups of people from voting, to solve a problem, an imaginary problem that's been trumped up. I believe it's been trumped up just so that they could exclude large numbers of people from voting. So I thank my friend for raising this critically important question, and I yield back my time to Mr. Gonzalez.
I thank my colleague from New Jersey. I appreciate his his words of encouragement here to address what is going on in this country as we speak. And as a matter of fact, there are other laws that are awaiting legislative action in different states. I return still because I think people have a legitimate and good faith question about what are these laws supposed to address, and it's supposed to be about fraud. Mr. Speaker, let me address the claim of fraud once more. There is no voter fraud that is going to be stopped by denying a 96-year-old woman in Tennessee her voter ID card because her last name doesn't match the name on her birth certificate and she doesn't have a copy of her marriage certificate showing the change. There is no voter fraud that will be stopped by denying Floridians the right to vote after church on Sunday before Election Day. Is that because there's no fraud? Not really. Fraud isn't about voters going to polls when they're not eligible. It's about the two individuals in the state of Maryland who were indicted earlier this year for organizing deceptive robocalls to keep voters from the polls. It's about the robocalls last month in the state of Ohio telling people that the election was on a Wednesday. This is about the group in Houston, Texas, that just hosted a man who said that registering the poor to vote is un-American and, quote, like handing out burglary tools to criminals. That's the fraud that's really perpetrated on Americans today. It's an old story of keeping people away from the polls when we should be encouraging them to vote. These new voter ID laws and law curtailing early voting or Election Day registration won't stop this kind of fraud. And the kind of fraud that would stop simply does not exist. The previous administration, as I noted earlier, nearly broke the Civil Rights Division of the Department of Justice in its quest to find this kind of voter fraud that voter ID would stop. They couldn't find any because it does not happen. But these laws will have a powerful effect. They will deny millions of Americans the right to participate in this democracy. So we know what the law is. We know what it is intended to address, but doesn't really exist, which is that kind of fraud. But what is the cost? Mr. Speaker, all of us in this chamber understand that when we pass legislation, we always look at the cost-benefit aspect of it. In other words, does the good really outweigh the bad? Is it worth the investment? Because there's going to be some consequence. In this case, it would not pass any kind of scrutiny if we really look at what it's going to cost Americans and how it's going to benefit Americans. Now, the NAACP, in a November 1st of this year brief, cited the following information. 11% of eligible voters in this country, 11% of eligible American citizen voters, 21 million strong, don't have updated state-issued photo IDs. So who's going to be impacted? potentially 21 million eligible American citizen voters. But of that 21 million, 25% will be African Americans. 14% are families or individuals that earn less than $35,000 a year. 18% will be seniors over the age of 65. But even 20% will be individuals between the ages of 18 and 29. So I was asking a colleague, why do we do the analysis? What is the benefit and what is the cost? And many times we'll say, well, the cost is beneficial because it's worth that kind of investment if we get any kind of return. But let me point out the fallacy of these laws when we actually apply the test. Because when we talk about numbers, there are mere numbers in the abstract, but these are real American voters that will be denied their right to vote when they go to that polling place and are informed that they need a state-issued photo ID. There is no more fundamental right than that of voting, and if a barrier that stops 1% of the people from voting is not acceptable merely because 99% of the people are still able to vote. Think of that proposition. You simply are saying, well, if we just deny 1%, 2%, 3%, or 5%, you still have 90-something other people, percent of the population, of the registered and eligible voters, that are still going to be able to vote. But think in terms, if that was your vote, if that was a family member's vote, every vote is precious in this country. And there is no evidence to support that what you're addressing is a widespread problem that will disenfranchise many, many thousands, hundreds of thousands, and even millions of American voters. That's what we're facing here today. That's what the analysis showed. So even the lightest of any scrutiny would show that this is ill-conceived. It will not produce the result that you're seeking because the problem that you're trying to remedy does not exist. But there's a price that will be paid, and the price will be paid by many, disproportionately seniors and minorities and those that may not be in the upper economic scales of this country. At this time, it's my honor, of course, to yield as much time as he may consume my colleague from the great state of Florida, who can tell us many things about the Florida experience, Congressman Ted Deutsch.
Well, thank you. Thank you very much. I thank my friend for yielding, and I thank you for the opportunity to come and join with you tonight to address an issue of great concern to many Americans. We're here tonight because Republican state legislatures across the nation are passing laws that make it harder for people to exercise their right to vote. The story they tell is one of rampant voter fraud that threatens the integrity of our elections and the very foundation of our democracy. It's a scary story. Imagine, just imagine, mobs of illegally registered voters entering our poll booths and hijacking our elections. However, there is something far scarier than the story that's being told, and that's the reality. It's the reality that our electoral system is not under siege by voter fraud, but instead by an historically deliberate and ongoing effort to suppress the votes of America's minorities, seniors, students, and other traditionally Democratic voters. Now, while this is a nationwide trend, there is no question that the recent voting law passed in Florida takes the cake for radically infringing on voting rights. Ask any Floridian. Florida doesn't have a history of voter fraud. Florida has a history of voter suppression. This is a state that didn't ratify the 19th Amendment guaranteeing women the right to vote until 1969. This is a state where in 2000, Secretary of State Katherine Harris eliminated 57,000 votes, mostly minorities, simply because their names resembled those of persons convicted of crimes. They were wiped from the voting rolls. Now, our current governor, Governor Scott, wasn't in Florida in 2000 when George Bush's legal team fought to stop counting the votes, when Katherine Harris certified election results without including the recount from my own Palm Beach County, and when the Supreme Court stopped a manual recount of votes. Florida is the state where thousands of seniors I am so privileged to represent today headed to the polls on Election Day in 2000 and never had their voices heard. That was hard work. It was hard work silencing the voices of the voters. HB 1355, the Florida election law, the voter suppression law, makes it child's play. Florida is the state where in 2008, when Governor Charlie Crist extended early voting hours, Republican officials decried the fact that better access to voting would likely cost them the election. And now, Florida is the state that is serving as a model for Republican legislatures across the country, looking for ways to suppress turnout at the polls. HB 1355 eliminates the ability of voters to update their addresses or names at the polls due to marriage, divorce, or even military base relocation. Those voters now have to cast provisional ballots, which will likely go uncounted. HB 1355 also cuts early voting from 14 days to 8, because the fact that the United States of America is one of the few democracies in the world to not to declare Election Day a national holiday simply is not restrictive enough. And HB 1355 allows absentee ballots to be arbitrarily tossed out of elections because of poor handwriting. The men and women I represent who may suffer from Parkinson's disease or arthritis or the after effects of a stroke will have their votes thrown out because their quivering hands make their signatures look sloppy. And perhaps most disturbing is how HB 1355 cripples the ability of third-party groups like the Boy Scouts, the League of Women Voters, and the NAACP to run voter registration drives. In fact, any third party, including high school civics teachers that offer to help students register to vote, must turn in registration form within 48 hours or face fines. By passing HB 1355, Florida has provided states across the country with a blueprint for voter suppression of minorities, seniors, students, and other Democratic voters. The voter fraud boogeyman may be a scary story, but it cannot compare to the very real and very blatant voter suppression efforts of Republican legislatures across America, perhaps because they know they can't win fairly. They need to suppress voters not because of imaginary voter fraud, but because of real Americans. Real Americans who have seen the true colors of a Republican agenda that ends Medicare, slashes education, eliminates jobs, and limits economic opportunity for working families. Real Americans have had enough, and they have the right to express themselves by exercising the most basic, the most fundamental right in our nation, the right to vote. I thank you for organizing this opportunity tonight for us to make very clear to all who are watching that we won't let them take that right away. And I yield back.
I thank my colleague from Florida, and this time I would yield to dear friend and colleague, also from the great state of Florida, Congresswoman Debbie Wasserman Schultz, for as much time as she may consume.
Thank you. I thank the gentleman for yielding. Congressman Gonzalez, it's really wonderful that you've organized this opportunity to have members come to the floor and highlight our concerns and our commitment to protect the fundamental right and the very bedrock of our democratic principles, the right to vote. I'm pleased to stand with so many of my colleagues who all share my deep concern over the organized, insidious effort now underway in many states to disenfranchise millions of Americans and silence their voice in our democracy. These efforts are purported to combat so-called rampant voter fraud, yet no investigative effort to date has found voter fraud to be a major problem in our nation, so no one should fall for this ruse. Every American should understand and be concerned about the political disenfranchisement that is going on in many states, including my home state of Florida, as my colleague from Florida just outlined. State legislatures are attempting to impose voting restrictions that are the modern-day equivalent of poll taxes and literacy tests. Now, let me be clear. The foundation of our participatory democracy, our democratic society, is rooted in the right to vote, the right to choose our elected leaders, to have representation in government, to have input on the major policies of the day, the right to have our voices heard. That's why more than 250 years ago, we threw off the shackles of the British Empire that denied American colonists representation in Parliament. The fight toward universal suffrage has been long and arduous, but it is a fight worth fighting. As May Wright Sewell, a leader of the women's suffrage movement in the 19th century America, said, "Universal suffrage is the only guarantee against despotism." Just as those who came before us have fought to gain and retain the right to vote, we too must stand vigilantly against those who seek to limit it. Each time I cast a ballot, I'm reminded that it is a right not to be ignored. Less than a century ago, the women who came before us were denied the right to have their voices heard. Women during that time were confronted by a wealth of arguments against our right to suffrage. Women do not want the vote, or women are already represented by their husbands, or, one of my favorites, a woman's place is in the House. Well, I would agree with that last statement if we're talking about the House of Representatives, with the note that a woman's place is also in the Senate, the governor's office, and in all seats of government. The women who fought for my right to vote were beaten, jailed, ostracized, and tormented, and still they kept on and persevered because they knew that women of our great nation should not be deprived of this fundamental right. So no, we will not stand by and allow anyone's voting rights to be threatened, not on our watch. And many of our colleagues also know this fight too well. Despite the passage of the 14th and 15th Amendments giving citizens equal protection under the law and the right to vote regardless of their race, African Americans still faced more than a century of overt voter suppression. And while we made huge gains with the Voting Rights Act of 1965, a seminal moment in our nation's history where we declared that truly no election law can deny or abridge voting rights because of race or color, we cannot afford to sit back and just declare the fight over. The struggle for universal suffrage is not over. We cannot allow state legislatures to drag our nation backward in what is nothing more than a political quest to protect their governing majority's interests. A little more than 10 years ago, Florida experienced Election Day turmoil that reminded us all how important it is to remain on guard against disenfranchisement. The many irregularities that occurred in my home state during the 2000 elections were a painful reminder of how rights can be denied. The Commission on Civil Rights report on the 2000 election in Florida found widespread voter disenfranchisement. As Commissioner Chairperson Mary Frances Berry stated at the time, and I quote, "It is not a question of a recount or even an accurate count, but more pointedly the issue is those whose exclusion from the right to vote amounted to a no count. In the last year, scores of states, including Florida, have passed laws restricting access to the polls. A recent Brennan Center report found that these changes in state voting laws will likely suppress the vote of more than 5 million voters nationwide. We need look no further than my own home state of Florida to see the threat against universal suffrage. The Florida law passed last spring restricts both voter registration and voting opportunities. It was championed by Governor Rick Scott and passed by the Republican-led legislature, which has overwhelming majorities in both the House and the Senate. First, it restricts the ability of nonpartisan organizations or individuals from helping citizens register to vote. It fines people and groups up to $1,000 per voter if registration isn't turned in within 48 hours. Just the other day, a teacher was sanctioned and is now being prosecuted because she didn't turn in her students' voter registration within the new amended time frame that voter registration cards have to be turned in, and now she is being subject to a fine, a significant fine, per voter. As a result of this law, the League of Women Voters, a champion of nonpartisan voting rights for over 7 decades, has suspended its voter registration operations in Florida because they can't take the risk that they would be bankrupted by this absolutely unfair, terrible law. Second, the Florida law rolls back early voting. It rolls back early voting opportunities, including the Sunday before an election. It eliminates voting on the Sunday before an election, and I can tell you firsthand how important weekend early voting is for the thousands of seniors who live in my district and for millions all across the state. Also in 2008, African Americans and Hispanics, who together make up roughly 1/4 of Florida voters, accounted for more than half of all voters on the final Sunday of early voting. So do we think it's a coincidence that that group of voters, which voted overwhelmingly for Democratic candidates, now suddenly has their right to vote on that particular Sunday removed from them? As far as we've come in our society in broadening the scope of civil rights, we cannot afford to revert back to a time when it was acceptable to limiting rights of a select few. We are not meant to have a government of some people, by some people, for some people. I hope my colleagues will join me in ensuring that we uphold President Abraham Lincoln's democratic ideal of government for all the people, elected by all the people. Thank you, Mr. Gonzalez, for the opportunity to speak tonight, and yield back the balance of my time.
Well, I thank my colleague from Florida. At this time, Mr. Speaker, I'd like to enter a colloquy with my colleagues from Florida and New Jersey, and I guess I'm just going to pose the question is, so what if just a few people are denied access to the ballot box? It's just a few, and after all, we're trying to see if there's any kind of provable, tangible fraud going on. Now, they haven't been able to prove any fraud based on identification, of course, but you pointed out in your remarks what happened in Florida in 2000. How many votes in Florida actually determined who was going to be President of the United States of America?
537.
And we've already touched on it, that estimates of how many millions of eligible American citizen voters don't have a current state-issued ID. In the millions. And in Florida, it was less than 600 votes. I don't know the experience in New Jersey, but it would seem, and I went over this earlier, and I don't know if my colleagues were here, we pass laws in this chamber, and we always try to demonstrate that we're trying to remedy a situation that is true in existence, and the manner in which we do it, we look at cost-benefit. We can't prove fraud, but I can assure you we can prove with beyond a shadow of a doubt that people will be denied access to the polls.
Well, I thank my friend from Texas. The history of America has been a history of expanding the franchise, the opportunity, the right to vote. And it's based on this principle that we often talk about in this chamber, but maybe don't pay enough attention to, which is the principle of equality under the law. We're not just saying that, yes, everybody can vote, well, unless you're disabled and you can't get into the polling place. Or everybody can vote except, well, if you're 75 years old, 85 years old, you're no longer driving and you've let your driver's license expire and no, you haven't gotten down to motor vehicles to get on the or we'll let everybody vote, well, as long as you pay a tax, or if your grandfather voted, or if you can cross these hurdles. You know, our history has been a history of saying everybody is equal under the law, and we don't put artificial hurdles in place. The 15th Amendment said you can't deny African Americans the right to vote. In 1915, the Supreme Court said the grandfather clauses are unconstitutional, which would outlaw exemptions from literacy requirements for voters whose grandfathers had been eligible to vote before, at the time of the Civil War. And the 19th Amendment said women could vote, and the 23rd Amendment said citizens of the District of Columbia could vote in presidential elections. And the 24th Amendment outlawed poll taxes, and in 1965, as I referred to earlier, in the aftermath of the march across the Edmund Pettus Bridge in Selma, the Voting Rights Act was passed, which prohibits discrimination on the basis of race or language minority status. It prohibits the use of suppressive tactics and various poll tests. These are, I could go on. The 18-year-old vote, the Americans with Disabilities Act that requires equal access to voting places, the National Voter Registration Act, the Motor Voter Act. These are all based on the principle of equality under the law.
Would the gentleman yield?
I'd be happy to yield.
Thank you. And in answer to the gentleman from Texas's question, what's wrong with it is that this is supposed to be a country that affords everyone, regardless of any category that you fall into, the opportunity to vote. The voter suppression laws that have been passed by Republican legislatures, championed by Republican governors across the country, have systematically targeted specific groups of individuals based on their propensity to vote differently than the legislators that support those laws would like to see them vote. In other words, they are essentially blocking access to the polls for people who vote against their interests, against Republican interests. That is, blocking anyone's access to the polls is unacceptable to begin with, but insidiously trying to influence the outcome of an election through systematically changing the law to prevent people who are likely to go to the polls to vote for your opponent is the most heinous form of anti-democratic policy. It's the kind of policy that you would see in countries that we abhor, countries that we criticize. Just for example, let's take the photo ID laws that have, we have a photo ID law in Florida. There are photo ID laws across the country. You may have told the story of the 96-year-old woman from Tennessee. I'm sure you probably already talked about that this evening. But there are, if you look at the statistics, which you may have gone over as well, 11% of Americans don't have a photo ID. 11%. 25% of African Americans don't have a photo ID, and I don't know the number. I was looking for the statistic for Hispanics, but it is unacceptable to say that the only way that you can identify somebody is by requiring them to carry a photo identification in order to vote. That's ridiculous. Modern technology today allows for signature matches. All of our supervisors of elections have the signatures on file, either in the old-fashioned way, written on a piece of paper, or scanned into a computer where they can match the signatures. I mean, that's how they did it they've done it for many years in Florida until they imposed the photo ID law. All that photo ID laws are an obstacle in the path of an individual who is more likely to go and vote for someone who is not a Republican. And I'm sorry, elections should be won fair and square.
And continuing to answer the gentleman's question, who cares? Why does it matter? My friend from Florida has talked about how millions can be disenfranchised, excluded by the photo ID laws. Additionally, state after state has made it more difficult to conduct voter registration drives. Mm-hmm. So people who are eligible, who should be voting, are prevented from or hindered in their registration, and hundreds of thousands.
Mr. Holt, I have a story
we
I want to share.
expect would be excluded because of registration drives.
And
there are other restrictions too, which I'll talk about in a moment.
Oh,
I yield
definitely. Thank you.
to the gentlelady.
I just want to tell a story on that very specific restriction. We had the Republican Secretary of State in Florida recently asked the Attorney General to start assessing $50 fines for each of the 76 voter registration applications that were submitted by a high school teacher in Santa Rosa County. There was no indication of foul play. The applications were of individuals who appeared to be eligible Florida voters. They were high school kids who were 18 and were eligible to vote, but because Florida has changed the law under the Republican voter suppression law that requires registrations to be turned in within 48 hours, and it used to be 10 days, this teacher got fined because she was trying to help her students register to vote and didn't get them in under the new time limit.
And so I asked the lady, the gentlelady, how many other patriotic Americans are going to be deterred from asking their friends, their neighbors, in this case maybe students, from registering for fear that they'll be prosecuted if they don't dot the I's just right.
Well, the League of Women Voters in my state, Mr. Holt, has registered voters in Florida for 7 decades and suspended their voter registration activity after this law passed because they can't take the risk. The organization would become bankrupt. Can you imagine that the League of Women Voters no longer registers people to vote in the state of Florida?
And then in other states, who cares, my friend asks, in other states they're making it harder to cast absentee ballots. So that's going to exclude people. And this is not, you don't have to be a conspiracy theorist to see behind this a purpose of exclusion. This is not, oh, we're just trying to clean up the procedures here to make sure that it's all neat and tidy. No, this is deliberate exclusion.
Well, the curious thing, and I know that the gentlelady from Florida already pointed it out, and that is there is no doubt that certain segments of voters are being targeted. This isn't an even application that is whose consequences will be felt across equally all sectors or segments of the voting population. We know what is really going on, and it is a concerted, directed effort. And some people may find it exceedingly hard to believe that that's what these laws will actually accomplish, rather than the lofty goal of somehow eliminating, addressing voter fraud, when we've already stated that you don't have any demonstrable evidence that the fraud is occurring. Now, I do want to say in Texas, we just had this new photo ID law passed, so I went to the Secretary of State's office and I went to the Department of Public Safety, which is charged and tasked with the duty of providing this election ID, photo ID. Now, this is the amazing thing. The Department of Public Safety in the state of Texas has not been appropriated $1 extra for this added burden. They are not going to have extended hours. They're going to have the regular hours. They're not going to have any mobile units of any type. They will continue using their existing facilities, which are already taxed to the limit by individuals going in there just for regular business. Now, this is the state of Texas. You may not believe this, but I think Florida is a pretty big state. New Jersey, not as big. But you can have a distance of 100 miles. You can have a distance of 100 miles from some of our towns to the nearest DPS office. Now, why would that be important? You don't have a Texas driver's license, so that tells you you're going to have to get someone to drive you to the DPS station. And then you're going to be in the same line. Maybe they'll queue it a little differently, whatever it is. But I will tell you now, the Texas experience is no different than most other states where you stand in line for inordinate amounts of time. And if we're talking about the elderly, if we're talking about those that have some sort of a physical handicap, they can still go out and vote because they're so proud of the right to vote that they've been exercising for 60-plus years. But I would yield to the gentlewoman from Florida.
Because in some states, it's equally as bad. It's certainly bad enough in Texas that they're not putting more funding in to make sure that people have more access to get those photo IDs. But in some states, because of the budget cuts, they're systematically in communities that have large African-American populations and large Hispanic populations shutting down driver's license offices so that it's even harder for those communities to go and get a photo ID. So, I mean, this has been insidious. The disturbing thing about this is that it's clear that these Republican legislatures led by Republican governors just don't think that they can win an election on the merits. And so they need an insurance policy, because in the event that voters actually decide that no, Republicans aren't interested in creating jobs. No, they're not interested in getting the economy turned around. And, gee, maybe I'd like to actually go to the polls and vote for the candidate of my choice. They are using the insurance policy of voter suppression laws to make sure that people who are likely to go to the polls and vote for someone other than them can't do it. It's un-American. It's unacceptable.
I believe that we still have at least 5 minutes, and I surely wanted to reference an article that was written by our colleague from Georgia, John Lewis. Mr. Holt, I think, has already referred to Mr. Lewis's illustrative career in the civil rights movement and such. But I'd like to read the last couple of paragraphs, because coming from John Lewis, it is special, because he's lived the worst of times. And he knows that it's been a progression, a slow one, and we're not there yet. To somehow return to those old days under the guise of some sort of voter fraud, which again has not been demonstrated. And we know that the cost is going to far exceed the benefits. This is what he said. These restrictions purportedly apply to all citizens equally. In reality, we know that they will disproportionately burden African Americans and other racial minorities yet again. They are poll taxes by another name. The King Memorial reminds us that out of a mountain of despair we may hew a stone of hope. 48 years after the March on Washington, we must continue our work with hope that all citizens will have an unfettered right to vote. Second-class citizenship is not citizenship at all. We've come some distance and have made great progress, but Dr. King's dream has not been realized in full. New restraints on the right to vote do not merely slow us down, they turn us backward, setting us in the wrong direction on a course where we have already traveled too far and sacrificed too much. Mr. Speaker, how much time remains?
6 minutes.
The gentleman has about 5.5 minutes left.
I'd like to yield time to each of my colleagues as we close out the special order, and I would recognize the gentleman from New Jersey, Mr. Holt.
Thank you. So, you know, as efforts are made to put hurdles in the way, to require proof that is difficult or expensive to get, that is, if offices are closed and open periods for absentee ballots are shrunk, and early voting is discontinued as it has been in some states. In fact, Florida, Georgia, Ohio, Tennessee, West Virginia have succeeded in enacting bills that reduce early voting. All of this serves not only to reduce the dignity of Americans by saying the principle of equality applies except for some people. Some people, as I said, who might have physical disabilities or might be elderly or might be low income. But more than that, it deprives us of a working democracy. The reason the history of America has been a history of expanding the franchise is so that we could have a more stable, productive democracy. We want everyone to vote. It makes this a richer country in every way. I thank the gentleman for setting aside this time. I can't think of a more important topic to be debated in this great chamber.
And I thank my colleague for his participation in his words, and I will yield to my colleague from Florida.
Thank you very much, and thank you for the opportunity and for calling us together on this very important topic. I just want to close out my time very briefly by saying to the gentleman from Texas and New Jersey that we are not going to lay down and just allow these laws to stand. That we are going to, that there are civil rights organizations as we speak pursuing these laws because we know that they're violations of individuals' constitutional rights. We know they're violations of the Voting Rights Act of 1965. We know that the Justice Department is reviewing many of these laws because they have to be pre-cleared under the Voting Rights Act of 1965. So people should know that while we are here expressing grave concern, we are certainly not only using our voices to fight these insidious laws, we are standing up for the franchise, standing up for the right to vote, and making sure that as Democrats, we go to bat to make sure that every eligible voter has an opportunity to vote, cast their vote for the person that is the individual that they want to represent them in this representative democracy, and we are standing against individuals who try to fix the outcome of elections by blocking people's access to the polls. So thank you, and I yield back.
I thank my colleague from Florida, and I thank the Speaker, and I yield back the balance of my time.
The gentleman yields back. Under the Speaker's announced policy of January 5th, 2011, the Chair recognizes the gentleman from Iowa, Mr. King, for 30 minutes.
Thank you, Mr. Speaker. It's always my privilege to be recognized to address you here on the floor of the House of Representatives, and I find it a bit ironic that I'm watching the representatives from Florida, New York, and Texas speak to the Speaker pro tem just previous to you about the election situation. I'm thinking about the 2000 election when it was reported, not substantiated to my satisfaction, but reported that as many as 25,000 people from New York voted both in New York and in Florida either for a president from Texas or one from Tennessee, where the Speaker pro tem momentarily ago was from. That's a bit of an irony as I listen to this discussion that's going on about the election process here in the United States. And I think there's too little concern on the part of my colleagues, whom I do respect and appreciate and count as friends in many respects. I think there's too much focus on how you get more warm bodies to the polls as many times as possible and not enough on the legitimate vote. Now, as I listen, the gentleman from Texas said there's no demonstrable evidence that fraud is occurring. I would disagree. I think convictions are demonstrable evidence. And the convictions, particularly in Troy, New York, of election fraud, I have seen it in the state of Iowa in a fashion that didn't result in convictions, but I have conviction that it happened. We have paid too little attention to election fraud. And in the case that I mentioned of people voting in the state of New York and in the state of Florida, if they do both, they surely can't be lawfully voting in each of the states. They may not be lawfully able to vote in either state, but voting in both states. And how does that happen, Mr. Speaker? This is an unexamined subject matter on the part of my colleagues from the other side of the aisle. How does it happen that people can vote someplace where they don't reside? How does it happen that people can vote when they're not citizens? How does it happen that they can vote when they're not qualified to vote? And how does it happen that they can vote in more than one jurisdiction for the same election, not necessarily simultaneously, but possibly simultaneously? And I can tell you, to answer those questions to some degree, how that is, Mr. Speaker. It works this way. The voter registration lists within the states are not integrated among the states. And so if an individual is registered to vote in New York, they can also be registered to vote in Florida, or any adjoining state for that matter, New Jersey, Connecticut, you name it. All we have to do is go in and register in one state and go register in the other state. In fact, in my own state, it was the case, and probably is not still the case, that the voter registration list does not integrate itself county to county in a definitive way. If John Doe registers to vote in Washington County and goes over to register to vote as John M. Doe in Jefferson County, there's two registrations there, and John Doe can vote in both counties, both by absentee. In fact, in my state, where it's 99 counties, it's possible to vote in 99 counties simultaneously by absentee. If you just simply register yourself to vote, put up an address that is perhaps a false address, but an address of someone else, and if that address is, if the voter registration is unique in any way, if it's, the initial could change, it could be John, it could be Jonathan, it could be the middle name can change, and that's all it would take. The same person could vote multiple times in a state. Now think how many times that can happen when they're crossing the state lines. No one has yet calculated how many times an individual could vote in the United States if they really wanted to game the system. And we do hear credible stories
of buses taking people across the state lines and buses taking people from precinct to precinct to vote multiple times. And who have been the advocates for same-day registration? Who have been the advocates for lowering the integrity of the vote itself? It's been the people on the other side of the aisle. It's been the Democrats. The things that Republicans bring to establish credibility and integrity in the vote are undermined by the Democrats on the other side of the aisle, Mr. Speaker. And why? Because they say that people are disenfranchised from their vote. And I would argue that legitimate voters, American citizens who respect the law and vote one time, one place in their legal residence, are watching their vote be canceled out by illegitimate votes that happen in this country. Because we don't have convictions for people voting in multiple locations for the same election, isn't it an indication that it doesn't happen? We do have some convictions. We don't have large numbers of convictions, as the gentleman from Texas may have implied, but not specifically said. And the reason for that is because our voting laws are so open, so lax, so insecure, that it's nearly impossible to get a conviction. For example, in the state of New Mexico, if I were working the voting booths as an election worker in New Mexico, and I open the polls up at, say, 8 o'clock in the morning, and I'm sitting there for the list of people that come in and they say, I'm John Doe, I'm Jane Doe, I'm Jim Smith. If one of them walks in and says, I'm Steve King, and I live at the address where I live, and I've not yet voted, I am compelled, even as an election worker, to let that false and fraudulent individual vote under my name. It's against the law in New Mexico and other states to challenge an illegitimate voter even when you know that they're illegitimate, even to the extent that they allege they are the person who is checking them off the list. They still have to let them vote and they can't challenge them. That's how open these laws are. That's the kind of thing that you have promoted, the kind of thing that you won't defend, the kind of thing that I will yield to if you've got a defense for opening up and eroding the integrity of the United States. And many of these are state laws, I recognize that. But we give direction and leadership. We have the HAVA Act, the Help America Vote Act, that open it up even more. And I think the gentleman from New York who spoke within the last half hour, and I do agree on this, there should be a paper trail so we can audit the votes that are cast. Now, we've agreed on that. We've worked together on that cause, not arrived at that as far as the conclusion for this Congress is concerned that can be passed into law, but I think there should be a paper trail, and the gentleman from New York and I are in conceptual agreement on that, Mr. Holt. And I appreciate that push. I do think it's out of the right spirit of his head and his heart, but it might also be from suspicion that the people that produce the electronic voting machines may be Republicans, they may be Democrats, and that seems to color our judgment. Mine is, don't give anybody a chance to cheat, and don't let the electronic voting machines be offered in such a way that some programmer can jigger the machine to give an advantage to either party. I think of the election situation that took place in Florida in the year 2000. I spent 37 days focusing on that. I was the chairman of the Iowa State Senate State Government Committee. It was my job to see to it that Iowa didn't become a Florida for the fiasco in Florida. So therefore, I chased through all the way through the internet, everything that I could find, all the research that I could come up with on the election processes state by state. 37 days of focus. And then after that, not quite as focused, but I followed through and wrote legislation which passed the Iowa Senate. And I discovered a significant amount of election fraud in this country. This is in the year 2000, well before the American public had heard of ACORN. I found, I believed, a significant amount of election fraud. There were a pair of brothers in Florida that had done research on election fraud in Florida, the Collier brothers. Both of them now passed away. They've written a book on this and did a video on it, as I recall. And part of that video was walking into the maintenance shop where they took care of the machines that counted the punch card ballots, the notorious punch card ballots that were prevalent in Florida in the year 2000. And they have the video of the former election commissioner who had retired from that and handed it over, of course, to his successor and gone to work maintaining the vote counting machines. The machines that you would feed in a stack of punch card ballots and it would run through and the machine would read it and it spit the number out the other side.
And on that video, and it was available at the time, I don't know if it's available now, the man walked through his shop and pulled out of the drawer a gear. And he said, here's how we do this. We just grind one tooth off of this gear, and then every time 10 ballots go through, it kicks an extra one in our side. On videotape, there it was. And of course, they got nervous afterwards and tried to do what they could to suppress it. Those kind of things have gone on in America. They have gone on in Florida. They've gone on in other states. And the people that advocate for or defend more open election laws and process are, whether they realize it or not, enabling election fraud in this country. I want it to be as clean as possible, as legitimate as possible. I don't want a single qualified vote to be canceled out by an unqualified vote, let alone one that's designed to be fraudulent. I don't want buses going across state lines loaded with people that are in there to do same-day registration to vote and disappear. We had voters in Iowa that registered from the hotel room where the campaign had out-of-state workers. People don't live in hotels in these kind of neighborhoods. It may happen in the inner city. It doesn't happen in a hotel in the neighborhoods I'm talking about in Iowa. These are people that come and stay a couple days, or 4 or 5 days, maybe a week, and they're gone again. These are folks that have a home of their own. It isn't a residence. When you register to vote from a hotel where they didn't have a single guest that stayed longer than 2 weeks in the last year, you're pretty sure that if that's the hotel where they put their campaign workers that came from out of state, it's a pretty good bet that those votes that were registered in that hotel are votes from people that are not legitimate to vote within that precinct, within that district, or probably, and almost in each of those cases, within the state. So I have advocated, let's see, here's another, the statement made by the gentleman from Texas, if you have no Texas driver's license, you have to get someone to take you to the polls. Well, is that person a recluse? Don't they have an opportunity for an absentee ballot? Do they ever go to town, for example? And if they do, can't they time their trip to the grocery store to go on Election Day and vote? And the concern about the primary part of this, yes, I think there are some fraudulent primaries that take place. And there are some that are stacked up that I'd like to see them revisit. I'd like to see the Granite State revisit their primary process that it lets people go to the polls and vote, and they say the Democrats go to the polls and vote in the Republican primary. We in Iowa have a caucus system for our president, and there we require that they be registered either as Democrats or Republicans. They have to pick one or the other, and they don't get to switch sides that easily, although it is possible in the state of Iowa. But here's what needs to happen in this country. We need to have voter registration lists that are free of duplicates, free of deceased, and free of felons where the law applies. And they need to be certified to be citizens, not a motor voter law that people go in that don't speak English, that get their driver's license, and then they ask them a question, check this box, check that box. If they don't understand English, they don't know what they're saying yes to. They don't realize that they are under a penalty of perjury if they claim to be a citizen and they are not. And so they will say yes, they get the nod, now they're registered to vote, now a non-citizen, quite often illegal, is in a position to cast a ballot. And we saw 537 votes be the difference in the state of Florida in the year 2000 on who would be the President of the United States, the Commander-in-Chief, and the leader of the free world, decided by 537 votes in the state of Florida. Now, every time they've recounted those votes in Florida, I think that Republicans on this side and Democrats on this side will agree that it came back to that same number. And if you've got some other narrative, again, I'll yield to you. You can tell me what your narrative is. But the consensus now, after all this analysis, is we got a legitimate vote there. George Bush was not the appointed president. He was the elected president. But it was very, very close in the year 2000. And it did pivot on Florida. But how far apart would that election have been if one could actually know which of the votes were fraudulent and which were not? Last time I came to the floor, I heard the whip, or the minority whip, come to the floor and make the statement that we didn't have evidence, again, as we've heard from the gentleman from Texas, no demonstrable evidence that fraud is occurring. And the gentleman from Maryland's statement was close to that, although not exact. I'd argue the opposite. We have Acorn that admitted to more than 400,000 fraudulent voter registrations.
more than 400,000 confessed to fraudulent registrations. This is the acorn that I carry in my pocket, Mr. Speaker. I carry it in my pocket every day to remind me of what happens to this country if we let organizations like ACORN or advocates that seek to diminish the integrity of the vote take over. If they do that, then they erode the faith in the American people in the election. You can have fraudulent elections, but as long as we believe that they're legitimate, American people are going to accept the results, because we do have great faith in this constitutional republic, which is guaranteed to us in Article 4, Section 4 of the Constitution, by the way, shall guarantee a Republican form of government. But this country respects the election process, and that's why we accept the results of the election process. And if we lose faith in it, in the election process, legitimate or not, then the very bedrock that the foundation of our country, the Constitution, sets on, crumbles. And the Constitution itself crumbles, and we crumble into some form of anarchy because we will have lost our integrity in our election process. Now, is it too much to ask that if someone goes to the polls, that they would bring with them a picture ID? I wonder if any of those folks have ever gotten on an airplane, or if they've ever gone to rent a movie, and they're asked for an identification to support their credit card when they rent a movie. That's not too much to ask. I've never heard anyone come to this Congress and say, I demand my civil liberties. I demand that I be able to rent a movie without any identification, without any credit card. Why can't we just do that on my word? I'll walk in and sign this paper that says, I'm Joe Blow, and I live at 100 Exotic Avenue, and I want to rent an exotic movie, and I don't want to have an identification to do that. Never had anybody ask for that in this Congress. They know they don't have a civil right to do business in this country without identification. If the merchant requires that identification, they willingly supply it. And yet, to choose the next leader in the free world, the commander-in-chief, the President of the United States, the advocates that have stood on the floor have said to the effect of, anybody that walk up there and attest that they are a living, breathing human being and that they live somewhere, they can vote. And they can register on the spot, and they can vote, and they can walk away not showing any identification whatsoever. And in some cases, it just takes someone to attest to that they are the individual that they say they are. So they don't really even need to misrepresent themselves. They can walk up and say, I'm Joe Blow, I want to vote here, and I lived in this precinct. They sometimes will lie about where they live, but they can actually say who they are. Then they can walk to the next precinct and say, I'm Joe M. Blow. And then I'm Joe N. Blow at the next precinct, and O. Blow, and P, Q, R, right on down the line. They can put a number in for their middle name, vote in 99 counties in the state of Iowa, and they can do it in many of the other states as well. We do not have the integrity in our election process that we need. I know that it's being gamed. I also know that we're not getting the convictions and the prosecutions because we don't have the structure in place even to get those convictions, because we've eroded the integrity to the point where there's not a basis there hardly to bring that kind of a prosecution. And then we watch George Soros invest in the campaigns of multiple secretaries of state across the country. And where was it? Swing states. And what happened in those close elections where George Soros was a campaign contributor? We know what happened. Those real close elections, in the last minute, votes showed up that were surprises, and the election turned. We have at least one senator down the aisle at my neighborhood that arrived in that fashion, Mr. Speaker. And so I am disturbed about the results of these elections if they do not reflect the actual will of the American people, the actual will of the people within the jurisdiction that should be voting for those candidates. And I believe we need to enhance the integrity of the ballot. I would shorten the terms that a person could be asking for an absentee ballot, and I would tighten the conditions, and so that if it's reasonable for you to vote in person on Election Day, do so. These elections should not be a drawn-out 45 or 90-day absentee ballot affair. The more we do the absentee ballots, the more we cast our ballots from afar, the more likely it is we're voting for a candidate who's passed away during the campaign. And the less likely it is we will know all the things we need to know to make a reasoned judgment about that candidate. In fact, it's possible we have elected a United States Senator who had passed away in a tragic plane accident. And I regret that that happened,
but the people went to the polls and voted to elect that person who was passed away. I'm for a voter registration system that's free of duplicates, deceased, and where the law applies felons. I'm for a picture ID, a government-issued picture ID that has legitimacy, and I'm opposed to motor voter, I'm opposed to satellite voting, and I'm opposed to same-day registration. And all of these components of the election process, I add to that again, there needs to be a paper trail for the ballots. Let's have integrity. Let's have a certification that they be citizens from the secretaries of state of each of the states. And then, if we don't have enough integrity in our ballots, something's got to happen where we crunch the databases of the voter registration against those of the other states to find out how many duplicates there really are. And there would be many. So I have less faith in this than most of the American public does, and if they had the exposure to what I've had the exposure to, I would submit, Mr. Speaker, that there wouldn't be the confidence in this election process that the American public has, and that lack of confidence might result in a different kind of a result here within this Congress and within the states. I think that they would impose more integrity in the ballot process. And so I didn't come here to speak about that. I listened to the gentlelady and the gentleman that spoke in the previous period, and yeah, I felt that I had to express the other viewpoint. I actually came here, Mr. Speaker, to talk about how we transform this economy here in the United States. And being from Iowa, I've listened to the economic proposals of each of the presidential candidates. I've listened to them make their pitch for their vision for America. And I said last January, February, March, and on throughout the summer, clear into August at least, that we don't have a presidential candidate on the Republican side of the aisle that's put together an economic recovery plan. Yes, they have pieces, yes, they have components, and they do tweak it around the edges, and they'll argue that one piece or another is what it takes to bring our economy back around where it belongs. Well, I've watched this economy devolve downward, and it's a deep trough, but worse than the deep trough is the length of this trough that we're in. And it is an economic fact that if you look at the patterns of economic growth and decline throughout the history of the free market world, one will see that whenever there has been a Keynesian economic theory applied, the more vigor with which it is applied, the longer is the trough for recovery. If one will look at the grandest experiment of Keynesian economics we had seen up till this point, was Franklin Delano Roosevelt's New Deal that he unleashed on the American people starting at the beginning of his term. Stock market crash in October of 1929, and we saw Herbert Hoover caught up in the throes of that climactic shift economically that was a global trend. Herbert Hoover had everything he'd touched had turned to gold up to that point. He believed that he could steer government to solve the problem. Well, he went to work to try to steer government, and it went the other way on him. Cool Cal Coolidge had a pretty good handle on it earlier in the previous decade, and that was set back, not just, let's see, how did it go? Don't just stand there, do nothing, and because the free market system will recover itself. Well, instead, we had Smoot-Hawley, we had trade protectionism, we had then the New Deal that flowed out of Franklin Delano Roosevelt. We had billions of dollars that ultimately were spent throughout that period of time, at least in today's dollars, and the CCC camps, the WPA programs, the TVA, the list went on and on and on that came out of Roosevelt. Throw another plan at it, throw some more money at it, borrow some money, grow the federal government, and put money into the hands of people. And if you do that, the theory was, according to John Maynard Keynes, who was the most influential economist of his time, and his curse lingers on us in this Congress today, that if you would get money in the hands of people, they would spend it, and that would stimulate the economy, and the economy would recover. In other words, we could spend ourselves into prosperity, according to John Maynard Keynes. Now, Franklin Delano Roosevelt bought into the Keynesian economic theory with more vigor than George W. Bush bought into the Henry Paulson stimulus plan, or should I say the TARP plan. $700 billion tossed in there to pick up toxic debt was the plan. But back in the 30s, it was FDR's plan
to follow Keynes's directive, which was put money into the hands of people and get them to spend it and you'll stimulate the economy. Because they believed that our economy was consumer-driven. Well, Mr. Speaker, every Keynesian experiment that I know of in history, and that includes Roosevelt's New Deal, it includes the Japanese, and it absolutely includes Barack Obama's economic stimulus plans, his approach to this. And by the way, President Obama has told us directly face-to-face that he believes that Roosevelt lost his nerve, that he should have spent a lot more money in the 30s, that because he lost his nerve and didn't spend more, it brought about a recession, a recession within a depression, and unemployment went up because Roosevelt didn't borrow and spend enough government money. Well, I know what it's like to compete with a government that has more money than the private sector has. I know what it's like to try to hire somebody off of unemployment. I know what it's like to train employees, put them on a benefits plan, and have them finally in a place where they can be a full-time employee that can yield a return on the work that they're doing, and you can count on them being to work every day and look at how their career is laid out working for your company, and have the federal government or the state government or the county government or even the city government come in and outbid you for those services. And how do they do that? Well, they do that by looking around and thinking, here's this trained employee, what's it take to get them? And they will up the ante until they can hire this trained employee, and inevitably that employee will take the offer of the higher paycheck and a benefits package that competes or exceeds the one that you can offer from the private sector and go to work for the government, where they don't have the responsibility, where they don't have to work as hard, where the hours are more predictable, where the risk of employment is less and it's more stable. I recognize that. But better wages and better benefits and all of those comforts that come with a government job work against the private sector. And so private sector employers then find themselves faced with having to go out and hire more help and train more help and see that those employees roll over into the government employment. Now here's the real downside, though, is this. Where does the government come up with the money to pay more wages and pay better benefits, which they have been increasingly doing over the last generation? By raising taxes. The government raises taxes to get the revenue to bid against the private sector. And then the government comes out and makes an offer that says, we're going to extend unemployment benefits out to 99 weeks. Now it makes it harder yet for the private sector to recover because once they're competing with the government's offer to hire employees away or the government's offer to pay people not to work. And where does that money come from? This federal government borrows it. This federal government borrows it from the Chinese, borrows it from the Saudis, borrows it from multiple countries around the world, and about 50% of it, to be fair, comes from investors within the United States domestic funds that are invested into U.S. Treasury bills, for example. So a government that believes that it can stimulate economy by stimulating consumption and completely ignores the part of the equation that requires that there be production and for the economy to function. And I would point out that if no one is producing any food, clothing, or shelter, if no one is producing any transportation links out there in the private sector, if no one is making available any of the recreational facilities that will attract those dollars, there's not production. If there's not production, there's no place for anyone to spend their money. This economy is production-driven, not consumption-driven. And we must, to grow out of this economic situation that we're in, we must produce goods and services that have a marketable value, both domestically and abroad. When we do that, and we will eventually do that, this country will grow out of this problem that we are in. But we must get government off of our back. We must keep a competitive tax rate for the rest of the world. We must reduce our regulation. We must stimulate our entrepreneurs. And this Republican side of the aisle has now for about 3 years been saying, where are the jobs? Mr. President, where are the jobs? Well, I've heard that echo many times in this chamber and across through the media outlets in the country. But I would submit that there's something else out there that's required before there will be any jobs, and that's the prospect of profit. Investors, employers, entrepreneurs must have a prospect for profit before they will invest their money or put their time in or take the risk of hiring employees, especially with ever more regulations, especially with Obamacare pouring down over everything that we do. We are not going to get to a recovery until investors, entrepreneurs, and employers can see an opportunity for profit and begin to realize that profit, because you can't write paychecks for employees from a deficit spending very long. You must have profit in order to pay employees. So if there's going to be jobs and we want Americans to go to work, you must have profit in order to fund the wages. And I don't know why I don't hear that from anybody else. It's as if this word profit is a dirty word. No, it's a very good thing. America is a country that has to build on profit, on free enterprise capitalism. I just took a look in my desk drawer today. There are flashcards in there that were published in 2008. These are the flashcards that enable one to be trained for naturalization here in the United States. So if you want to become an American citizen, you come to America legally, get yourself a green card, and what you do is you have to take the test, and part of that test is what's the economic system? Free enterprise capitalism. That's on the test. It's a little heads up, Mr. President. I hope you could pass that test. Mr. Speaker, I appreciate your attention, and I yield back the balance of my time.
Gentlemen, yield back. Under the Speaker's announced policy of January 5th, 2011, the Chair recognizes the gentleman from Oregon, Mr. Blumenauer, for 30 minutes.
Thank you, Mr. Speaker. I appreciate the opportunity to be here this evening, sharing some observations. It is, of course, always interesting to have shared the floor with my good friend from Iowa, listening to his view of the universe, and even wincing a little bit as I hear him talk about the vilified public employee, where they don't have to work as hard and they get lots more money than the private sector. It's interesting that most independent studies suggest that for many categories of public employees, they are not above the market. And it's sort of a fantasy land, I think, to have this disdain that was overwhelmingly rejected in Ohio, when voters had a chance to put a stamp of approval on the fairly radical agenda of Governor Kasich, our former colleague here on the floor, in the House of Representatives. Things, by the way, that Kasich and his fellow traveler, Governor Walker in Wisconsin, didn't talk about during the election. But turning their guns on public employees, voters in Ohio had a chance to give their verdict. And it's interesting that they overwhelmingly repudiated this notion, the lack of value of public employees, the fact that they're slackers, laggards, and that what they do is not worthy of public support. It wasn't the public health nurse, the firefighter, the teacher, the Marine, the person in the Navy that almost wrecked the economy. Many of these people are providing essential services. They are extraordinarily hardworking, and I'm happy to invite my friend from Iowa to come meet some very hard-working public employees in Iowa and in Portland, Oregon. I think those generalizations are really unfortunate. It's feeding what we see in terms of the back and forth now. It's actually why there are people who've been motivated by the Occupy Wall Street movement. But I'm here tonight to deal with one very specific focus that I think needs some more attention, and that has to do with the Postal Service. You know, this is one of the areas today where people are zeroing in. You will hear some talk of folks that would feel much better if we just privatized the Postal Service. Get out of the business. Let the private sector provide this service to American households and commerce, and that we'll all be better off. I think it's important for us to take a step back and look at some of the facts and look at some of the consequences. You know, the United States Postal Service has a long and storied career. It's the second oldest federal agency. In fact, the predecessor was actually created by the Continental Congress, and Ben Franklin was the postmaster there, just as he was America's first postmaster. The Postal Service is one of those activities that maybe some of my colleagues in the floor kind of overlooked when they had this great ceremony of reading the Constitution early in the session, and then proceed to act as though they really aren't paying attention to the Constitution. Well, Article 1, Section 8, explaining the Congress's powers, one of them is specifically to establish post offices and post roads. This was one of the unique institutions that helped bring America together. And it is still bringing America together today. It is, in fact, a vast and sprawling enterprise. It employs more people than the entire auto industry in the United States, all what we used to call the Big Three. It's the second largest non-military employer in this country. It has more installations than Walmart, Starbucks, and McDonald's put together, even though a number of them have been closed over the years. There's a reason that we've made this investment for 235 years. There's a reason that there are hundreds of thousands of dedicated employees. There is a reason why we have the broad sweep, and that is this critical element of holding our country together. It is a backbone of commerce. We talked today about the economy of the future. E-commerce is a large and growing area. It relies upon the Postal Service for much of its efficiency, and I'll talk a little bit about that later. But it's also a tremendous resource for the American public. I can drop in the mail here in Washington, D.C., before I get back to my home in Portland, I can drop my tax payment in the mail, 44 cents, with great confidence that that's going to arrive in a timely fashion and my bill will be paid. It is, I think, interesting to look at the large national direct mail marketing industry that involves advertising and shipping worth billions of dollars a year, and again is very important to a large number of Americans. In fact, some of the people that my colleagues would just turn the Postal Service over to provide this activity for the American public, like UPS, like FedEx, they actually rely on the Postal Service for that last connection. There is actually an important partnership between these carriers and the Postal Service. Now, there is no doubt that if we completely privatized, turned it over, got out of the way, there would be some people who would benefit. People who live in very large cities, people who are big businesses that can negotiate certain types of services, may actually see a little bit of rate reduction, and they may be able to tailor the service to their needs. For them, the free market may provide a modest benefit. Maybe. But the more important question is what would happen for the rest of America, the other 99%, particularly rural and small-town America. Does anybody think that you would be able to send a letter from the Florida Keys to Nome, Alaska for 44 cents if all of a sudden government wasn't there providing that universal service, a mandate? I don't think so. We would also lose the personal touch that is so cherished by so many. We're hearing the outcries now. I hear it in Oregon, where there are dozens of communities that are being considered to lose their postal service. Every rural and small-town American community will feel that bite. Higher costs, less service,
loss of job, loss of community identity, loss of connectivity. I would urge some of my colleagues to take the time to listen to rural postmasters and letter carriers about the role that they play in these far-flung parts of America. They are an important part of the local economy. It is a place where community members gather. There are opportunities for them to be in touch with loved ones and to be in touch via the magic of e-commerce. They have far more choices and opportunities. Well, before we jettison that element, I think it is important to consider how important that is to our national infrastructure. And that's what it is. It's not just arguably the largest source of non-military family wage jobs in America. I don't think Walmart is necessarily the criterion that most people want for family wage jobs, for health care and retirement benefits. You know, there was a time when that's what most people in the middle class, if not took it for granted, at least aspired to. And most of us growing up in post-World War II America saw that, even with people with limited education who are willing to work hard and be able to follow through. They had that. Well, more and more the norm is that is unusual. I hope that we don't reach the point where we lower the standard. But 2/3 of a million family wage jobs with decent retirement security, with decent benefits, people who are providing an essential service is important. But it's the infrastructure that ties America together that I think is even more important. Now, there's many things that are involved with the Postal Service that are hidden away, that people simply don't pay any attention to. In part, I guess I would just reference the exemplary service that is provided by most postal employees. In fact, it is, I know a number of postal employees who are highly regarded by the people on their route. They are recognized on their birthday. They get Christmas presents. People look forward to them. They rely on the service. They appreciate it. Postal employees are involved with a wide range of activities in terms of helping people with their income tax reforms, food drives, checking on housebound friends and neighbors. When something is amiss, it's often a postal employee who understands it first. I think it is important that we take a deep breath and look at the service that's provided, look at what difference it makes for America, look at what it means as an example of where we are going as a country. I think one of the items that should be acknowledged is that this is the so-called crisis that we are facing is much like the summer's debt ceiling crisis. It's manufactured. The same way that we were always going to pay the debts that the United States had already incurred, but some people were raising doubts. They created a political firestorm. It encouraged the downgrade in the eyes of some in one rating agency of United States debt. But we were, in fact, going to pay our bills, but it's possible to manufacture a crisis. Well, the Post Office is facing a continuation of a theme that has plagued its existence ever since Washington decided to trap the United States Postal Service between being a business and government control. Business demands government control. Back, Mr. Speaker, when the Postal Service ceased being a formal government agency, there were certain conditions that were negotiated. because for years the post office was a government agency. The benefit, the public benefit that was recognized was taken into account. There's no question that the post office provided subsidized mail service. Some people remember the 3-cent stamp. Some people, I guess there aren't many people who remember now, the Postal Service helped launch the aviation industry in this country in 1918 when air mail service began between New York City and Washington, D.C. The Post Office was a part of helping create that part of our infrastructure. The Post Office helped with the development of the Transcontinental Railroad service that served cities large and small. There was a synergy that was involved there. Well, in 1970, the Post Office, the Postal Reorganization Act, changed the Post Office from being a department of the federal government to being an independent agency. It created a board of governors, it authorized the Postal Service to borrow from the public, and it phased out the government appropriation for operations. And by 1982, that public benefit, that national connection, was entirely eliminated. There were also other items that were involved with that negotiation. At the time, there were hundreds of thousands of employees, past and current, who were part of a federal employee retirement system and its successor system that followed on in the 80s. Their retirement was a responsibility of the federal government. It had been a responsibility for the federal government for over 180 years. Well, there was negotiations at that time about how much the Postal Service would have to pick up versus that in terms of that liability, even though it was a long-standing responsibility of the federal government and the way the Post Office operated. There was a very significant payment that the new Post Office paid into the old retirement systems by virtue of employees who were federal employees. Well, you could make the argument that you want to completely privatize it and cut it loose, but that was a long-standing federal obligation. A deal was cut, a number was picked, and it was, I think, arguably a pretty generous deal on the part of the federal government, on the part of Congress, in terms of what they were forcing the Post Office to pay. It's not unlike what has happened more recently when the Post Office has been required, unlike other businesses or government agencies, to pre-fund health payments for future employees. Tens of billions of dollars have been extracted from the Postal Service and current operations to deal with something that's going to be far in the future, something that, again, as I say, the federal government doesn't do, private employers don't do. You can argue about how everybody would be better off if that happened, but it is creating, it's an example of creating an artificial crisis. And these tens of billions of dollars that were extracted in the early deal, or the tens of billions of dollars that are now flowing because of the 2006 Act, have destabilized the Postal Service at a time that fairly, I mean, it's clear that the Postal Office itself is stressed. Revenues have dropped for a variety of reasons. In part, there's e-commerce. There are a number of things that we routinely now email that we would have mailed even a couple of years ago. And of course, with the bubble bursting in the economy, its near meltdown, we have seen economic activity decline. So the Post Office has faced some $20 billion in lost revenue over the last 4 years. and it's something that, in fact, needs to be addressed. But we ought to understand what the dynamic is, that by forcing the post office to pre-fund its future health care payment benefits for the next 75 years in an astonishing 10-year time frame was something that was calculated to stress the Postal Service, even if the economy hadn't collapsed. You know, without the provisions of that 2006 legislation, the Postal Service would be operating at a surplus even with the challenges today. Well, there are interesting pieces of legislation that is floating around. I must confess, a little partial to looking at some of the proposals that are coming forward that would help take the post office off life support and allow us to move on to addressing these larger issues. Now, there are certain variations that Congress could have dealt with in the past. Policy questions. Should it cost the same to mail a letter from here to the White House as it does from Key West to Nome, Alaska? Can we have some variability in pricing? That is a legitimate question. There may be some arguments for doing that, but for the Congress over the years has hamstrung the post office, on one hand arguing that it should not have public support, it should operate like a business, and then turning around and denying the Postal Service the flexibility that private business has in terms of setting rates, differential rates. In terms of moving into certain product lines. In an enterprise that we value, that has this vast infrastructure that is in place, hundreds of thousands of dedicated employees, over 30,000 locations, a tradition of service and connectivity to Americans 6 days a week, we would think that maybe give them a little opportunity to be creative. Well, what we have found is that there is very little interest in allowing them to actually operate like a business. I do hope that my colleagues, as they look at the reform proposals that are coming forward and look at whether or not we're going to give them some flexibility to use the resources they already have and not penalize them with draconian and unrealistic requirements, take a look at what these proposals will have on rural and small-town America. You know, not everybody has access to high-speed internet that make email and reading your favorite magazine online very difficult. There are 26.2 million Americans that still lack access to broadband services, with over 3/4 of those people living in rural areas. I mentioned that in my state of Oregon, there are over 40 post offices that are listed for possible closure. People should think about those impacts. If you live, over half of them are more of the people in these communities are located more than 10 miles from the next nearest post office. Some are as far as 33 miles away. What are the impacts of having customers drive an hour round trip to visit the nearest post office? Is that reasonable? You know, it's a little frustrating for me that as we have looked at some of these impacts, the attention that is paid to rural and small-town America has not been, I think, given its due. One of the areas is the proposal of eliminating 6-day service. Let's consider how important Saturday mail delivery is for communication and marketing, utilized by millions of citizens and mailers across the country. Again, especially in rural areas. There are millions of Americans now who are using the Post Service to deliver prescription medications, a service that relies on moving the mail 6 days a week, not lying dormant in mail processing facilities for 2, 3 days, or depending on how holidays will fall, maybe longer. It will have negative impacts in terms of being able to, for people to be able to sign for packages if they're not home over the weekend. Think about these details. Think about what's going to happen if you eliminate Saturday delivery for the post office. Customers are likely to see private carriers charge much higher surcharges to have them deliver that option, or drive long distances to pick up their mail after renting out a private post office box for that purpose. Saturday service distinguishes the product line that we allow the Postal Service to have, and I think further diminishes their ability to be more self-supporting. And, of course, eliminating the 6-day service is going to eliminate 80,000 middle-class jobs. And they do so with some real question about how much of the saving is actually going to occur. The Postal Regulatory Commission was set up as part of this mechanism to establish an independent post office. They do some outstanding work. There's some really bright people. The Regulatory Commission found that the Postal Service has miscalculated the potential savings by about $1.4 billion a year when they talk about eliminating 6-day service. They found that the Postal Service additionally failed to account for nearly $500 million in lost revenue that would come from cutting back Saturday service. And as the president of Hallmark noted in a congressional hearing last year, such reductions in service could lead to a death spiral where service reductions and a declining consumer base are self-reinforcing. The Postal Commission found that eliminating 1 day of mail service would cause 25% of all first-class and priority mail to be delayed, often by 2 days. This has serious consequences that ought to be, I think, examined carefully before we move forward in this direction. This is not to suggest, Mr. Speaker, that the Post Office should be immune like any business or government agency. We all, in these difficult times, in changing circumstances, need to consider new ways of doing business. And my conversations with people in the Postal Service, with the men and women who work there, postal supervisors, letter carriers, clerks, the postmasters, they all have ideas. They all are interested in being part of a solution. And I hope that Congress approaches this in the same fashion. Last but not least, part of this infrastructure that ties us together needs to be looked at in a broad context. We've all been deeply concerned about national security in the aftermath of 9/11, the anthrax situation we've had here, potential pandemics where there are health crises. How are we going to deal with people quickly in times of need, to get them information, to check on people, to distribute potential medicines? You know, the Postal Service, with 2/3 of a million employees, a nationwide network of over 30 facilities, people who have equipment, who have know-how, knowledge of the community, the same way they help people with the right tax forms or immigration, could also be a resource in time of natural disaster, epidemic, or terrorism. Let's think big. Let's think fairly. Let's not have an artificial crisis. Let's deal meaningfully with this critical resource that America has developed over the last 235 years, not scapegoat the employees, not scapegoat the management, and have Congress be able to have it both ways, saying treat it like a business but not giving them the flexibility. I think it's time to take a deep breath, look at the resource and what it means for America, particularly rural and small town. Thank you, Mr. Speaker, for the opportunity to share some observations on this important topic.
The gentleman yields back his time. Under the Speaker's announced policy of January 5th, 2011, the Chair recognizes the gentleman from Texas, Mr. Gohmert, for 30 minutes.
Thank you, Mr. Speaker. We're living in interesting times. As I understand it, that's a bit of a Chinese curse. May you live in interesting times. Well, we're here. Not exactly as perhaps the founders would have hoped, where we would have an executive branch that just declares that without consulting Congress, he's going to commit American military to an action without knowing really who he's helping in Libya, without knowing exactly what's going to happen once we finish helping them, and without knowing just how much we're going to suffer and just how much our closest allies, like Israel, are going to suffer after this president unilaterally, without consulting Congress, commits our most valuable assets, American lives, not to mention the treasure and American equipment. For those who have ears and those who have eyes, you understand that when the president says, oh, but we're not to worry, eventually we'll turn it over to NATO, and then has a grandiose announcement, we're turning it over to NATO, that actually the United States military is 65% of NATO's military. Because there's supposed to be a regular order to things. And in fact, Republicans ran last year saying we're going to get back to regular order. And one of the things we went through for the preceding 4 years with the Democratic majority and Speaker Pelosi in charge was the Democratic majority came to the House floor over and over with bills that had not gone through committee process. And then they were brought to the floor with no opportunity to make any amendments whatsoever. Well, one of the things we have done this year, we've had lots of amendments. We've had an incredibly open process on the floor compared to what had happened the preceding 4 years, when there were more closed rules than there had ever been in the history of the country. Meaning no input, basically shutting out the almost half of America that Republicans represented. It was our way and no highway. That's not the way regular order was supposed to go. And we were assured by our own leadership, of course, that once we had the majority, it was back to regular order. And then over and over, big things had to be dealt with. Not that they couldn't have been foreseen. It could be reasonably foreseen that a continuing resolution was going to have to occur. And lo and behold, it came upon us in the spring as if it had never been contemplated. And we're told there's no time for regular order on these things. We just got to do it. Can't have amendments. Can't cut off funding for Obamacare, even though we cut off funding for some other things that would otherwise be considered legislating. But since it was part of the bill as it came directly from committee, we're told it's okay. So the Rules Committee waived any point of order objections. Now that's inside baseball, but the bottom line is, even though we've done a better job of allowing amendments here on the floor, we still haven't gotten back to regular order. We've gone from one crisis to another crisis and have had to tell America, gee, this is another crisis, so we don't have time to go through regular order. So I understand it, tomorrow, most likely, possibly Friday, we're going to have a balanced budget amendment brought to the floor. It was part of the debt ceiling agreement that was negotiated end of July, end of the summer session for the August recess. We were going to have a vote on a balanced budget amendment, but there was no specification as to what balanced budget amendment it would be. Well, along the lines of the so-called regular order, we have had a balanced budget amendment. We've had hearings on it. We've had it marked up out of subcommittee, committee, came to the full Judiciary Committee, and we had a long, protracted markup. In other words, markup is simply the hearing where anybody can bring any amendment, and we have debate, full debate, and anybody on the committee who has any amendment they want to bring to that bill, they can bring it to the bill. That's regular order. We had that in committee on the balanced budget amendment. And our good friend from Virginia, who has been such a long-suffering, valiant warrior for a balanced budget amendment, it was his bill. House Joint Resolution 1. And I had an amendment to that resolution that actually changed the cap on spending from 20% of the gross domestic product to a cap of 18% of the gross domestic product. And that amendment passed. That's regular order. That's how you do it. Some of us had amendments that didn't get passed, but we still had the chance to bring them, to have our chance to speak on them, debate on them, have every other member on the committee who wished to speak on every amendment be heard. Those things make for long, drawn-out hearings, and that's what we had. That's called regular order. That's because everybody who is involved can have input, and that's what we had. And after that long, protracted process, we voted out of committee, affirmatively bringing out of committee, voting out of committee, with a majority of those on the committee voting for the ultimate product after that long, arduous debate, voting process. We voted out of committee a balanced budget amendment. Now, I'm given to understand the Rules Committee has taken up a different balanced budget amendment, and we're told we didn't need to go through regular order for that. We're bringing a balanced budget amendment that did not come out of committee, that was not voted out of committee, and gee whiz, it reminds me a great deal of the outlandish hearings that the Energy and Commerce Committee had when they came forth with a 1,000-page health care bill in the last Congress. And it was there was a lot of strong-handedness that brought that bill out of committee, and it was clear from the polls that that was not what America wanted. But then by the time the Speaker Pelosi, and Leader Reid down the hall, President Obama had their say, that 1,000-page bill that was voted out of committee turned into ultimately a 2,000-page bill. And that came to the floor not under regular order because it just appeared. Nobody knew who had written it. But when we took the majority, we were going to do better. America would be able to see the debates, listen to the debates, see who was taking what position, see who was pushing what amendments, see what got voted out of committee, and would have some confidence that that would be what would come to the floor. Well, this week we're going to take up a balanced budget amendment. Didn't come out of committee. But we're told we got to vote for it because it's another crisis. We got to. It doesn't have a spending cap on it. Not even the one of 20% of GDP that was amended down to 18%. None of that. Regular order would mean that we bring something to the floor that was voted out of committee. At some point, we have got to get back to regular order, which was promised to the American people if they would put us back in charge. And it's good politically for both parties because each side gets to show in committee and here on the floor what amendments they're pushing for. They push for them in committee, push for them here on the floor. So by the time a law gets passed, it's been fully debated and talked about. That was one of the problems with the last majority. They were shoving bills down our throats, down America's throats, without any real debate. And that's how you could get a comment from a speaker like, gee, we got to pass the bill to find out what's in it. That's because it never went through a subcommittee process, a committee process, came to the floor with a full and open and amendment debate. No, we just bypassed all that. And one of the things that has hurt this country and has hurt this Congress is we haven't gotten back to regular order like we were supposed to. We've done a lot better, a whole lot better, because of all the amendment debate. But we haven't gotten back to regular order. So we're going to bring a balanced budget amendment to the floor that's different from the one that was fully debated, full opportunity for amendment at committee. Well, we're not going to have that opportunity on the floor. No, sir. Not going to have it. We're told we can't have a spending cap in the one we're going to have on the floor. Why? Well, not because the committee voted it down. They didn't. Not because the body voted not to have it here in Congress, but because we're told that what came out of committee cannot be what comes to the floor. I recall people previously saying that regular order makes for better law and allows the House to work its will. Well, how is it that we're not going to be taking up the balanced budget amendment that came out of committee? That's regular order. That's the House working its will. What staff member decided that we weren't going to get to have a spending cap that we could debate and vote on? We know that staff members had a lot to do with Obamacare or the President's health care bill because there was provision in there that exempted the Speaker's staff from having to be under Obamacare when all the rest of us were going to have to be under it, including members. So you kind of figure, well, it must have staff writing that one. Well, what staff member decided that we couldn't bring to the floor the balanced budget amendment that came through regular order out of committee? because that balanced budget amendment, fully debated, fully opportunity to amend in committee, but regular order means we'd have that same opportunity with the whole body here. Well, who was it, a staff member? Who was it that just decided we can't do what the body decided was the will of the committee and the will of the House? Who intervened? I really don't know. But the right thing to do would be to bring the balanced budget amendment with the spending cap. Now, there were all kinds of amendments addressing the spending cap. Some folks didn't want it. They lost. There was the provision for a supermajority to raise taxes on that bill that was voted out of committee. Well, that's not in the balanced budget amendment. Why? I don't know why. We're bringing to the floor a balanced budget amendment that appeared, and we didn't have anything to do with bringing it out of committee. But we're told that we've got to pass this one because it's the only one that has a chance to pass, even though the Senate says they're going to bring it down, even though we've got Democratic leadership saying they're going to bring it down. Well, if people on the other side of the aisle in the House and the majority in the Senate say they're going to bring it down, then why are we bringing to the floor a balanced budget amendment that a majority voted for and debated and amended and voted down amendments and passed it out to come to the floor in that order? How is it that we're trying once again in the House as a majority to strive to pass a bill to hit a mark that we think maybe there might be some chance that the Senate may pass as well, when we're told that, you know, that it's not everything we believe in, but we're not going to get everything we believe in because we got to try to do something the Senate will do. Well, if we've been told repeatedly that the Democrats are not going to assist, that the Senate's going to vote it down, then why not bring to this floor what we believe in our hearts as a majority ought to be passed? It's going to make it real confusing a year from now in November for voters, when the Republican majority in the House is going to have to go back as the founders envisioned and face our constituents. And even though we were in the majority, we didn't bring to the floor the things that we believed in. We brought to the floor things we were hoping maybe the Senate would agree to go along with. We're bringing to the floor what's called a minibus that's going to have some appropriations on it, but actually it went through the conference process, yet the underlying bill that passed out of the House was not a bill that a majority in the House really thought would be the best. It was a bill that we thought maybe the Senate would pass. So we compromised with ourselves in the majority in the House, thinking if we compromised with ourselves in the House, that maybe the Senate would vote through just what we passed. But no, they didn't. They compromised with us further after we compromised with ourselves, trying to hit the mark that we thought they would pass. So it goes to conference committee, and we're further required to compromise with ourselves. What was the sense of that? And now we have to vote on a bill, an appropriations bill, where we didn't even start out hitting the mark we thought was best, but rather hitting the mark that we thought, gee, maybe the Senate would pass. It's going to be confusing to voters, because we're going to say, here are the things we believe in next year in November, and they're going to say, why didn't you pass that? And apparently the response is supposed to be, well, because we were trying to pass something we thought the Senate would pass. And the voters are going to respond, but what about the principle you told us in November of 2010 you were going to stand on? And unless we get back to the regular order in this body, we're going to be in trouble. Because we need to be able to show the voters in America we passed in the House what we believed with all our hearts was best for America. We're going to cut spending. So we cut spending. We cut over $4 trillion over 10 years. We ought to be able to tell the American public that. But instead, we have to tell them, well, no, we were trying to hit a mark that wasn't too high because we were hoping the Senate would just pass it without the need for a conference. That's why it'll be confusing to voters. Well, I know you're saying that you believed in those things, but that's not what you passed. It's time to start passing what we, as the majority in the House, believe is right. And force the Senate to pass what they think is right. The big giveaway spending bills, force them to pass those. Don't come down here and compromise with ourselves and have a spending bill that we think, even though it spends more than we think is appropriate, we think, gee, maybe the Senate will go along, because that looks to the American public like we're just like the Democratic-controlled Senate. But if we stand firm on principle in this body and we say, here's what we believe in, here's what went through regular order, here's what was passed out of Judiciary Committee, here's the balanced budget amendment, and we took it to the floor and we have wide open amendments, wide open debates, the American public could see this body at work, and we passed what we believed was right for America. And then force the Senate to pass what they believe is right for America, and not continue to give the Democrat majority who want to spend like crazy in the Senate, we keep giving them cover because we won't stand on what we believe and pass that here in the House. It's what we ought to be doing. And that balanced budget amendment ought to be the one that came out of the Judiciary Committee. It ought to have a spending cap. It ought to have a supermajority in order to raise taxes. That was on that bill. Oh, it was debated. There were efforts to strike that part out. There were a lot of amendments, some to strike things like that out, some to put other things in, some to make it weak. But we fought those off successfully in committee, and we came out of committee with a good, strong, balanced budget amendment, and that's what ought to come to the floor, not the weak-kneed one we're going to get. Because a balanced budget amendment with no cap on spending unfortunately looks like a prescription for spiraling upward taxes, because we've seen, even with a conservative majority in the House, it's just tough to cut spending. Because we're told we got to spend to get the Senate to go along with these bills. It's time to take the tough stands. America's in trouble. It's in big trouble. And as we fight these battles, it doesn't help to have people jumping on a bandwagon that really wasn't the bandwagon they showed themselves to really believe in previously. And by that I'm talking about Secretary Panetta. Secretary of Defense. He wrote this scathing letter talking about how if the sequestration occurs, hundreds of billions are cut from defense, it could mean the loss of, I believe it was a couple of $100 million of our military, which is a little ironic coming from the current Secretary of Defense, because the people on this side of the aisle believe in a strong defense. We all believe that it is our #1 job to provide for the common defense, Because if we don't do that, all these other things just go away. And we're overtaken by people who want to bring down our way of life. But if you look to what Secretary Panetta was participating in back in the Clinton administration, you get a little better look at what really was believed at the time. You know, we've had President Clinton and those touting his time as president claiming, gee, he's the one president that actually cut the federal workforce. No, he didn't. He cut the military. Didn't cut the federal workforce. He cut the military. It's the only area he cut. And we paid a massive price after 9/11 because we had to gear back up because we once again found having a strong defense is important. Reagan tried to warn us about that. He said people don't get attacked because they're perceived as being too strong. They get attacked when people perceive them as being weak. And that's how we were perceived. But let's see, in January of 1993, when now Secretary of Defense Panetta started as a part of the Clinton administration, there were 1,761,481 members of the United States military. In July of 1994, Secretary Panetta started as the Chief of Staff for President Clinton. And that continued through January of 1997. So let's take a look. From the time Secretary Panetta started as a part of the Obama administration, we went from 1,761,481 members of the military to, in January 97, when he left the Clinton administration, 1,457,413 members. That's a 304,068 drop in members of the military while he was part of the Clinton administration. Seems to fall a little bit on deaf ears when you have a secretary crying about cuts to the military when he presided over a far more draconian cut to that same military when he was in charge or was part of the Clinton administration. The problem is we can't afford massive cuts to our defense, and at the very time they're okay with that, the President goes down to Australia and said, we're going to commit some troops down here too. We got troops, this President's committing all over the place without any regard, like in Libya or Egypt, to the outcome of what is being done. What's going to happen at the end? And we're going to pay a severe price. We need to stand for a solid defense. And if we get back to a regular order in this body where things are voted out of subcommittee after full chance to amend, voted out of the full committee with full chance to amend and debate, brought to the floor as they come out of committee, and fully debated and fully amended here on the floor, America will see who stands for what, and it'll be easier for the voters in the next election, and it'll be easier for all of us to tell what it is the American voters are wanting, because they will have had a clear view of just exactly what they're getting. I really enjoyed Mark Levin's book, Liberty and Tyranny. I think it ought to be a textbook. Let me just finish with this quote from Ronald Reagan that Mark puts in his book. How can limited government and fiscal restraint be equated with lack of compassion for the poor? How can a tax break that puts a little more money in the weekly paychecks of working people be seen as an attack on the needy? Since when do we in America believe that our society is made up of two diametrically opposed classes, one rich, one poor, both in a permanent state of conflict, and neither able to get ahead except at the expense of the other? Since when do we in America accept the alien and discredited theory of social and class warfare? Since when do we in America endorse the politics of envy and division? It's what the President's preaching right now. It needs to stop. It's time to provide for the common defense, get back to regular order in this body, and the country will be better off for it. With that, Mr. Speaker, I yield back.
Gentleman yields back. For what purpose does the gentleman from Texas rise?
Move that we do now hereby adjourn.
The question is on the motion to adjourn. Those in favor say aye. Those opposed, no. The ayes have it. The motion is adopted. Accordingly, the House stands adjourned until 10 a.m. tomorrow for morning hour debate.
Earlier today, members passed a bill that allows gun owners to carry concealed handguns across state lines. The vote was 272 to 154. The chamber returned